For withdrawal, madam.
Wait, one by one I will ask. Fresh memos all for Tuesday. And FR ಇದ್ರೆ comply ಆದ್ರೆ according to senior I will ask. Fresh memos all for Tuesday.
Then it was not posted.
And FR ಇದ್ರೆ comply ಆದ್ರೆ according to seniority.
Then it was not posted.
Whatever fresh. One minute. One by one. Wait. Settlement memos ಯಾವಿದೆ ಕೊಡಿ. One minute.
Withdrawal.
Settlement memos if any. I'll come to that. Wait. No settlement memos. Settlement memos ಯಾವಿದೆ ಕೊಡಿ.
Withdrawal.
Settlement memos if any. I'll come to that. No settlement memos. Now withdrawals. Give it. Settlement. Got it. Now withdrawals. ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳಿ. 2:30 ಕೊಡಿ ಅದು. 2:30 ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಹಾಕಿ ಮೇಡಮ್. 1 minute. ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳಿ. 1 minute. 2:30 ಕೊಡಿ ಅದು. ಒಂದೇ ನಿಮಿಷ. ಅದು ಗೊತ್ತು ನೆನ್ನೆ mediation 2:30 ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಹಾಕಿ ಮೇಡಮ್. ನಾವು withdrawal ಎಲ್ಲ ಕೊಟ್ರಾ? 1 minute. 1 minute. Vacating stay applications ಯಾವ್ಯಾವ್ದ್ರಲ್ಲೇ ನಿಮಿಷ. ಅದು ಗೊತ್ತು ನೆನ್ನೆ mediation all those memos where vacating stay withdrawal ಎಲ್ಲ ಕೊಟ್ರಾ? All right. Vacating stay applications ಯಾವ್ಯಾವ್ದ್ರಲ್ಲಿದೆ? Give all those vacating stay applications where vacating stay applications are filed. Give. ಅದೆಲ್ಲ separate pin ಮಾಡಿ ಮೇಡಮ್. Only vacating stay applications. All right. Now come on. Yes. Yes, Somana. ಅದೆಲ್ಲ separate pin ಮಾಡಿ ಮೇಡಮ್. All right. Now come on. Tuesday it will come, give it. Yes, Somana. ಅದು ಅಲ್ಲಿವರೆಗೂ urgency ಇದೆಯಾ? Tuesday it will come, give it. ಅದು ಅಲ್ಲಿವರೆಗೂ urgency ಇದೆಯಾ? Forward sir. Bail ಇಲ್ವಾ? ಆಯ್ತು, ಫ್ರೈಡೆ ಕೊಡಿ. ಫಾರ್ವರ್ಡ್ ಸರ್. ಬೇಲ್ ಇಲ್ವಾ? ಎಂಪ್ಲಾಯಿಯಾ? ಆಯ್ತು, ಫ್ರೈಡೆ ಕೊಡಿ. ಅದು ನಡಿ. ಟ್ಯೂಸ್ಡೇ ಎಂಪ್ಲಾಯಿಯಾ? ಯಾವತ್ತಾಗಿದೆ ಸರ್? ಅದು ನಡಿ. ಈಗ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗ್ಬಿಟ್ಟಿರುತ್ತೆ. ಫ್ರೈಡೆ ಕೊಡಿ. ಅಲ್ಲ, ಫ್ರೈಡೆ ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ. ಈಗ ಚಾರ್ಜ್ ಅಮೆಂಡ್ಮೆಂಟ್, ವಾಟ್ ಅಮೆಂಡ್ಮೆಂಟ್? ಫ್ರೈಡೆ ಕೊಡಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಅದು ಫ್ರೈಡೆ ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ. ಇನ್ ಇಟ್ಸ್ ಓನ್ ಕೋರ್ಸ್. ಎಫ್ಆರ್ ನಂಬರ್ ಇದೆಲ್ಲ ಅಪ್ಲೈ ಮಾಡಬೇಕು, ಇಲ್ಲರ ಬರಲ್ಲ. ನಿಮ್ದಲ್ಲ ಸರ್, ಚಾರ್ಜ್ ಶೀಟ್ ಹೇಳಿ. ಅದು ದಟ್ ವಿಲ್ ಕಮ್. ನಿಮ್ದು ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಇಟ್ ವಿಲ್ ಕಮ್ ಆಫ್ಟರ್ 2 weeks. ಎಫ್ಆರ್ ನಂಬರ್ ಇದೆಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಬೇಕು, ಇಲ್ಲರ ಬರಲ್ಲ. ಸ್ಟೇ ಇದೆಯಾ? ನಿಮ್ದಲ್ಲ ಸರ್, ಬೇರೆ ಬರಲ್ಲ. ನಿಮ್ದು ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಇಟ್ ವಿಲ್ ಕಮ್ ಆಫ್ಟರ್ 2 weeks ಕೊಡಿ. ವಿತ್ ಸ್ಯಾಟರ್ಡೆ 31st ಸ್ಟೇ ಇದೆಯಾ? ಆಗಾರ್ ಪರಲ್ಲ. ಎಸ್, ಕಮ್. All right. Fresh matter. You realize that it did not get listed today. Kodi parayala. All right. All right. Give it no problem. Tuesday. You realize that it did not get listed today. Okso. Kodi parayala. All right. Give it. ನೀವು ನಿಮ್ದು Tuesday. 2 ವಾರದಿಂದ FR ಇದ್ರೆ ಏನ್ ಮಾಡಕ? Okso. Okay. Give it. ನೀವು ನಿಮ್ದು FR MPML ಎಮ್ಯಾಟಸ್ ಯಾವ್ದಾರ ಇದ್ರೆ 2 ವಾರದಿಂದ FR ಇದ್ರೆ ಏನ್ ಮಾಡಕ? Okay, give it. 304A. So what? That is tomorrow. Give it. Tuesday, sir. PML matters ಯಾವ್ದಾರ ಇದ್ರೆ ಕೊಡಿ ನಾಳೆಗೆ. Fresh matters 304A. Tuesday ಗೆಲ್ಲ ಕೊಡಿ. If they are complied and according to seniority, give it. Please give all the fresh memos. Tomorrow you will not. Please don't wait. Tuesday ಗೆಲ್ಲ ಕೊಡಿ. If they are complied and according to seniority, give it. Memo. Please give all the pending matter. If I am continuing, I'll take it. Yes.
Submission.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅದು ಕೊಡಿ. ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಾ? 307 ಅಲ್ಲ, ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್. ಇಫ್ ಐ ಆಮ್ ಕಂಟಿನ್ಯೂಯಿಂಗ್ ನನ್ನ ಮುಂದೆ ಬಂದಿತ್ತು ಒಂದ್ಸರಿ ಎಂಪಿ ನೋಡಿ ನೋಡ. ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಾ? ಅದು 307 ಅಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲದೆ ಇರೋದನ್ನು ನನ್ನ ಮುಂದೆ ಬಂದಿತ್ತು ಒಂದ್ಸರಿ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲದೆ ಇರೋದನ್ನು ಪೋಸ್ಟ್ ಇಟ್ ಎಂಪಿ ಕೊಡಿ ನೋಡ. ನಮ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಪೋಸ್ಟ್ ಇಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ. ಅದು ಎಂಟ್ರಿ ಮಾಡಿ ಮೇಡಮ್. ನನ್ನ ಮುಂದೆ ಬಂದಿಲ್ಲ ಒಂದ್ಸರಿ ಅಂದ್ರೆ ಟ್ಯೂಸ್ಡೇ. ಎಸ್, ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲದೆ ಇರೋದನ್ನು ಪೋಸ್ಟ್ ಇಟ್. ನಮ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಪೋಸ್ಟ್ ಇಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ. ಅದು ಎಂಟ್ರಿ ಮಾಡಿ. ನನ್ನ ಮುಂದೆ ಬಂದಿಲ್ಲ ಒಂದ್ಸರಿ ಅಂದ್ರೆ ಟ್ಯೂಸ್ಡೇ. Yes. CBI take it for Friday. ಅದು interim bail ಬಂದಿಲ್ಲ ಅದು. CBI no problem. We'll have it tomorrow. Interim bail ಬಂದಿಲ್ಲ ಅದು. Give it. Yes, give everything. ಅದು ನಾಳೆ ಹಾಕಿ. No problem. ಒಂದು being spoken to ಒಂದು we'll have it tomorrow. Give it. 2023 ಮಾರ್ಚ್ ಗಿವ್ ಎವ್ರಿಥಿಂಗ್. ಅದ್ ನಾಳೆ ಹಾಕಿ ಮೇಡಮ್. 24 ಮಾರ್ಚ್ ಆದ್ರೆ ಏನ್ ಗ್ರೌಂಡೇ ಅಲ್ಲ. 2023 ಮಾರ್ಚ್ ಟೂ ಅರ್ಲಿ ಸರ್. 24 ಮಾರ್ಚ್ ಆದ್ರೆ ಏನ್ ಗ್ರೌಂಡೇ ಅಲ್ಲ. ಕರೆಕ್ಟ್. ಆಯ್ತು ಕೊಡಿ. ಎಸ್
My lord.
ಆಯ್ತು ಕೊಡಿ. ಎಸ್
My lord.
ಏನು ಸೆಟಲ್ಮೆಂಟಾ ಮತ್ತೆ ಸ್ಟೇ ಪೋಕ್ಸೋ ಏನು ಅದಕ್ಕೆ ಓಲ್ಡ್ ಮ್ಯಾನ್ ಪೋಕ್ಸೋ ಸ್ಟೇ ಕೊಡ್ಬೇಕು ಮತ್ತೆ ಸ್ಟೇ ಪೋಕ್ಸೋ ಗೊತ್ತಾಯ್ತು. ದಿಸ್ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಅಂಡ್ ಟೆನೆಂಟ್ ಪ್ರಾಬ್ಲಮ್, ಅದಕ್ಕೆ ಓಲ್ಡ್ ಮ್ಯಾನ್ ಪೋಕ್ಸೋ ಸ್ಟೇ ಕೊಡ್ಬೇಕು ಅಂತ ಕೊಡಿ ಅದೆಲ್ಲ ಡಿಸ್ಕಸ್ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಅಂಡ್ ಟೆನೆಂಟ್ ಪ್ರಾಬ್ಲಮ್. ಗಿವ್ ಇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಥರ್ಸ್ಡೇನ ಹಾಕಿ ಅದು ಕೊಡಿ ಅದೆಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡುವಂತ ಮಾಡ್ಬೇಡ. ಗಿವ್ ಇಟ್ ವೆನ್ ಡು ಯು ವಾಂಟ್. Give it.
My lord.
Give it week like next Wednesday or Thursday.
My lord.
Tomorrow, but give it when do you want? 4:30 PM.
My lord, Pokso matter today. The date has given. My lord,
tomorrow.
My lord,
tomorrow.
It was posted on 9th. Today date has given. My lord.
At 4:30 PM.
My lord.
My lord, Pokso matter today. The date has given. My lord. 20th has not come. My lord. 28th. It was posted on 9th. Today date has given. My lord.
Lord, there is a pending matter by direct.
Am I not listening?
Yes, my lord.
20th. Why this indiscipline?
28th.
Lord, this is a
20th.
pending.
ನಾಳೆ ಕೊಡಿ.
Lord, there is a pending matter by
My
direct.
lord,
Am I not
14
listening?
person already filed
Why
one
this
memo which
indiscipline?
is, they said it is missing. I filed
Yes.
on 5/9.
ನಾಳೆ ಕೊಡಿ.
Kindly
My lord,
today end of the
14
posting, my
person
lord. Already filed
ಯಾವ
one
court
memo
ಬಂದು?
which is, they said it is
E
missing. I
If you
filed
give a
on
memo
5/9.
before other court, you will not be taken.
Today I
File
filed
another
today
memo,
end of
my
the
lord.
posting, my
Your
lord.
respondent petition. ಯಾವ court ಬಂದು?
856
Your
re-court.
respondent, if you give a
I am the
memo before other
petitioner.
court, it will not be. When do you want?
Today I filed
end of
another
the list,
memo,
my
my
lord.
lord.
Seriously.
Uh,
Your
TRLP
respondent petitioner. Why, from where have you come?
856
Your respondent
JP
or
Nagar,
the
my
petitioner.
lord.
petitioner? All right. When do you want?
Today
Proof
end
or-
of the list, my lord.
Seriously.
The
No,
thing
my
is
lord.
that I have
Why,
a
from
minor
where have you
child.
come?
We are made to start
JP Nagar, my
without
lord.
any interim remedies. It's been 3
Proof of
years.
the offense.
The thing
He
is
has
that I
made
have
a
a minor
settlement before
child.
the Kerala
We are
court,
made
but
to
he has
start
violated
without
that
any interim
settlement
remedies.
He filed
It's
a
been
case
3
after
years
case.
in
Offense.
Bangalore and trying to
He has
evacuate
made a
us from
settlement
our own
before the
property.
Kerala
Fresh
court,
matter or
but
pending?
he has
Fresh
violated
matter.
that
So that
Settlement.
Yes.
He filed case after case in Bangalore and trying to
Tuesday.
evacuate us from
ನೀವು
our own
14
property.
person. Fresh matter or pending?
Fresh
ಇಲ್ಲ,
matter.
2:30 Yes. Tuesday. ನೀವು 14 person. 10th ಟೈಮ್ ಮೂವ್ ಮಾಡಿದ್ರು ಟ್ಯೂಸ್ಡೇನೆ ಕೊಡಿ. ಹಾಗಾದ್ರೆ ಒಂದ್ ಕೆಲಸ ಮಾಡೋಣ, ನೀವು 10 ರೀಚ್ ಆಗೋವರೆಗೂ ಪೋಸ್ಟ್ ಆಗೋದ್ ಬೇಡ. 10th ಟೈಮ್ ಮೂವ್ ಮಾಡಿದ್ರು ಟ್ಯೂಸ್ಡೇನೆ ಕೊಡಿ. ಟೈಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಏನಾಗಿತ್ತು? ಹಾಗಾದ್ರೆ ಒಂದ್ ಕೆಲಸ ಮಾಡೋಣ, ನೀವು 10 ರೀಚ್ ಆಗೋವರೆಗೂ ಪೋಸ್ಟ್ ಆಗೋದ್ ಮೇಡಮ್. ಅದು ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿರೋ ಕೇಸು ಪೋಸ್ಟ್ ಇಟ್ ಟುಮಾರೋ. ಪರವಾಗಿಲ್ಲ. ಟೈಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಏನಾಗಿತ್ತು ಮೇಡಮ್? ವೇರೆವರ್ ಡಿಸ್ಪೋಸಲ್ ಲಿಬರ್ಟಿ ಮೇಡಮ್, ಅದು ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿರೋ ಕೇಸು ಪೋಸ್ಟ್ ಇಟ್ ಟುಮಾರೋ. ಅದನ್ನ ಹೇಳ್ಬಿಡಿ ಸಾಕು. ಏನ್ ಮಾಡಿ
2022
ಏನಾದ್ರು ಟೆಲ್ ಮಿ.
ಪೋಸ್ಟ್ ಆಗಿದೆ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ವಿ.
ಅದು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ವಿಡ್ರಾ ಮಾಡಿ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡೋದು ಅದನ್ನ ಹೇಳ್ಬಿಡಿ. ಗೆಟ್ ಪೋಸ್ಟ್ ಇನ್ ದಿ ನೆಕ್ಸ್ಟ್
2022
ಏನಾದ್ರು
ಪೋಸ್ಟ್ ಆಗಿದೆ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ವಿ. ಇದೂ ಪೋಸ್ಟ್ ಆಗಿದೆ.
ವಿಡ್ರಾ ಮಾಡಿ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡೋದ್ರಿಂದ ಅಂತ ಹೇಳಿ ಮೆಮೋ ಫಾರ್ ಅರ್ಲಿ ನೆಕ್ಸ್ಟ್ ಡೇ. Yes. Because at the instance of the court you have withdrawn it. That's why. Yes. No debt. Yes. Early hearing. Memo for early listed once also Tuesday it will come. Give it. Give it.
It's a fresh matter, my
You have come there. No debt. Yes. Finish. Yes. Huh? If it is not listed once also Tuesday it will come. Give it.
It's a fresh matter, my
You have come there. Wait. Madam ತಗೊಳ್ಳಿ this. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ತಗೊಳ್ಳಿ ನಾಳೆ ಕೊಟ್ಟಿಲ್ಲ. ಇವನ್ ಅದರ್ವೈಸ್ ಮೇಲೆ ನಾಳೆ ಮೇಂಟೆನೆನ್ಸ್ ಸ್ಟೇ ಆಗಿದ್ರೆ ವಿಲ್ ಸಿ.
My lord, 2023 matter.
ಅದು ಮೇಡಮ್ ತಗೊಳ್ಳಿ.
Notice ಇಲ್ಲ ಸ್ಟೆಪ್.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಸ್ಟೇ ಆಗಿರೋದು ಇಲ್ಲ. ಇವನ್ ಅದರ್ವೈಸ್ ಗಿವ್ ಇಟ್ ಆನ್ ಮೇಂಟೆನೆನ್ಸ್ ಸ್ಟೇ ಆಗಿದ್ರೆ ವಿಲ್ ಸಿ.
2023 matter.
ಅದು
ನೋಟಿಸ್ ಇಲ್ಲ ಸ್ಟೆಪ್.
ಮೇಂಟೆನೆನ್ಸ್ ಸ್ಟೇ ಆಗಿರೋದು ಎಲ್ಲಿದೆ ಟೈಮ್ ಮೇಡಮ್? 13th. ಓಕೆ, ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆನ್ 13th if possible. Yes.
2023
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
Fresh matter.
ಟ್ಯೂಸ್ಡೇ ಎಲ್ಲಿದೆ ಟೈಮ್
is taken for my lord trafficking, whereas the allegation is that my lord bonded labor and child marriage act. My lord, I'm requesting for Tuesday, my lord. The urgency is this, my lord. This is taken for my lord trafficking, whereas the allegation is that my lord bonded. No, my lord, WP number it was listed before the lord. I'm requesting for Tuesday, my lord. The urgency is this, my lord. Fresh matter. Tuesday, my lord.
Proceedings under the legal
No, my lord,
methodology
WP
act.
number it was listed before the
Covered by your
lord.
lordship's judgment.
Next
But this is a pending
20th.
matter where
My lord,
the directors
this
of an
is
e-commerce company have been made accused in
Lord, this
proceedings
is
under the
application,
legal
my lord.
methodology
You
act.
have an application
Issue
has been
stands
rejected
covered
by
by your
the
lordship's
judge.
judgment.
Next when? 20th.
This is
Yesterday.
no.
Too fast, sir.
My lord, today they have posted for final argument of the action has been
2:30
rejected by the
when was
trial
it
court. my lord.
rejected? When?
Yesterday, my lord.
Yesterday.
No.
Too fast. Joined
My
in.
lord,
Wait.
today they
Yes.
have posted for final argument of the accused. my lord.
2:30 ಯಾವಾಗ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ?
ಮತ್ತೆ madam.
Huh? ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಜಾಯಿಂಡ್ ಇನ್ ವೇಟ್. ಯಾವತ್ತು ರಿಜೆಕ್ಟ್? ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಏಪ್ರಿಲ್ ಆದ್ರೆ ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ 17th ಹಾಕಿ ಟ್ಯೂಸ್ಡೇ. ಎಸ್. ನೋ ಸರ್. ಸೊ ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಏಪ್ರಿಲ್ ಆದ್ರೆ FR ಅದನ್ನು. ಎಸ್. ಅದು 17th ಹಾಕಿ ಟ್ಯೂಸ್ಡೇ. ಎಸ್.
Election of Tamil Sangam.
No,
One and a half
so
years
what?
ಆಯ್ತು.
17th is
Stay
before
ಆಗಿದೆ.
18th.
Further is ಇದೆ.
ಅದು ರಿಲೀಸ್ ಮಾಡ್ಬಿಡ ಕೊಡಿ ಮೇಡಮ್. ಅದು ನಾಳೆ ಹಾಕಿ ವಿಲ್ ರಿಲೀಸ್ ಇಟ್ ಫ್ರಮ್ ಪಾರ್ಟ್.
Election
release
of
it tomorrow.
Tamil Sangam. But 1.5 years ಆಯ್ತು.
2:30
Stay ಆಗಿದೆ. Further is
ರಿಲೀಸ್
ಇದೆ. Please.
ಅದು ರಿಲೀಸ್ ಮಾಡ್ಬಿಡ ಕೊಡಿ ಮೇಡಮ್. ಅದು ನಾಳೆ ಹಾಕಿ ವಿಲ್ ರಿಲೀಸ್ ಇಟ್ ಫ್ರಮ್ ಪಾರ್ಟ್.
ಆಗಿಲ್ಲ.
ಏನದು? ವಿಲ್ ರಿಲೀಸ್ ಇಟ್ ಟುಮಾರೋ. ಪೆಂಡಿಂಗ್ ಅ ಫ್ರೆಶ್ 2:30 ಆಕ್ಸ್ ಟ್ಯೂಸ್ಡೇ ವಿಲ್ ರಿಲೀಸ್ ಇಟ್.
Please.
ಕೌಂಟರ್ ಬ್ಲಾಸ್ಟ್ ಕೇಸ್ ಏನದು? ಪೆಂಡಿಂಗ್ ಅ ಫ್ರೆಶ್ ಟ್ಯೂಸ್ಡೇ. ಎಸ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ ಮೇಡಮ್. 20th ಪ್ರಾಬಬ್ಲಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ ಮೇಡಮ್. ವಾಟ್ ಇಸ್ ಇಟ್ ಫಾರ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ? ಪ್ರಾಬಬ್ಲಿ. ಹೌದಾ? ಬರಲ್ಲ. ಟ್ಯೂಸ್ಡೇನೆ ಬರಲ್ಲ. ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗ್ಲಿ. ವಾಟ್ ಇಸ್ ಇಟ್? ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ನೋ ಸರ್. ಮಂಡೇ? ನೋ ಸರ್. ಟ್ಯೂಸ್ಡೇನೆ ಬರಲ್ಲ. ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗ್ಲಿ ತೊಂದ್ರೆ. ನೀವು ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗದ್ರೆ ಏನ್ ಮಾಡಲ್ಲ. ಇಶ್ಯೂ ವಾರಂಟ್. ನೋ ಸರ್. ಮಂಡೇ? ನೋ ಸರ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ಎಸ್. I will also issue a warrant. Yes. Pending matter. Next Friday ಕೊಡಿ. Tuesday next Friday ಕೊಡಿ. Now tell me.
Arising out of the same impugned proceedings, my lord, the matter is listed on 13th by a party in person for final
Tuesday
hearing.
ಹಾಕಿ madam.
We have also filed a writ petition arising
Now
out of the
tell.
same-
You want it on
arising out of
13th?
the same impugned
I don't
proceedings.
know whether I
my
can
lord.
take
The
it.
matter
We'll
is
see.
listed
Give
on
it.
13th by a party in person for final hearing. We have also filed
Huh?
an act petition arising out of the same.
You want it on 13th? I don't know whether I can take it. We'll see. Give it. Yes.
Under section 196 of PNS.
Huh? Tuesday, fresh matter.
Published by accused number 1, my lord, have been indicated.
Wait. Yes, madam.
Section
It's
196
PC
of
Act, my
PNS.
lord. The charge sheet is already filed. It's a fresh matter.
Tuesday,
Kindly
fresh
post it.
matter. Tuesday. Yes.
Kindly have it on
Yeah.
Friday, my lord.
FR? Yes, madam.
It's
FR number.
PC Act, my lord. The charge sheet is already filed. It's
Yes,
a fresh matter. Kindly post it for tomorrow.
21. Yeah, give it. FR? FR number. Yes.
No, sir.
It's been a month of
Yes, no.
filing WP, my lord. Still
Settlement
not-
failed.
Fresh
21.
fresh hearing.
Memo bidoit. Give it. Yes.
My lord, it's been
Give
a
it.
month of filing, my lord.
been a
Maybe
month
taken
of,
today
uh,
after filing
No,
WP,
the
my lord.
cap
Still
is
not
6 months, sir.
fresh-
Here.
fresh
So
hearing.
don't worry.
Memo
Give
bidoit.
it.
My lord, tomorrow, my lord.
No, sir.
My lord, it's been a
Tuesday.
month
Yes.
of filing, my lord.
Yalla
Maybe
false,
taken
sir.
today afternoon.
Yes. No, the cap is 6 months, sir. Here. So why family matter here?
My lord, tomorrow, my lord.
No, sir. Tuesday. Yes.
False FIR is filed, my lord.
ಎಲ್ಲ false
2021
matter. ಕೊಡಿ. Yes. ಇಲ್ಲಿ ಬರಲ್ಲ. Next ಕೊಟ್ಟು.
No, my lord.
Why family matter here?
Filed the petition Monday, my lord. The petition referred for
2021 matter.
Police Act 2021.
ಇಲ್ಲಿ ಬರಲ್ಲ.
Because
Next
other
ಕೊಟ್ಟು.
no, my lord, not been arrested. Crime has been registered. I have filed the
No problem.
petition in
You also take the
Monday,
bail.
my lord. I have taken the bail.
No
my lord. I
problem.
complained
Give
the
it.
bail order, my lord. Police, but
No problem. Yes, yes.
because
Tuesday,
other
Tuesday.
accused have not been arrested. They have not taken the bail. The FR
No
number, my
problem.
lord.
You also
They have
take the
not-
bail.
I have taken the bail,
No
my lord. I
problem.
complained
Give it.
Monday, but
No problem. Yes, yes. Tuesday, Tuesday. Comply ಮಾಡಿ compliance ಹೋಗುತ್ತೆ. ಆಗಿದ್ರೆ Tuesday ಬರುತ್ತೆ.
They have not
Yes.
complained. My lord, they are not complained the matter. I Monday I
Memo
filed
ಹೋದ.
the petition, my lord. But the-
FR ನಂಬರ್ ಕಂಪ್ಲೈ ಮಾಡಿ ಕಂಪ್ಲೈನ್ಸ್ ಹೋಗುತ್ತೆ. ಆಗಿದ್ರೆ ಟ್ಯೂಸ್ಡೇ ಬರ್ಕೊಡಿ. ಅದು ರಿಲೀಸ್ ಮಾಡ್ಬೋಣ.
my lord, they are not complaining the matter.
ಮೆಮೋ ಹೋದ. GM GM ಆದ್ರೆ ರಿಲೀಸ್ ಮಾಡಿ ಅದು ಕೊಡಿ. ಅದು ರಿಲೀಸ್ ಮಾಡ್ಬೋಣ. ಫ್ರೈಡೆ ಹಾಕಿ ಕೊಡಿ. GM
Lordship, may kindly have it on
GM ಆದ್ರೆ
Friday,
ರಿಲೀಸ್
my lord.
ಮಾಡ್ತೀನಿ ಕೊಡಿ. ಯಾಕೆ ಸರ್? ಎಲ್ಲ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಫ್ರೈಡೆ ಹಾಕಿ ಕಾರಣ.
There is an apprehension of kindly have it on Friday, my lord. He is residing in Delhi, my lord, sir.
ಅದಕ್ಕೆ ಟ್ಯೂಸ್ಡೇ ಫ್ರೈಡೆ ಹಾಕೋಬೇಕಾ? ಕಾರಣ
There is an
ಏನ್
apprehension of
ವಿಟ್ನೆಸ್
harassment,
ಸಮನ್ಸ್
my
ಇಶ್ಯೂ
lord.
ಮಾಡಿದೀವ.
He is residing in Delhi, my lord, sir.
ಗಿವ್ ಇಟ್ ಟ್ಯೂಸ್ಡೇ. ಅದಕ್ಕೆ ಟ್ಯೂಸ್ಡೇ ಫ್ರೈಡೆ ಹಾಕೋಬೇಕಾ? ಏನ್ ವಿಟ್ನೆಸ್ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದೀವ. ಅದು FR ಮತ್ತೆ ಅರ್ಜೆನ್ಸಿ ನಾಳೆ. ಗಿವ್ ಇಟ್ ಟ್ಯೂಸ್ಡೇ. ಎಸ್.
Call the case number. The 427.
ಅದು FR ಮತ್ತೆ
427,
ಅರ್ಜೆನ್ಸಿ
asking for concurrent of all the sentences.
ಓ ಇವತ್ತು ಅವ್ರ ಕೌನ್ಸಿಲ್ ಚೇಂಜ್
The
ಆಗಿದೆ.
427.
Senior is out.
427, asking for concurrent of
I
all
may
the
need your, I
sentences.
told you, list on 20th. Yes. ಓ ಇವತ್ತು ಅವ್ರ ಕೌನ್ಸಿಲ್ ಚೇಂಜ್ ಆಗಿದೆ.
No, senior is out.
ನರ್ಗುನ್ ಸರ್, ಆಲ್ ರೈಟ್. ಅದು
My apologies to the court. Yesterday I had gone through the order sheet. I have noticed that the number which I have quoted was disposed of. Therefore, ma'am, it's a mistake committed by me. Matter may kindly be listed Monday, Tuesday or Wednesday. Number which I have quoted was disposed of. Therefore, ma'am, it's a mistake committed by me. Matter may kindly be listed Monday, Tuesday or Wednesday. I shall make a
post on Wednesday and fresh matters. Inadvertent mistake in making a submission on 9/9/2024 the matters that were following. Therefore, list this matter. Senior counsel would submit Wednesday and fresh matters. Inadvertent mistake in making a submission of the matters that were disposed. Therefore, list this matter on Wednesday in the fresh matters. Madam, ಇದು recall.
Petition is charge sheeted and is exonerated in the departmental inquiry. Produce the lordship judgment along with the order passed by the petition is charge sheeted and is exonerated in the departmental inquiry.
sir.
Produce the lordship judgment along with the order passed
What is
by
the
the
offense?
commissioner. Offense is
That is on 10/4/2023, sir.
465, 468 million.
ಅದಕ್ಕೂ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ ಏನು ಸಂಬಂಧ?
That order has been
What
produced.
is the offense?
Offense is for 167,
376
420,
accused ಆದ್ರೆ
468 million.
ಅದಕ್ಕೂ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ hypothetically if you are an accused for offense punishable under 376 departmental inquiry is 376 accused
So
we should close
no
it.
charges are not proved against the
hypothetically.
present petition in
If you are an
department.
accused for offense punishable under 376 departmental inquiry is conducted.
This allegation
So we
that
should
the
close it.
charges are not proved against the present revenue entries.
420 ಹೆಂಗ್
And
prove
after
ಆಗುತ್ತೆ
lapse of
departmental
10 years,
inquiry?
the present complaint came to be filed that
Yes,
allegation that he
tell that.
forged the
That's all
signature
right.
notating the revenue entries against the present petitioner. And after lapse
1
of 10 years,
You are
the
what?
present complaint came to be filed that the
Tell
revenue
that.
inspector.
That's all right.
Thereafter, charge sheet is granted against the present petitioner. And
Stay there. You are what? Sorry, really good.
I'm the revenue
List the matter
inspector.
after 4 weeks interim order subsisting shall
Has been
continue till the
granted
next
by
date
some
of hearing.
court
Retire
and-
ಆಗಿದ್ದೀರಾ? Stay there.
No, no, stay
Retire
there.
ಆಗಿದ್ದೀರಾ? Really good.
Return
List
ಆಗಿದೆ,
the matter
return
after
ಆಗಿದೆ.
4 weeks
ಹಾಗಾದ್ರೆ
interim
date
order
ಕೊಡಿ.
subsisting shall
List the
continue
matter
till
on
the next
20th
date of hearing.
the-
Retire ಆಗಿದ್ದೀರಾ?
21st October.
Retire ಆಗಿದ್ದೀರಾ? 22nd October.
Return
Yes.
ಆಗಿದೆ. Return ಆಗಿದೆ, return ಆಗಿದೆ.
ಹಾಗಾದ್ರೆ
Interim
date
order
ಕೊಡಿ.
shall continue to the next
List the matter on 20th 21st
Hearing
October,
for petitioner,
22nd
my lord.
October. Yes.
My lord, in this case, my lord, the PCR
Interim
filed
order
by the
should
respondent
continue
number
to
2 in the year 2014, my lord. A charge sheet
Hearing for
filed against
petitioner,
3
my lord.
persons, my lord. I
But
have
in this
received
case, my lord,
notice from the
the
police
PCR
in the
filed
year
by the respondent
2022
number
to
two,
the year
till
2014, my
split
lord.
ಅಲ್ಲ
A charge sheet filed against 3 persons, my lord.
without issuing,
I have
kindly
received
see the
notice
page number
from
of
the
the
police
19
in the year
ಅದರಲ್ಲಿ charge sheet
2022,
ನಲ್ಲಿ
my
SV
lord. Till
Hireಮಠ
ಅಂತ mention ಆಗಿರುತ್ತೆ.
ಅಲ್ಲ ಸ್ಪ್ಲಿಟ್ ಆಗಿಲ್ಲ ಸರ್
Thereafter, my lord,
without
2022,
without
I have
issuing,
received
kindly
notice
see the
from
page
the
number,
police,
my
my
lord,
lord.
19
And
ಅದರಲ್ಲಿ
obtained bail,
charge
my
sheet
lord,
ನಲ್ಲಿ SV
taken bail,
ಹಿರೇಮಠ
which is
ಅಂತ
page
mention
number
ಆಗಿರುತ್ತೆ.
51, my lord.
All right.
Thereafter, I have
approached
approached
this honorable
2022,
court,
I have
my lord.
received
There
notice
is no
from the
ingredient
police
to
to
alleged
and
accused
obtained
number,
bail, my lord. I am accused
taken
number
bail,
3, my
which is
lord,
page
as
number
stated in
51, my
the
lord.
charge sheet.
Thereafter, I have approached
And
this
accused
honorable
number
court,
2,
my
my lord,
lord.
quashed
There
by
is
this
no
honorable
ingredient
court
to
to
alleged
alleged
accused number.
ಕೊಡಿ.
I am accused number
Accused
3,
number
my lord,
2
as stated in the charge sheet,
So
my lord.
come to page
And
20.
accused number 2, my lord, quashed by this honorable court,
Come
my
to
lord.
page 22, sir. ಕೊಡಿ.
Accused number 2 quashed, my lord. Yes, my lord.
1 minute, 1 minute.
Yes, my lord.
1 minute, 1 minute.
Allegation against the
ಎಸ್ ನೀವು ಇದನ್ನ ಇದೇ ತಪ್ಪು ಮಾಡೋದು. ಕಾಪಿ ಮುಂಚೆ ಕೊಡಕ್ಕೇನು?
allegation against accused number 2 and
I
3.
will adjourn it by 4 weeks now. ಕಾಪಿ ಮುಂಚೆ
ನೀವು
ಕೊಡ್ಬೇಕು.
ಇದನ್ನ
Whatever
ಇದೇ
you
ತಪ್ಪು
want to
ಮಾಡಿರಲ್ಲ.
rely on.
ಕಾಪಿ ಮುಂಚೆ
Should they not
ಕೊಡಕ್ಕೇನು?
see it?
Allegation against the accused number 2 and
I
3.
will adjourn it by 4 weeks.
Yes,
now.
you come to
ಕಾಪಿ ಮುಂಚೆ ಕೊಡ್ಬೇಕು.
paragraph
Whatever
5.
you want to rely on.
Yes.
Should they not see it? The case of the prosecution is that the alleged
Yes,
trespass
you
was
come
made by
to
A1 and not by the
paragraph
present
5.
petitioner.
Tejesh.
Present, their petitioner was A2. The only allegation made in the
case of
charge
the
sheet is that
prosecution
the
so-and-so,
alleged trespass was
with the
made by
help
A1
of
and not
A3 and
by the
A4
present
has
petitioner.
fabricated.
Present, their
He-
petitioner was A2.
The court goes to
The
show,
only allegation
goes
made in
to
the
hold
charge
that
sheet is
A2
that so-and-so
himself has not done anything.
with the help of A3
helpers
and
will go
A4
away.
has fabricated.
Please, madam.
All right. The court
The
goes to
petitioner
show, goes to
is
hold that
accused
A2
number
himself has not done anything. Helpers will go away.
in
Please,
CC.
All right. 1518 of
The petitioner
2014 registered
is
for offences
accused number
punishable under so and so. The
Three.
learned counsel for the petitioner
In
would place
CC,
reliance upon the judgment of the coordinate bench in criminal petition for offences punishable under so and
of
so.
2016.
The learned counsel for the
Disposed on
petitioner would
1st
place
August
reliance upon
2019
the
concerning
judgment of the
the
coordinate
accused
bench
number
in
two.
criminal
Notice.
petition
My lord, notice has to go to the
4262 of
second respondent.
2016, disposed on 1st August 2019
sorry,
concerning the accused number
Notice-
2.
My lord, notice
The
has to go
court
to the
has,
second
the
respondent.
coordinate
Notice
bench
not-
has held as follows.
ಸರಿ ಬರ್ಕೊಳ್ಳಿ.
ಅದರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿರ್ಲಿಲ್ಲ.
accused number 2
Served and unrepresented has, the coordinate bench has
ಇದ್ರಲ್ಲೇನ್
held as
ಬರಲ್ಲ.
follows. Anyway,
But
let
charges
your
has also
apprehension
been-
get
ಅದರಲ್ಲಿ notice ಆಗಿರ್ಲಿಲ್ವಾ?
created. Served and
This,
unrepresented. Court
ಇದ್ರಲ್ಲೇನ್
notice,
ಬರಲ್ಲ.
paragraph 5. Anyway, Let your apprehension get, the court observed that the complainant, first respondent therein was served and unrepresented. First time I go. The court observed that the complainant, first respondent
Therefore,
therein
to
was served and afford an opportunity to the complainant, second respondent herein,
First time.
issue emergent
Therefore,
notice to the
to
emergent
afford
notice
an
returnable
opportunity
by
to the
27th
complainant,
of September. Second respondent herein, September.
in the light
Issue
of the
emergent
finding
notice to the
rendered by the coordinate bench
returnable
way
by
accused number 2,
27th of
the
September.
petitioner accused number 3,
The
September.
proceedings against
In the
petitioner
light of
accused
the
number 3
finding rendered
shall remain
by the
stayed.
coordinate bench way accused number 2, the petitioner accused number 3, the proceedings against petitioner accused number 3 shall remain stayed. ಇದು ಫೈಲಲ್ಲೇ ಇರಲಿ.
Undertake to file wakalat for R2 in this case. Undertake to file wakalat for R2 in this case.
Learned counsel so and so undertakes to enter appearance for the second respondent. Registry to print the name of so and so appearing for the second respondent. Promise to undertakes to enter appearance for
Child was born.
the second respondent.
Thereafter,
Registry to print the name of so and so
376 has
appearing
been
for the
invoked
second
as
respondent.
promise
Promise to marry,
No, child was born.
You got married.
Thereafter, 376 has been alleged.
376 has been,
Ah.
according to her
That sheet is
complaint,
376,
she has got married at Mysore.
Ah.
She was not divorced and
You got
the
married?
petitioner is also not divorced.
Ah.
According to her
Consider.
complaint, she
Yes,
has got
both of
married
you are
at
married.
Mysore.
Ah.
She was not divorced and the petitioner is also not divorced.
The counsel for the petitioner is before this
Both of
court
you are married.
calling in question so and so. The counsel for the petitioner.
The offence
is before
alleged
this
against the
court
petitioner is
calling
the
in
offence
question
punishable
so
under
and so.
section
376 page 35 alide so and so.
the offence alleged
As
against
on
the
the
petitioner
dates
is
of alleged
the offence
incidents that have
punishable under
happened,
section
both the
376
learned counsel
page
for
35
the
alide.
petitioner
So
and
so.
the complainant would admit
As on
that
the
the petitioner
dates of
and
alleged
the
incidents that
complainant
have happened
were
both the
married,
learned counsel
were
the
married
petitioner and the
separately
complainant
to
would admit
different spouses
that the
and
petitioner
the marriage
and
had
the
not yet been
complainant
annulled in accordance
were
with law.
married,
Therefore, the promise of marriage cannot spring
different
unless
spouses
and the marriage had not
unless
yet
the
been annulled in
spouses
accordance
were
with law.
divorced
Therefore, the promise of
prior
marriage
to the,
cannot spring
unless
prior to the said
the,
promise of marriage or the incident.
unless the
spouses were
the acts between the
divorced
complainant and the
prior
respondent
to
appear
the
to be
consensual.
prior
Matter
to the
requires
said promise of
consideration.
marriage or the
Therefore,
incident.
objections, if
The-
any,
the
by the
acts
respondent
between
by
the
the next
complainant
date of
and
hearing,
the
there shall be an
respondent
entry
appear
matter
to
of
be
stay of further
consensual.
proceedings
The
where the
matter requires
petitioner till the next
consideration.
date of hearing. Therefore, objections, if any, by the respondent by the next date of hearing, there shall be an entry matter of stay of further proceedings where the petitioner till the next date of hearing. Yes. Next. ಬರುತ್ತೆ. Settlement ಬಂದಿತ್ತಾ ಇದು?
Settlement
ಹಾಗಾದ್ರೆ 26 ಹಾಕ್ಬಿಡಿ. List on 26, both of you are there, will close. ಬರುತ್ತೆ. Yes.
Petitioner is
Settlement
accused number
ಬಂದಿತ್ತಾ
2,
ಇದು?
my lord.
Settlement
ಹಾಗಾದ್ರೆ
The offence
26
punishable under
ಹಾಕ್ಬಿಡಿ.
section
List on
420
26,
IPC.
both of you are there, will close it.
The case of the prosecution is that, my lord, petitioner is accused number 2, my lord. Sold the timber to accused number 1, 420
Who is
IPC.
the respondent, sir?
The case of the prosecution is that, my lord,
The
respondent
respondent.
number 2 sold the timber to accused number 1. He represent accused number 1,
Who
my
is the
lord.
respondent, sir?
Case number 1 and case number
The respondent
Or
2
the
remained
learned-
absent.
Therefore, the
on
respondent
several
remained
occasions.
ill. Counsel ಇದ್ದಾರೆ.
In the connected matter.
He represent accused number 1, my
appearing
lord.
for the
Case number
respective
1 and
learned
case
counsel
number-
appearing for the
Respondent remained
petitioners in
absent
both these
on
cases.
several
Remained
occasions.
ill. Counsel for the respondent has remained absent. Or
R2,
the learned
R2.
counsel appearing for the respective learned counsel appearing for the petitioners in both these cases.
This matter on
Counsel for the respondent has remained
26th.
absent. Interim order
Throughout.
subsisting shall continue till the next date of hearing.
In
In
that
the event
light,
he would remain
lest
absent
this matter
on
on
the said
20,
date, the petition would be
26th
answered. Interim order
Criminal
subsisting
order
shall
was
continue
brought
till the
down.
next date of
One
hearing.
more
In the
similar
event he would remain
2-3
absent
occasions.
on the
no,
said
don't
date,
have an
the
interim order?
petition would be answered in terms of
Criminal
the
order was passed down. the
That's all
previous
right.
occasion.
One more similar order.
2-3 occasions.
ಹಾಗಾದ್ರೆ
no,
interim
You
order
don't have an
ಮಾಡ್ಬಿಡಿ.
interim
As
order?
last chance.
We have not lordships on the last date.
Date may
and
be-
that interim order
26,
will
yes.
stay till the end of this,
Next.
till the disposal of.
ಹಾಗಾದ್ರೆ interim order extend ಮಾಡ್ಬಿಡಿ. As a last chance ಕೊಡಿ.
What's in this case? Date may be.
26.
Yes.
Next.
I'm appealing for the respondent BDA, my lord.
Lord,
Direct fresh matter ಬಂತು.
My lord, say,
there is an application.
seek for 2 weeks
Why
time to
has
file
it
BDA,
come
my
for
lord.
fresh matters, sir?
Lord,
Direct fresh matter ಬಂತು.
My lord, say,
Heard the learned
Your lordship
senior
can
counsel.
kindly
seek for 2
Yeah,
weeks
turn
time to file.
Why has it come for
184.
fresh
Lord,
matters, sir?
today your lordship is
There is an application for
Your Lordship,
senior
kindly-
counsel. Let it be. We'll hear it
Turn to page
along with the main.
184. Not the, today your
Lord, the
Lordship
learned
is-
senior counsel Ganpati Bhatt
There is
appearing
an
for the
application
petitioner
for
and
improvement.
so on. Let it be. The counsel appearing for the
along with the main.
respondent, BDA, Murugesh
Heard the
Charati,
learned senior counsel
seeks
No,
2
my
weeks
lord.
appearing for the
Murugesh
petitioner.
Charati,
Ilva?
yes, my lord.
The
Section
counsel
BS, yes,
appearing for the
Section
respondent
seeks 2 weeks time to
BDA,
file statement of
Murugesh
objections.
Charati.
No, my
The
lord.
2 weeks application of the
Murugesh Charati,
impleading
Sachin
applicant
BS,
would be
my
heard
lord.
along with the
Yes,
main
my
matter.
lord.
Interim
BS
order
seeks 2 weeks
subsisting
time
shall
to
continue
file
till the next
statement
date
of
of
objections.
Next,
Name of the
the
Murugesh V. Charati
application
will be
registry to
filed.
delete the name of
Murugesh
Murugesh Charati
would be
from the
heard along with the main
causes.
matter.
Interim order subsisting shall continue till the next date of
Yes,
hearing.
my lord.
Next,
Name of the Murugesh V. Charati.
well,
will be
registry to
released.
delete the name of Murugesh Charati from the cause list.
Date may be fixed, my lord.
applicant.
ಆಯ್ತು, ಅದನ್ನ ಒಟ್ಟಿಗೆ ಹಿಯರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಿಮ್ನು ಹಿಯರ್ ಮಾಡ್ತೀನಿ. ಹಾ.
ಬಾಲಸುಬ್ರಹ್ಮಣ್ಯ applicant.
ಆಯ್ತು, ಅದನ್ನ ಒಟ್ಟಿಗೆ ಹಿಯರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಿಮ್ನು ಹಿಯರ್ ಮಾಡ್ತೀನಿ. Upon the second respondent. Yes, yes.
354.
Post immediately after service of notice
354 ಇದೆ
upon
ಇದ್ರಲ್ಲಿ,
the second
ಅದಕ್ಕೋಸ್ಕರ.
respondent.
Stay, madam.
No.
No, there is a
ಏನು?
two complaint, madam. There is a
ಗೊತ್ತು.
change the version
354
and
ಇದೆ
develop
ಇದ್ರಲ್ಲಿ,
the
ಅದಕ್ಕೋಸ್ಕರ.
complaint after.
What is the first? What is the first
No.
complaint?
First complaint is
ಏನು?
two not a complaint, madam. Loan amount. Change the version and develop the complaint after.
What is the first? What is the first complaint?
First complaint is the.
354
not written the loan amount. There is no outage. Second complaint is the written the annexed loan amount, but the interest was not given.
354
There
Act.
is no, there is no outage of modesty.
Number 18, my lord.
And third and annexed email, no outage of modesty. There is no allegation against the.
Page number 18, my lord.
Anything else?
Assault and injury. There is no outage of modesty. 6 days, the complaint was
ಪರವಾಗಿಲ್ಲ.
put.
Anything else, sir?
The only money.
I will
issue-
dismiss it right away.
Anything
ಸುಮ್ನೆ
else,
ಇರ್ತಾ ಇತ್ತು case. Now I will pass
After
an order.
6 days, the complaint was
ಪರವಾಗಿಲ್ಲ.
put.
Anything else, sir?
The only money.
I will
issue-
dismiss it right away.
Petitioner
ಸುಮ್ನೆ ಇರ್ತಾ ಇತ್ತು case.
Is before this
Now I will
court
pass an order.
calling in question
Anything
proceedings in crime number 54 of
The
2023
petitioner
registered for
is
offences
before
punishable
this
under
court.
section 504,
Calling in
323,
question
354 and
proceedings
506
in
of
crime
the
number
IPC
54 of
in
2023.
CC, registered
and
for
the
offences
proceedings in
punishable
CC
under section 504, 323, 354 and
Facts in brief
506 of the
germane,
IPC.
heard so and so.
In
Facts in
CC,
brief germane are as
and
follows.
the proceedings in CC
The
651 of
petitioner
2023.
and the second respondent
Facts
are
in
said
brief
to have
germane,
had a
heard so and so.
loan
Facts in brief
transaction
germane
between
are
the
as
two,
follows.
loan transaction. The petitioner
On
and the second respondent are said to
3/7/2023,
have
a
had
crime comes to be
loan
registered
transaction
in crime
between
number
the two,
54
loan
of
transaction. 2023,
2023, alleging that
On
6 days prior to the
3/7/2023,
registration of
a
the
crime
crime
comes to be
the
registered.
petitioner had in crime number
Threatened
54
the
of
complainant
2023,
when
alleging that
she
6
had
days prior to the
asked
registration
the
of the
return
crime,
loan. The petitioner
not only
had
threatened but
threatened
also
the
had
complainant
outraged the modesty
when
of
she
the
had
complainant.
asked
Therefore,
the return
the,
of the loan.
therefore,
Not only
the complaint
threatened,
comes
but
to be
also
registered.
had
The police
outraged
after
the
investigation
modesty
file a
of
charge
the
sheet.
complainant. Filing of the charge sheet is
Therefore,
what has driven the petitioner to this court.
therefore,
in
the
subject
complaint comes
petition.
to be registered.
The learned
police
counsel
after
appearing for the
investigation
petitioner
file a charge
submits
sheet.
the
Filing of
first
the charge
complaint
sheet is what has
was
driven the
sought to be
petitioner to this
registered
court
on
in the subject petition.
6/7/2023. The learned counsel appearing for the
which is
petitioner
rendered
submits
a non-cognizable
the first
report.
complaint.
Thereafter,
was sought
the
to be
complainant
registered
improves
on
the version
6/7
and
2023,
registers the
which
impugned
is
complaint
rendered a non-cognizable report.
offences punishable under
Thereafter,
section
the complainant
354
improves the
as
version
well and registers
therefore
the
he would
impugned
submit that the
complaint.
improvement in the
For
complaint
adding
would inure to
offences
the benefit
punishable
of the
under
petitioner
section
towards
354
quashment of the
as well.
proceeding. The
The-
learned
therefore, he would
HCGP
submit that the
would, however,
improvement in the
refute the
complaint would
submissions
inure
to
to
the benefit
contend
of the petitioner
that this fact
towards
is also
quashment
taken
of the
note
proceeding.
of while
The
filing
learned
the charge sheet,
HCGP
and the
would,
offence
however,
is clearly
refute
made
the
out
submissions to
in,
contend
that
this fact
is
the-
also taken note
while
of
filing the
while
charge sheet by
filing
the
the charge
jurisdictional
sheet.
police.
And the offence
I
is
have
clearly
given my
made out
anxious consideration
in,
on
the
therefore narrated facts
in
are
the-
not in dispute. While filing
therefore
the charge
narrated
sheet by the
facts are a
jurisdictional
matter of
police.
record.
I have given my
transaction
anxious
between the
consideration
petitioner
therefore
and the
narrated
respondent.
facts are not in dispute.
The
Therefore narrated
respondent seeks
facts
to
are a
register
matter of record. The complainant seeks to register a complaint on 6/7/2023, which is rendered a non-cognizable report by observing as follows. Page 21. This was dubbed to be a money problem between the complainant and the petitioner and a non-cognizable report was rendered. The complainant then registers a detailed complaint before the jurisdictional police, Bere police station, before the very same police station by very same police station. The complaint registered on the second occasion reads as follows. Page 14. The second occasion, the complainant narrates the entire story, and the police, after investigation, have filed a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows. The allegation against the petitioner is that he has hurled abuses, dragged the complainant, hit the complainant on certain parts of the body. If this cannot be construed to be an outraging the modesty of a woman, be it any transaction between the two, I fail to understand what else can be, albeit prima facie. In that light, it is a matter of trial for the petitioner, a matter of further proceedings for the petitioner to come out clean. Leaving open the remedies available to the petitioner in law, the petition stands rejected.
There is a chance of settlement also.
Huh? No, sir.
Any date may be given. There is a chance of settlement also.
I have passed the order. Yes, next.
For the respond number 2 million. In this case, I have filed my objections also, producing certain documents.
My lords, I heard this matter, my lord, on the 2-3 occasions, my lord, is.
I have not granted the interim order. Be not to.
No, my lords, I heard this matter. It's a matter, my lord, complaint against the president of the society for trespass, my lord.
Yes, sir.
Lord, your lordship may kindly see.
You will hear it.
Yes, ma'am.
At leisure.
Yes, ma'am.
There's a detailed interim order by Justice Vishwesh Shetty.
Lord, what has happened is this, ma'am. The allegation statements made in the petition, they are contrary to the stand taken by the petitioners in the civil proceedings. They have contended.
Civil proceeding, idea.
I will clarify, if your lordship gives me 5 minutes time, I'll clarify. What has happened is there is a civil suit that is pending in OS number 12 of 2021 in the Court of Civil Justice Senior Division. What has happened is, admittedly, these are all admitted facts. There was a resolution passed in 2008, on 2/9/2008. I have produced that document along with the objections. It's an admitted fact. A resolution was passed by the society under which the institutions which were established earlier have been bifurcated into 2 committees. And these 2 committees are exclusively managing the 2 institutions, 2 groups of institutions. And A group institutions are being managed by the petitioners.
All right, you fight out the civil suit. Why criminal case?
What is happening is this, this is a case where, on the ground that the then secretary of the society was convicted in a criminal case. On 3/10/2023, a resolution was passed seeking to suspend a resolution of 2008, which was in force throughout, admittedly. In fact, that resolution was challenged by us by seeking the stay of the said resolution.
What happened to that?
Stay has been granted.
Which petition is that?
Yes, Miller.
Which WP?
WP number 473.
I'll submit. Let me clarify.
WP number?
473.
Stay was granted by the trial court on the application filed by the petitioner.
By the trial court?
By the trial court. That has been challenged by the petitioners.
What happened to that?
That is pending before the Honorable High Court. In WP number 473.
Is it stayed?
No. That is not stayed.
That resolution is not stayed.
That is not stayed. My only submission is, admittedly, right from beginning in 2008 onward, I can even point out the very documents produced by the respondent, petitioners. This fact that there is a bifurcation of institutions is an admitted fact even by the petitioner.
What the police do in all this, sir?
Miller, what has happened is this. On 6/10/2023, these people, under section 4, to amount to a criminal trespass, I should be in possession of the property.
Criminal trespass.
Criminal trespass.
Who are they?
They are the persons who admittedly are the president and office bearers of the society. No dispute about it. But in view of the fact that by virtue of the bifurcation, the resolution passed in 2008.
Is that resolution still in existence?
Yes, because of the stay granted by the High Court, by the trial court.
In a challenge to that is not stayed?
No, that is not stayed.
Bifurcation.
Yes,
why did that bifurcation happen?
Bifurcation happened because, during the lifetime of the founder president, who is the father of the petitioner number 1 and also the father of the husband of respondent number 2 before your lordship. My lord, what had happened was he himself passed everything. This is an admitted fact. May I pass on to your lordship, kindly invite your lordship's attention to page 98 of the paper book filed by the petitioners themselves. This is the written statement filed by the petitioners in the civil suit, wherein they categorically admit that there has been a resolution passed, there is a bifurcation. Along with my objections, I have also produced letters addressed by petitioner number 1, wherein he categorically admits that ever since 2008, there is bifurcation of institutions, bifurcation of bank accounts. They are in exclusive management of the institutions. And as on date, what happened is, even the conviction made by this honorable court in...
Are they not office bearers of the...
They are office bearers, but so far as management, so
That's
far...
all right. They are office bearers?
They are office
How
bearers.
can it be criminal trespass?
My submission is this.
Yes, sir.
The allegations may kindly, in the complaint may kindly...
If they are not office bearers and have trespassed
may be-
into the educational institution, you
They
tell
may
me.
I-
Long as they continue to be office bearers, you cannot allege 447.
My only submission is this, my lord. Your lordship may kindly see. My lord, in the complaint itself, it has been categorically referred to.
Complaint?
In the complaint filed before the police,
Huh.
there is a categorical reference to the fact that there is a bifurcation of the institution.
All right.
So my only submission is, my lord, if your lordship...
Is the bifurcation
Now, may I make
decided?
one request, my lord?
Is the bifurcation become final?
It has become final, is my response.
Where final?
Because, my lord, the stay has been, as on date, my lord, it is in force.
It is challenged before this court.
In spite of it, my lord, the no interim order has been granted. The
Well,
matter
which,
is being heard.
what
May I
is
make
the-
one request, my lord? Maybe this is a case which your lordship may have to hear immediately after the disposal of the writ petition.
Why?
My lord, what will happen is, in the event of the writ petition being decided in our favor, holding that the
Sir,
resolution...
Writ petition may be decided in your favor.
Yes,
That's all right.
Yes,
The incident is 447.
I understand.
All right.
Yes, my lord.
That has happened as alleged by you by these people entering into the premises.
Of the
Your writ petition being decided or not will not take away the incident. The incident is trespass.
That's
They are office bearers of the association.
Sir, ultimately-
When that confirmation comes about, are you putting the clock back?
Well, my only submission is this, my lord. As on the date on which this action happened, this act happened, my lord, even though they had passed a resolution, that was not within our knowledge, and that has been subsequently challenged. And ultimately, one more aspect your lordship may kindly bear in mind. The fact that we have been in possession of the property is an admitted fact.
What would police do with that, sir?
But what I am saying is, when I am in possession of the property, when somebody else, maybe the office bearers, including the owner of the property also, assuming that the owner of the property comes into the property, can he disturb the possession of the person who is in possession of the settled possession of the property?
We'll see. Yes, sir. Raghavan, sir.
But if lordship kindly takes the
Now,
blame.
maybe before that, if your lordship was
No,
going
no,
to-
he had to start. I have heard.
I
you.
understand.
Yes.
I may have to again respond also, my lord.
You can respond because last 4 occasions none appeared.
I understand.
So I have
what-
recorded that.
I understand, madam. I was informed about it. Of course, last occasion, my another colleague who appeared earlier was there. And it
Yes,
appears the matter could not be taken up on that day.
All right.
Lordship not kindly see
Yes.
page 39, my lord, which is the complaint. There is no dispute, and in fact, your lordship sees the plaint also. Kindly to have a look at the plaint, my lord, which is filed by the complainant, page 47. The lordship would have a look at my lord, paragraph 4, my lord, at page 50. Plaintiff number 1 society in the course of time successfully established number of education institutions in various fields. Just so and so and so.
Who has filed this suit? All right.
Your lordship would have a look at not about just five lines below. While some of the institutions are established and run with the aid and succor of the government, some are run by the society alone by its own resources and borrowings. A list of institutions run by the plaintiff societies as under. The lordship would find not reference to the Polytechnic at serial number 3.
No, this society is not there.
Society is very much there.
All right.
In fact, not the suit is filed on behalf of the society also. Kindly see, not first plaintiff is shown as the society itself.
All right.
Therefore, not, and your lordship, therefore, not the fact that the society is running this institution, is the owner of this institution, is not in dispute according to them.
You are the office bearers of this.
And the office bearers of the society.
Who is the complainant?
Complainant my lord, is the one of the members of the society. She was earlier an office bearer. Then my lord, in the AGM of 2022, she did not turn up at the AGM. Earlier she was an office bearer. Now she is not an office bearer. That AGM was questioned before this honorable court by them, and that was not upheld by this honorable court by its order. Your lordship would have a look at I'll just give the page number. Your lordship would have a look at. But it is in WP at page 697. My lord, your lordship takes the second volume.
Madam. Volume 2. Volume 2. ಕೊಟ್ಟಿದ್ದೀರಾ? Second volume idea.
But there is a second.
3 volumes.
But all the orders and proceedings in the suit also not are.
All right.
There
We'll hear
the
3 volumes. We'll hear it after 3 weeks.
this is only the order not to show that
Yes.
AGM was not the limited question is this. Where is the question? There being a criminal trespass not case is the simple point not before the Lordship.
Page 690.
Page 697, my Lord. The trial court my Lord had stayed the proceedings of the AGM. A detailed order was passed by this honorable court, allowing my writ petition, setting aside the order, holding the civil court had no jurisdiction to interfere with proceedings, and therefore my Lord, the AGM of 2022 my Lord, came to be upheld. We are the office bearers of this society now. And in fact, my Lord, the Lordship takes the prayer also in the plaint. Kindly have a look at the prayer in the plaint, my Lord.
Page.
Kindly not first volume itself. Lordship kindly turns to my Lord, page 85. My Lord. At page 87,
Yes.
kindly have a look at my Lord, H.
87.
I'm sorry, page 87.
H.
H.
Yes.
Issue a judgment and decree of direct mandate ranging direct and defendant number 1 and other defendants concerned to adopt impartiality and take undiscriminated and equal care of all institutions and staff and employees established and run under the parasol of the first plaintiff organization by needing to pool a single pool budget and composite financial management on plaintiff number 1 for all the institutions run under it. This is the prayer asked. But in the light of this,
What was the resolution in the AGM of 2022?
not of electing office bearers. In that manner, they did not participate.
Electing office bearers.
Office bearers.
You were elected as
I
office.
was elected as office bearer. That was questioned my Lord, before the civil court.
When did this offense of trespass?
After that, thereafter. Lord, your Lordship seeks the
Where do I get the resolution in the AGM?
Lord, your Lordship would find not in the order of the High Court, it's not, it is referred to. Kindly have not page 700, not the judgment starts.
I know.
Your Lordship would see not page 704, where all the resolutions not are referred to.
704.
703 not and 704. The AGM of 4/3/2022.
703, paragraph 6.
Paragraph 6 minute, yes, please.
Yes.
AGM of 4/3/2022.
Yes.
Initially, the trial court had stated, this honorable court not overturned that. And the Lordship would see the date of the offense.
So this,
that is,
what is the resolution? 4/3/2022, is it?
Yes, ma'am.
Date of the offense?
That is
6/10.
6/10/2022. 23.
Long thereafter.
Not they challenged it because
what happened to that Justice Sachin's order?
But that was taken up to the Supreme Court. Supreme Court did not interfere it. It ordered mediation.
That is what
they appealed to mediation. Mediation did not succeed.
Supreme Court's order, your Lordship may kindly see. That is there because they themselves have produced it. Kindly see the Supreme Court order at page 748. Let's kindly go to the second last paragraph 749. We are sanguine that the dispute
intervention of Justice R.V. Ravindran.
Then, however, in case the mediation does not succeed, the petitioner shall be at liberty to pursue the civil suit and the writ petition pending before the different forums, and such matters shall be then decided as per their own merits, uninfluenced by the observations made by the High Court in the impugned order. Now, what has happened is these resolutions which my learned senior is referring to, including the resolution dated 4/3/2022, is challenged by us before the civil court in the pending suit. In addition to that, this resolution has been passed, wherein they have passed a resolution seeking to displace the husband of respondent number 2 from the general secretary post, and Mr. Akshay. No, I have challenged that. What I'm submitting is
pursue it.
No, that is a different thing. What I'm submitting is
we are not displaced.
That's what I'm saying. That's a different matter.
That we are
not displaced. In fact,
that we are doing
murder as a consequence. He lost it.
I think I may be given 10 minutes time to
suspect. Yes.
Now, what has happened is this. I will try to answer your Lordship. Ultimately, we are at your Lordship's hands. But your Lordship may kindly say, they have referred to the plate governments. They have also referred to these orders. What has not been stated is this. An order of injunction has been granted by the trial court earlier, restraining them from passing any resolutions and restraining some of the petitioners, that is petitioners 4 to 6, from participating as even the members of the society. Those resolutions were challenged, though that particular order passed by the trial court, granting injunction in favor of the plaintiffs in the suit, has been challenged in a miscellaneous first appeal before this honorable court. Two miscellaneous. They are pending even now. While admitting those miscellaneous first appeals, on 3/12/2021, an order was passed by this honorable court, which is still in force, wherein, while staying the order passed by the trial court, this honorable court said, no resolution shall be passed, seeking to remove petitioner number 3, that is the husband of respondent number 2. Plaintiff, and also, he should be permitted to participate. This was the order which was passed.
Page.
Milord, they have produced the document. I don't know whether they have produced that document. Milord, your lordship may kindly let me examine whether they have produced. Only today I filed the wakalat and all that.
Page number
271. Yes, ma'am. So many volumes are there, Milord, I could not immediately lay my hand.
ಏನಿಲ್ಲ ವಾಲ್ಯೂಮ್ಸ್ ಅಷ್ಟೇ ಕಂಟೆಂಟ್ ಇಲ್ಲ. Yes.
271 million. This is the order passed by the honorable court in the MFA. Kindly go to page 274 million. It is just and appropriate to stay. Your lordship gets it, Miller. Second line. It is just and appropriate to stay the impugned order. Therefore, interim stay of the impugned order in the above appeals with a condition that the appellant shall not pass any resolution for removal of respondent number 3 till disposal of the appeals. The appellant shall permit respondent number 3 to participate in the meetings of petition number 1, plaintiff number 1 society and its business according to the applicable rules. So this was the order that has been
Why
passed.
was the apprehension of removal there?
Well, at that time, what happened was earlier.
He was convicted for 302?
No. Conviction happened only recently. That is now challenged before the Honorable Supreme Court. Appeal is admitted.
Would you not become disabled to
That's what I'm
become a
submitting.
member once you are 302?
So far as petition number 3 is concerned, he is not the complainant before your lordship, Miller. What I am submitting is.
Complainant is his wife?
Yes. Conviction is concerned. What I am submitting, I have to go on to clarify that also. The conviction is concerned, it was a case of a reversal. Trial court has.
Conviction is conviction.
Yes, conviction
Unless
is conviction.
it is set aside.
That's right. Appeal
Yes.
has been filed. A statutory appeal is filed before the Honorable Supreme Court.
All right.
Appeal has been admitted. Well, I also produced the copy of the order of the Honorable Supreme
All right.
Court.
No problem.
Wherein Honorable Supreme Court has suspended the sentence and also has.
Stayed the conviction?
No.
Leave it.
That's
Suspension
right.
of sentence
And
will happen.
he has been released on bail. That's another aspect of the matter.
Yes.
Well, what has happened is this. They have passed a resolution on 3/10/2023 on the ground that because of the conviction, we are superseding all the earlier resolutions of 2008 also. My submission is this Group B committee did not constitute of only plaintiff number 3.
All those matters are pending before the coordinate benches or the division bench as the case would be.
Yes, ma'am.
In appropriate proceedings. You are not in possession of the property.
I am in possession of the property.
That is a disputed question.
No, what
Yet
I am
again,
submitting is this,
AGM of 2022, which
I have
you had
produced-
challenged, you have lost it.
May I
up to
make
the
one
Supreme
request,
Court.
Miller?
Criminal case, we will not permit to continue for the asking of the complainant.
No, kindly see the objection statement, Miller, which I have filed. Kindly see the order passed by the trial court while staying the resolution. In the objections, Miller, kindly go to objections.
Page
68 and 69, para 25.
Sixty-eight.
Yes, ma'am. Ink page 68. Internal page 46, Miller.
Yes.
Para 25.
Para?
25, Miller.
It is submitted at subjects.
Miller, statement of objections, Miller, I'm sorry.
Whose statement of objections? In the suit?
No, I'm talking about. I will come to the written statement filed by them again, which will later.
Yes, sir. Page 25. Para 25.
Para 25.
All right. Yes. Para 25 of what?
Page 68, no, para 25, the order passed by the trial court.
All right.
Staying the resolution passed by them.
Which resolution?
3/10/2023 resolution seeking to nullify the earlier resolution of 2008.
That is stayed.
That is stayed.
What happened to that?
That's what the writ petition has been filed. In the against the order granting this the stay, they have filed a writ petition before this.
What happened to that writ petition?
Pending, no interim order is granted.
Which is that, Justice Sachin or the other?
Such an order, that particular order is in respect to the earlier resolutions. Nothing to do with this resolution. Kindly go to para 25 million.
ಇದರಲ್ಲಿ ಯಾವ್ದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಸ್ಪ್ರಿಂಗ್ ಆಗಲ್ಲ. Don't use the criminal justice system for
What is happening is, they have tried to, they have
solve all your disputes everywhere.
Para 25, your lordship. I will only take another 5 minutes, and then
All right, yes.
Para 25. In view of the above, on perusal of the merit,
Of the objections.
Put up money.
ಇದೆ. Para 25 of the trial court's order.
Yes, madam.
All right, yes.
Page 68, madam.
I am there, yes.
In view of the above, on perusal of the case on hand, it prima facie reveals that bifurcation of the committee A and B is not temporary arrangement. The bifurcation of committee A and B was acted upon, and as per the memorandum of understanding dated 25/2009, and under the resolution of the council meeting date 25/2009, it is clearly stated that since it may take some time to smoothly transfer the assets and liabilities to their respective trusts by making legal documents and other permissions required under prescribed acts and statutes during the interim period, all the institutions allotted to second and third party, as mentioned in B and C schedule, shall continue to be running in the existing first schedule. There is no right is reserved by the society to supersede A and B, committee A and B in future, and the resolutions dated 25/8/2008, 29/2008, and 23/8/2009, and MOU. Therefore, the resolution dated 3/10/2023 passed in the council meeting of AOLE is without jurisdiction. It is in violation of the principles of natural justice and modified the intention to take over the management and administration of the plaintiff's 2 to 5. Therefore, it is just unnecessary. This is the order that is passed. No stay has been granted. Apart from that, regarding this bifurcation, your lordship, yes.
I am not hearing an appeal against
I
your
understand.
disputes.
No.
We are only on the.
What I am trying to draw your lordship's attention is, he has referred to the averments in the plaint. I may be permitted to read the stand taken by the petitioners themselves in their written statement. Your lordship may kindly.
You will hold up the whole day.
Not the whole day, another 5 minutes, that's all.
Hello and welcome to Business 360. I'm Archana Solanki. Here are the headlines we're tracking this evening. Consolidation continues on Dalal Street. Sensex and Nifty end with marginal cuts. Mid-caps outperform. RBI Governor Shaktikanta Das says that headline inflation, which gives 46% weightage to food prices, matters as people understand that. Says there's a need to preserve the credibility of the flexible inflation targeting framework.
So the disability is taken as 15% and the income is taken
directions. For a period of more than 1 year, my lord, the state KE, my lords, did not file any objections. My lord, on one or the other reason, they took time. And my lord, the matter was getting adjourned. In the meanwhile, my lord, selections also happened. So I filed application for impleading those persons who were selected in the sports category. My lord, that application is, my lord, is pending, but all are served. They have appeared. They have filed counters also. My lord, the state, my lords, now has filed a counter. My lord, saying that that insofar as they say, my lord, that there is no material to show that I represented the country and secured the position. Number two, what they say is it is beyond the cutoff date, according to them, that it is only from 1/6/2018 to, my lords, the June, end of May 2023 that they will consider. They rely upon, my lords,
The period of study between 8 and 12.
my lord, my lord, that is what I am trying to say. My lord, my respectful submission is, when, my lord, the rules are clear, it says period of, my lord, study between 8th and 12th. They could not have, my lords, prescribed a cutoff date. And if your lordships kindly see their counter, my lords, the counter filed by the state, as to when, my lords, the circular is issued, After, my lords, the seat is over, my lord, the entrance is over. My lord, when the counseling is about to start, if lords kindly come to my lords annexure R2, Kannada version at page number 17, my lords, English at 18. They issue this, my lords, on 23/6/2023. It's what, my lord, they have produced.
Where is Rule 9, page 69?
My lords, in the writ petition, my lords,
15.
it only says, my lords, a period of study, my lords. That is
Page number 16, Lord.
60, my lords.
And where they have received the cutoff date?
My lords, the circular, my lords, at annexure R2, what they have produced. My lords, translation, my lords, English translation at page number 18, my lords. In that, my lord, number 2.
Page 18.
My lords, page number 18, my lords, English version.
Statement of
Lords, at seal number 2, they say the cutoff date will be taken into consideration only for the sports certificate from 1st June. Page number 18, my lords, of the statement of objection filed by the state, my lord. That is, my lords, respond number 1, my lords. I'm sorry, my lord, respond number 2. My lords, on 2 points, my lords, according to me, my lords, this is not applicable for the reason that, my lord, this was issued, my lords, as late as, my lords, on 23/6/2023. My lords, after, my lords, CET is over, my lords, everything is over, when the counseling is about to begin. My lords, at that time, my lord, this is...
Your claim is for which year?
My lords, for 2023, my lords.
23.
23.
20 to 23.
No, 23/24.
23/20.
When, my lords, the counseling is about to start, my lord, they issue this circular according to them, my lords, which according to me is not permissible. Secondly, my lords, field is covered by, my lords, the rules. It says, my lords, period of study. My lords, without defining, my lords, period of study, my lords, nothing is there in the rules also. My lords, it was not open for, my lords, for the state to come out with, my lord, this circular instruction. Lord, insofar as this, my lords, I have also relied upon a decision of this, the Honorable Supreme Court, my lord, which I have, my lords, filed along with the synopsis, my lords. Specific contention is, my lords, when the field is covered by rules, no circular instructions could have been issued. My lords, I have filed, my lords, memo for list of authorities. Your Lords may kindly have a look at my Lords 2007-15 SCC 129, my Lords, which is.
We'll see. That is
Yes, my lord.
non-proposition. That rule can't be amended by
circular instruction.
But the administrative instruction can supplement the rule.
Yes, ma'am. That is always there.
What is the nature of this? Now, this go to page 59, 60.
60, yes,
That is
ma'am.
rule.
Please.
So you passed out 8 exam.
Lords, my submission is that, my Lord, the rules.
Period of between 8 and.
Yes, my Lords, the certificate, my Lords, if I go back to, my Lords, which is at, my Lords, Annexure D2, my Lords.
No, you studied in which year?
My Lords, 2023, I completed PUC, my Lords. 2018, my Lords, I joined, my Lords, 8th standard.
And completed 12th standard in 23.
Yes, my Lords.
So how this page R3 will come again?
Yes, my Lords, I would, my Lords, the rules would say is that, my Lords, period of study. My respectful.
How does this 23rd June 23 circular is adverse to you?
My Lords, if Lords kindly see the certificate, what is issued, my Lords, Annexure D to page number 27. The event was, my Lords, held between 1st to 10th April 2018.
Between?
1st of April to 10th of April 2018. 18. They say, my Lords, it is before the cutoff date, that is 1/6/2018. As such, we will not take that into consideration. That is one, my Lords, argument they have.
But you are falling within between 1/6.
Please.
Lord, the crux of the matter is only that, my Lord. The crux of the matter is only that, my Lord. They don't fall in the cutoff dates. My Lord, they fall short by about 2 months. And this circular, my Lord, is only a clarification issued as the cutoff date, as that is the beginning of the year for an academic year. 1st June is the beginning of an academic year. And we have taken 5 years prior. So it is 31 May, 5 years back. Hence, they've participated in a tournament. It is a recognized tournament. There is no doubt about it, my Lord, but that is not within the cutoff period. And rest of the tournaments, what she has participated in, that is not considered to be eligible. That even they have no dispute about it.
My submission is, my Lords, Annexure R2 is not issued as a clarification, my Lords, to the rules. The rule, my Lords, the circular, if it is seen, there is no mention of the rules, my Lords, at all. It's just how we are doing it. If at all it is said, my Lords, it prescribes a period of study, so we classify this as between from this date to this date, my Lords, I can understand. There is nothing in this circular, my Lords. In fact, my Lord,
File your counter.
I have filed my counter.
Lord, this
also
pleadings are coming.
I want to file a memo on 21/8/2000.
In fact, my Lord, the state is on record, my Lord,
Has been classified as P5. On that basis, she selected a seat, joined the
So
institution.
your rule says that all certificates which are obtained from the commencement of study in eighth till conclusion of study in 12th are liable to be considered.
Yes, that is the block P.
Now you are carving out a period which may exclude somebody like petition. Today you are studying something?
My lords, I had to, my lords, join the, my lords, payment quota. My lords, my submission is that, my lords, if, my lords, I had no other option, my lords, because this petition was pending, they are not filing the objections. It is filed only now. In August 2014, my lord, the state comes with this objection on 19/8/2014. My lords, it is, my lords, my submission is, my lord, the seat can be adjusted, my lords, with the respondents or, my lords, this year, my lords, in the counseling.
Which we are relying on, which you are relying on some judgment?
Yes, my lords. Your lords, my lords, on the other day I filed, my lords, list of authorities, my lords.
You have filed it?
Yes, my lords. In the court, my lords, I filed.
You participated in chess? Yes.
Please, my lord.
Which game you participated? Chess?
Yes.
Chess, my lords. At page number 3, my lords, I have laid upon, my lords, the order passed by your lordships in the other matter.
You were admitted in the very year on payment
Yes.
sheet.
On payment, Lords, I have taken a payment sheet. Lord, as such, my Lords, my submission, Lords, placing reliance on, my Lords,
What fees you did pay
please, my Lord,
for your admitted payment sheet?
payments.
What is the fees? What are the
Lords, it comes to, my Lords, about 20 lakhs and odd.
20 lakh?
Lords, if I,
Here, what is the fee?
it will be around, my Lords, I understand about 2 lakhs. My Lord, I'll have two chances, my Lord, two choices, my Lords, if I get P1. One, I can have, my Lord, choice of the college. Number two, my Lords, the fees will be less. It will be a government seat, my Lords.
You would have got different college also.
Yes, my Lord, it was possible for me.
And your lordship's judgment, my lord, there, my lord, the state found him eligible under P5. That's the reason my lordships have.
So you people are appearing, both of you?
For respondent number 13, appeal for respondent.
13.
They were selected candidates at that point.
Selected. So heard learned advocate, Mr. So-and-so for the petitioner, who learned additional government advocate, Mr. Sudhir HIGHCOURT, respondent state and authorities, from a learned advocate, Mr. N.K. Ramesh, for respondent number so-and-so, Karnataka examination authority, from a learned advocate, Mr.
I'm for respondent 7 to 9, 11, 12.
So-and-so for, and you are for?
Respondent number 13, my lord.
13.
13.
So-and-so, 7 to 9 and 11.
7 to 9, 11, 12. 10 is not appearing.
9, 11, 12. And learned advocate Miss so-and-so, number 13. From at length. Learned counsels for the party stated that they argued the petition finally. All are represented, all testimony.
Yes.
And that the pleadings are complete. They do not want to add or supplement any pleadings, any supplement any further the pleadings. Resort for judgment.
Chess Federation of India not represented by.
Chess Federation of India is not been represented.
Who?
Chess Federation of India, my Lord, those served. They are, my Lords, they are not.
Chess Federation
They are
of
served.
India.
So as for the last, who is that number?
Respondent number 6.
6, sir. 6.
Number 6. Respondent number 6.
All India Chess Federation.
Number 6 goes out, has not chosen to act.
And respondent number 10 also, private respondent not appeared.
Both.
10 respond.
5 and 10 both.
Yes. My Lords,
5 and 10.
my Lords,
So result.
with leave, my Lords, I'll make one submission. My Lords, I am required to, my Lords, pay the fees, my Lords, for the second year. My Lords, I have cleared, my Lord, the examination, my Lords, in first class. Lords, my Lords, consider it, my Lords, pronouncing the order, my Lords, at an early date, so that, my Lords, it will help me, my Lords.
It is our duty, we are alive to it.
My Lords, it's only a request from my side, my Lord, so that.
The request is not in a good terms.
I'm sorry, I'm extremely sorry about.
To our duty.
Yes, my Lords. I'm extremely sorry about it. My Lords, it was my.
Any doubt about that course of action, you go before another court.
No, it
Will
is not. No. What I tried to say, my Lords,
So
was.
in Gujarat, I never used to enter in such a request.
I'm extremely.
You can't presume that we are delaying it.
No. What I tried to say is, my Lords,
We are alive to subject matter.
I understand.
Alive to the urgency.
I understand.
Alive to your rights. Or we are alive to their rights.
I'm sorry, my Lords, I'm
The
obliged.
request, henceforth, any advocate mates will not take up the
My Lords, the only I. My
out
Lords,
of
I tried-
propriety on your part, and it is not acceptable to us at all, Mr. Counsel.
my Lords, I'm extremely
Please
sorry. my
take
Lords.
the word. Such a requests are not to be made.
I'm extremely sorry, my Lords.
Pension is not permitted.
I'm extremely sorry,
Maintain
my
the
Lords.
decorum of the court. If you want to conduct the court before this court and conduct the court in accordance with the stream of the matters, you do it. Otherwise, you go before another court. We are not enamored to take any matter.
My Lords, I'm
Not
extremely
before
sorry.
this court then.
No, I'm extremely sorry, my Lords, about that.
Don't mention such a.
In fact, my Lords, a request was made, my Lords, from.
No, sir.
I am sorry, my Lords. My Lords, my Lords, I have nothing more to say.
If you don't know the decorum and the propriety of the court, you must learn it.
I'm sorry, my Lords.
Counsel.
I am sorry, my Lords.
We are devoting time like anything. You are making
My
such
Lords,
request.
my Lords, I'm sorry, my Lords. It's only, my Lords, for the reason, my Lords, that they made the request, my Lords, today. My Lords,
Next matter.
I'm sorry.
Nothing. Yes, Mr.
Correct.
In that case, this is, as an officer of the court, I am saying, because otherwise I would say that taking that seat this year and that I will oppose. That will be the normal. But if this court comes to the.
We are not enamored to any advice. We are aware of it. No, next matter. You argue, don't advise the court. Yes. We are aware of everything. We have concluded the hearing. Any advices and instructions are not, we are not soliciting. We laid down the law. If we are not right, you can go ahead.
It is not a textbook. This is a submission as an officer.
What is this? This lawyer makes such request pronounced early. Other lawyer makes a suggestion. We are not accepting any suggestions. We know what to lay down and what not to lay down. Yes. Mr. Counsel, we are not here in any advisory jurisdiction.
We are not. My lords are not. Here, a sentence of a submission, as an officer of the court, if you are that, if that is the case, one possible remedy would be this court wishes to pass that order. In case it comes to a conclusion, it could be that the state government, because in our jurisprudence, damages are not developed to that extent. I would request the court when my lord ask the question, what would be the extent of the fee? What could be done? One seat from the state government quota can then be transferred to the so that seat will remain intact, and one seat here will get transferred to the other, so that the fee issue gets resolved, but not a wastage of a seat. That's the only submission.
We'll consider everything. Yes.
This is number 3. Lem Chidanandaya.
Appear for the petitioner and the matter.
Yes, madam.
Lordship's copy is served to me today, Your Lordship. Some time may be granted. Respondent number 2 has filed.
Learned advocate, Mr. So and Miss so and so petitioner, 6 times stating that the copy of the appeal in reply is served.
Statement of objection served by the respondent number 2.
Appeal in reply comes statement of it. Stand over to 25th.
10 days time to be granted.
10 days. It can go after vacation.
Yes, Lord.
It can go after vacation. 16th of October. As requested by her. As requested by her.
This is number 4.
Yes, for.
Number 4, I appear for the petitioner matters. Last time the respondent number 2 had to get a direction because I have produced, this is a matter pertaining to sports quota, my lords. I produced 2 certificates.
What happened?
They had to get an instruction.
Acceptable.
The last occasion, my lords had directed the Youth Affairs Department to forward it. We have forwarded to the KEM for consideration.
We'll Lordship, I have this tomorrow, day after.
It's orally they have informed us that they will be we will be considered to round 2.
Then
orally they have considered, my lords, but
definitely consider.
Tomorrow.
Round 2 is not at all. Lordship, I have it on Friday or tomorrow. I will.
Tomorrow.
Or 19. 19.
It's 19th will be too late because
tomorrow.
Only this is orally they have informed us only in.
Mr. Ramesh will try to.
Please.
Very
Great.
It's number 5.
Yeah.
For petitioner.
This matter, my lord, this matter pertaining to medical seat, my lord. My lord, this matter pertaining to medical seat, my lord. My lord, the petitioner passed the second PUC examination on distinction, my lord. My lord, he secured the marks, my lord, 559, my lord, out of 600, my lord. Thereafter, my lord, he returned the NEET examination, my lord. In the NEET examination, my lord, he secured the 560 marks, my lord. And also ranking, my lord, 1,24,657, my lord. My lord, when he submitted the application before the competent authority, my lord, he mentioned his caste, my lord, as a OBC 3B, my lord. My lord, but in the verification slip, my lord, wrongly mentioned the caste of the petitioner, my lord, is a GM category and income shown the income as a 0, my lord. My lord, it is adversely affected the candidature of the petitioner, my lord. For that reason, my lord, the petitioner has submitted a representation before the second respondent, my lord, on 15/8/2024, my lord, for correction of the caste, my lord. But my lord, till this date, they have not taken steps, my lord. My lord, I produced my caste certificate, my lord, annexure F, my lord. Lord, verification slip, my lord, annexure C, page number 15, my lord.
It is too late, my lord. And in the application itself, he has not claimed OBC. He has claimed only as religious minority. OBC he has mentioned as GM. Yes, my lord. Lordship. Yes.
This is one investigation. But the changes that have happened,
Now, first round counseling is over.
Number 6, VV Siddaramaiah, appearing for petitioner. My lord, I will not press the memo. We have the IA number 1/2024. Memo may be dismissed as not pressed. IA number 2 is only with respect to correction of the academic year 2000.
This can wait.
Memo may kindly be dismissed as not. Memo may kindly be dismissed as not pressed. I have filed a memo for consideration of interim prayer that may be dismissed as I will not press that memo. I have filed separate application. My lord, I have filed a memo. I am withdrawing memo. And IA number 2 is for correction of the writ petition that may kindly be allowed, my lord. There is office objection on memo. Subsequently, I have filed IA 1/2024. The office objection is I have to file an IA. I have filed IA in view of the same memo does not survive. And IA number 2, my lord, is with respect to correction of the academic year as 2024-25 in page number 11 of the petition. In IA number 2/2024, my lord. One. Amendment of the writ petition. Well, one IA is for consideration of interim prayer, another IA is for amendment of the writ petition. So only correction of the academic year as 2024-25 instead of academic year 2023-24. Please, ma'am. Amendment.
So IA 4 of IA 4.
amendment.
I1, 1 of 24, heard learned counsels for the respective parties. The present is in application under Order 617 of the Code of Civil Procedures 1908, whereby the applicant petitioner seeks to amend the memorandum of original petition by praying thus. Bracketed portion on page 46. Full stop. The amendment is formal in nature and the petitioner applicant wants to correct the academic year as 2024-25 in place of 2023-24. Accordingly, amendment is granted as prayed for. The interim application is allowed.
Yes. My lord, filing of amended petition may kindly be dispensed. Only small corrections.
Looking to the smallness of the amendment, filing of the amended petition is dispensed.
I may be permitted to carry out amendment right now, my lord.
Pardon?
I may be permitted to carry out amendment right now. Yes, please.
Yes.
This is number 7. So Prasanna Deshpande.
Yes, sir. Next.
For the petitioner has challenged the order passed under section 19. Direction, no, Lord, section 91.
91.
Please, Lord. Lord, the case of the prosecution, Lord, the complainant filed a complaint on 29/11/2021. The complaint allegation that the accused number 1 and 2 had been to the shop. Who is the
in a 7A proceeding?
Please, Lord.
Who is the respondent? Government servant?
Yes, Lord.
All right. Yeah, trial start agidya.
The charge sheet is filed before, during the investigation, they filed an application for seeking a information about the call details of the investigation officer.
91 right would spring to you only after the commencement of the trial. You can seek that document at the commencement once the trial commences. Mic use ಮಾಡಿ.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ 3 ವರ್ಷ ಮಾಡಿದ್ರೆ ಡಿಜಿಟಲ್ ಡಾಟಾ ಡಿಲೀಟ್ ಆಗಿರುತ್ತೆ ಲಾರ್ಡ್ಶಿಪ್ ಅದು ಕ್ಲೈಮ್ ಮಾಡಕ್ಕೆ ಸಾಧ್ಯ.
I will reserve liberty and direct conclusion of the trial within a time frame.
Yes, Lords. But parties judgment ಅಲ್ಲಿರೋ restrictions ಬರೀ ಪ್ರೊಡಕ್ಷನ್ ಮಾತ್ರ ನಾವು ಪ್ರಿಸರ್ವೇಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀವಿ ಲಾರ್ಡ್ಸ್.
No, not parties judgment. 2004 you are talking of. There's Nitya Dharmananda in 2018, which distinguishes parties judgment, saying that that right would flow only after Nitya Dharmananda would flow after the commencement of the trial. We'll reserve your right. But that would run counter to, see, parties judgment went on a footing that if that was of a sterling quality, then yes, it can be produced in 482 also.
Yes.
So that would not inure to your benefit now. ಈಗ ಯಾವ ಸ್ಟೇಜ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ?
Charge sheet is filed.
3 ವರ್ಷ ಯಾಕೆ ತಗೊಂಡ್ರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ?
Lord, initially it was.
That is why I say you should put your house in order. ಏನ್ ACB ಇಂದ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಬೇಕಾಯ್ತಾ?
House.
ACB did nothing?
Lord, the initial trap and the sanction was pending for the obtaining sanction.
Sanction ಎಲ್ಲ ಆಗಿದೆ.
Charge sheet was filed.
Whatever application is now pending, what's your name?
Avinash.
Avinash ಅವರೇ. Whatever application is pending, you can revive that the moment trial commences.
But digital data ಯಾವ ತರ?
Digital data ಏನು?
2 years ಆದ್ಮೇಲೆ ಡಿಲೀಟ್ ಆಗುತ್ತೆ ಲಾರ್ಡ್ಶಿಪ್ ಅದು.
ಏನ್ ಡಿಜಿಟಲ್ ಡಾಟಾ ಕೇಳ್ತಾ ಇದ್ದೀರಿ?
CDR.
CDR of whom?
Investigation officer and the writing party there is asking. Lord, the trap was successfully laid. And he is claiming that, Lord, he had demanded 10 lakhs initial, 10,000.
I don't think CDR gets deleted.
ಇಲ್ಲ ಲಾರ್ಡ್ಶಿಪ್.
Deleted? 1 ವರ್ಷನ?
ಗವರ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ಇದೆ 2 years ಆದ್ಮೇಲೆ ಡಿಲೀಟ್ ಆಗುತ್ತೆ.
ಮತ್ತೆ ವಾಟ್ ಡು ಯು ಡು? ಇವಾಗ
2 years ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ.
ಈಗ ಅಲೋ ಮಾಡಿದ್ರು ಏನಾಗುತ್ತೆ?
Within 2 years ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ ಲಾರ್ಡ್ಶಿಪ್.
ಅಲ್ಲ ಆರ್ಡರ್ ಆಗಿದೆ, ಬಟ್ ಈಗ ಅಲೋ ಮಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ ಹೇಳಿ? ಟುಡೇ ಐ ಅಲೋ your application. If the data is deleted as per the government direction, and what is the use of the
plus sessions court order within 2 years ಅಲ್ಲಿ ಆರ್ಡರ್?
ಅದು ಆಯ್ತು, it's now gone. Today we are at a stage where it is 3 years. Does the sessions court say that it should be preserved?
ಪ್ರೊಡಕ್ಷನ್ ಆರ್ಡರ್ ಮಾಡಿದೆ.
ಪ್ರೊಡಕ್ಷನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಪ್ರೊಡಕ್ಷನ್ ಆರ್ಡರ್ ಯಾವಾಗ ಆರ್ಡರ್ ಮಾಡೋದು? 2 years ಒಳಗಿತ್ತು ಅದು?
ವಿತಿನ್ 2 years. ಅಟ್ ಲೀಸ್ಟ್ ಪ್ರೊಡಕ್ಷನ್ ಆರ್ಡರ್ ಮಾಡಿದಾಗ ಒಪ್ಪ ಮಾಡಿರ್ತಾರೆ, ಅದನ್ನ ಸೀಲ್ಡ್ ಕವರ್ ಅಲ್ಲಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕಸ್ಟಡಿಗೆ ಆದ್ರೂ ಕೊಡಬಹುದಲ್ಲ.
The trap was laid in the 2020.
When did the court direct production of that CDR?
Lord,
November 2023.
17/11/2023.
17/11?
Sir.
Date of trap in?
date of draft, my lord, on 1.
2/12/2021. All right. 17/11/23 is the allowing of the application.
9/11/23, Lordship.
9/11/23. So it is within 2 years.
In 2 years.
All right.
Please.
When did you file this petition? 14 June 24.
Please.
What have you done with the data now?
Lord, what the information he sought, Lord. Lord, as per the complainant, Lord.
If you have deleted the data, adverse inference will be drawn because order was passed prior to 2 years. You have challenged it only after 6 months or 7 months after the passage of the order.
Lord, the application was filed in the year 2023.
ಹೌದು sir. 9/11/23 is the order.
Please.
Correct. 7 ತಿಂಗಳಾದ್ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ನೀವು.
Yes.
He is right in saying that data should be preserved.
Lord, it is our case, Lord. I have to prove the case, our case, Lord. He can take a defense at the stage of defense when it is posted for defense.
So preserve the data. In terms of the order, data should be produced at the stage of evidence. I will order that.
Lord, what the information, kindly see the order, Lord.
Sir,
He is seeking the tower location.
Impossibility of production of a data on the score that it would be deleted in terms of the government order or government circular. You cannot now do it because you're 6 months late.
I'll verify it, Lord.
What verify?
Whether it is preserved or
ಇದೆ ನಿಮ್ಮ ಹತ್ರ. ಇವ್ರ ಹತ್ರ ಇದೆ ನೋಡಿ. He will have everything ಕೊಡಿ.
2021 ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. 1 year ಇದ್ದಿದ್ದು 2 years ಸ್ಟೋರ್
2 years ಮಾಡಿದಾರಾ? Anything else, sir?
I'll cross verify it, Lord.
ಇದನ್ನ verify ಮಾಡ್ತೀರಾ?
No, Lord. Whether they preserved or now it is available or not.
ಅಲ್ಲ, if it is not preserved, deleted ಅಂತ if you come, that will run counter to the order.
I'll make submission.
ಈಗ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವ ಇದರಲ್ಲಿ?
There is a stay.
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದು?
Lord, interim order was granted.
7/8/2024.
7/8/2024.
8/7/24.
8/7/24. Please. All right. So, March water has flown. 23 ಆಗಿರೋದು order. You better well preserve it because interim order is granted after 7 months or 8 months. I'll take it on Friday.
Please.
If there is no information, we will dismiss this petition, directing its preservation till he files an application or revives it.
And next week,
Tuesday. Yes, list on Tuesday in the fresh matter. Wednesday in the fresh matters list. Yes. Idu file early, madam. Yes, next.
The petitioner's speech.
ITP and 370, sir.
Yesterday, my lords had directed the state to. They've employed the foreigner. They've employed a foreigner in the spa.
So foreigner id takshana it is presumed.
That is not the only thing.
Then, sir.
There is also a Mazar, my lord, which speaks about.
Give the records.
In the Mazar, my lord, it speaks about the.
List this on Wednesday in the fresh matters list. Madam. ಈ ರೆಕಾರ್ಡ್ಸ್ ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿರ್ತೀರಲ್ಲ ಮಾತ್ರ ಕಳಿಸ್ಬೇಕು. ಸರಿ, CH3 ಜೊತೆಗೆ ಅದೊಂದು ನೋಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Avoid services. Avoid service.
Post immediately after service of notice upon the respondent.
Entry mod.
Idea entry mod.
This error.
Subsist interim order, comma, if any subsisting shall continue to the next date of hearing.
In both.
Idre. Oh, sorry, list to note.
Here for the petitioner. My lord, it appears in this matter, the police will not file a B report. And then, my lord, a protest memo was filed. Protest memo has been accepted. And then, my lord, there is a further order for investigation by the magistrate. So, my lord, they have to tell you, lordships, what they have done. And
where are the papers?
Last time, that was what was required to be done.
Additional SPP is directed to.
Pass over, my lord. received the papers to them.
You have received the papers. Anyway, I have granted some protective orders.
No, my lord. Your lordship said after the. I'm seeking for a protective order.
Yes, we'll pass it over. Pass over. 4 o'clock. Yes.
Anyway, I have another matter, my lord.
Then comes. Yes. Oh, that further hearing matters.
Yes,
All
further. Yes.
24.
Petition. Lords, this is a matter wherein, my lords, initially there was an apprehension by the respondent number 3 that there is companies which are being floated in India where they are they have launched betting apps and they try to destabilize the economy. On that information, my lords, the respondent number 1 and 2 register an FIR against 9 companies.
Correct.
On the all the 9 companies, they call for records, and 7 of them are probably guilty, please, my lords. 2 of them, we, especially the petitioner herein.
Not guilty at all.
No, we give whatever documents are given, asked for. And we show our bona fide saying we are people who are manufacturing wheelbases and we are exporting it, importing it from China. Now we want to start a plant here, manufacturing plant here. We have acquired lands in Siri City. We showed them all those things. They defreeze the account. But only problem was, my lords, now they have not filed charge sheet. Because my name is reflected as an accused, nobody is doing business with me. It's a small market, please, my lords. We have only 2 customers, TVS and Honda. They are not doing business with me. On that pretext, my lords, we are come here.
What is your company? Chong Quing Jelly. What do you mean by that?
It's a name, please.
A name. All right. Yes.
That's why it's the only ground, please, my lords. 2.5 years have lapsed. They have asked for every documents. They defreeze the account. If they say now that there is nothing, I have nothing to do with the crime which has been reported, it may be quashed because they cannot file a charge sheet.
So you are dependent on his say. We will ask Shanti Bhushan.
They say of R1, R2.
My learned friend has
You're
to say why he is the investigation, my lord, with regard to the investigation.
What happened? I believe, my lord, that number of complaints was given on the same day with respect to all these Chinese apps.
All right.
About 60 plus charge sheets have been filed. Not against him, in all the complaints which they have given on that day.
All right.
So some more cases are being investigated. But this case, my lord, it is not a Chinese app, loan app case.
If it's not, then why freezing of the account?
Freezing.
No, freezing, they defreezed it. Now it is being showed as an accused. I have been showed as an accused, that's all.
Investigation officer says, my lord, since it is not a Chinese loan app case, they probably file a different report.
Please.
B report ಆಗ್ತೀನಿ.
Only against me. If they file B report, I have no problem. But they are not filing it only against me.
ಅದೇ ಬೇರೆಯವ್ರಿಗೆ ಯಾಕೆ ನೀವು worry ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
No, they can't file a partial final report. That's the only problem.
Why are you worried about others?
We have filed 60 plus charge sheets.
ಚಾರ್ಜ್ ಶೀಟ್ಸ್ ಹಾಕಿದ್ರೆ ನಿಮ್ಗೆ ಹಾಕಿಲ್ಲ ಅಲ್ವಾ ಇನ್ನು? ಆಯ್ತು, ಈ ಕಾಂಗ್ಚಿಂಗ್ ಜೈಲಿಗೆ ಏನ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ?
Time, my lord, we will file a report.
ಯಾವತ್ತು when will
No, problem is time only, please, my lords.
Problem is time.
Please.
ಜಾಸ್ತಿ ಕೊಡಲ್ಲ. Yes. Come up with whatever you have.
End of the month, my lord.
We'll take it on 25th. By then, if it is not there, I'll quash it.
Published.
I'll consider quashing it. ಯಾಕಂದ್ರೆ ರೆಕಾರ್ಡ್ ಬೇರೆ ಆಗ್ಬಿಡುತ್ತಾರೆ. ಕ್ವಾಶ್ ಮಾಡ್ತೀರಿ ಅಂತ ಹೇಳಿದ್ರಿ ಅದು.
Yesterday, my learned friend told my lord,
No,
not cooperating. That was when I don't know that I'm scared now.
Ella, don't tell anything in the lighter way, sir. Yes.
I meant his client, not his.
ಗೊತ್ತಾಯ್ತು. He will not mind. He knows what Jagdish is. Yes.
25.
My lord, I filed my wakalat in the counter yesterday, please, my lord, for R2.
ಯಾರಿಗೆ sir?
R2, respondent number 2. R2, I filed my wakalat in the counter yesterday.
Lord,
my name is not shown.
Petitioner in criminal petitions.
Come this side. Come this side, sir. You are the petitioner, right? Now, why are you standing away from him? Yes.
Lord, there's a writ petition pending before your honors. Writ petition number 7122 of 2024.
With 482, na?
Read with 482, yeah.
71 is already connected.
In the last occasion, your lordship had connected this matter with my matter, my lord.
All right.
ಏನ್
Lord,
ಪ್ರಾಬ್ಲಮ್?
In that, there's a stay operating.
ಏನಾ?
In my matter, there's no stay.
All right, sir. Yes, Tulsi Kumar sir.
I will file my statement of
Every
objection.
case will
My lord, my name may please be shown, please.
The learned counsel B.N. Tulsi Kumar submits that he has ಅವ್ರ ಅವ್ರ ಹೆಸರು ತೋರಿಸಿ ಅನ್ಬಾರ್ದಾ? ಸ್ವಲ್ಪ ಇರಿ. Yes. The learned counsel B.N. Tulsi Kumar submits that he has entered appearance for the second respondent. Registry to print the name of B.N. Tulsi Kumar is appearing for the second respondent. ಏನ್ ಹೇಳಿ?
Case filed by me, my lords, the petitioner in the cell number 25 is the complainant.
For the complainant.
My contention.
Why do you want to stay in that?
My lord, no, my lord. There's a counter blast.
Wherein he is
It is arising out of the same crime, my lord.
that two different FIR.
But it's arising out
You
of
have
the
been
same.
protected, will protect him also. This court, in the 7122 na.
7057.
This court in writ petition 7122 of 2024 on 27/3/2024 has passed the following order. In the light of the common facts obtaining in both these cases, there shall be an interim order of stay of further proceedings in criminal petition 7057 of 24 as well till the next date of hearing. List on 26th. Yes.
Great.
Interim order subsisting in so and so shall continue till the next date of hearing.
Great.
Stay application alone. Yeah.
26?
Next week. Okay, sir. List after 2 weeks. Yes, next. Next bench ಮುಂದೆ try ಮಾಡಿ. Yes.
During the course of the day, my lords.
Interim order ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ.
Learned counsel submits that needful would be done in the next 2 days. In the event needful is not done in the next 2 days, interim order subsisting will stand vacated. Yes, next. Subject to the aforesaid condition, interim order stands extended to the next date of hearing, list after 4 weeks. Next.
28?
For petition minutes. It's 138 proceeding minutes. Absolutely non-compliance of section 56. Without endorsing the payment made by the.
Without?
Endorsing any payment minutes, they have.
No, that's all right. Where? Counsel for the petitioner to serve on the counsel.
Already served.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ. 6/9 ಅಲ್ಲಿ ಆಗಿದೆ.
List the matter after 2 weeks awaiting the representation of the counsel for the awaiting the representation of the respondent. There shall be an interim order of stay of further proceedings further proceedings before the concerned court till the next date of hearing. Next.
29?
354, my lord. Lord, there is a dispute with regard to property between the, my lord, the complainant's wife, sister, husband, family, and my lord, accused of 4.
Learned HCGP Tejesh to secure the investigation papers.
But in fact, I have placed all the records, my lord. Charge sheet is filed here.
The entire charge sheet material is not produced, my lord. Inside.
If you go by this, then I will dismiss it. Wound certificate ಇದೆಯಾ?
ಇದೆ.
ಕೊಡಿ. Anything else?
Lord, wound certificate, my lord, that is against, my lord, accused number 224, not against A1. As far as A1 is concerned. As far as, my lord, allegation against A1 is concerned, my lord, he slapped the, my lord, on Uma Devi. She is the mother of, my lord, no, that is allegation. My lord, as far as, my lord, assault is concerned, my lord, that is against.
That's a matter of trial, sir. 354B is what is alleged.
Lord, hear the case, Lord. Kindly appreciate it. Lord, here.
One male allegation ಇದೆ. A1 male kindly see.
A1, Lord, as per the charge sheet allegation, Lord, as far as the A1 is concerned, Lord, ಸಾಕ್ಷಿ ಹೇಳೋ ಬಟ್ಟೆಯನ್ನು ಹಿಡಿದು ಎಳೆದಾಡಿ ಕಪಾಳಕ್ಕೆ ಹೊಡೆದಿದ್ದು. That is
ನಿಮ್ಮ ಮೇಲೆ.
as far as A1 is concerned.
Sakala.
Lord,
Anything
Lord,
else?
kindly appreciate, Lord, kindly appreciate. Lord,
Anything
yeah,
else?
Lord, he being the Lord, the police officer, Lord, he is nowhere concerned with Lord, the dispute with regard to Lord, the family of A4.
Take chance, October 2nd week. Less than the 2nd week of October, pendency of this petition
as
will
far as
not.
354 is concerned, there is no ingredients.
Court. Yes. Surely. Purpose could be.
Lord, in so far as
Change other
350
chance.
354 is concerned, Lord, there is no ingredients of 354.
Idikinta ಬೇಕಾ?
Lord, kindly see, Lord, in terms of the judgment
They
of Apex Co.
Groped her and
Lord,
that's a matter after evidence. Sir. What is 482 354 report?
482 and in the appeal.
Yes.
Lord, some and substance, Lord, I just pass on this. Lord.
I will hold some and substance.
Lord, when Lord 354 Lord come into play, I just Lord, first Lord in the bottom, what constitute?
No. Idralli hair the accused had dragged the hair and pulled her.
Here, Lord, in this case, what happened, Lord? Why, Lord? How, Lord? In what circumstances, Lord? 354, Lord, gets subtracted. That's Lord. It's Lord called out here.
Yes, 2nd week of October. Yes, next. Give the papers back.
My lord, petitioner is accused number 4, my lord. Accused number 1, 2, 3, and 5 have been acquitted, my lord. Split up.
Split up?
Yes, my lord.
Pages?
My lord, 116, my lord.
116,
my lord.
Paragraph? Adena?
Yes, my lord. First, but from page number 116, my lord.
As per prosecution, para 16.
Yes, my lord.
Is government?
Please.
Page 116. 116 to 118. The petitioner is accused number?
4, my lord.
Accused number 4. He, along with other accused, would get embroiled in a crime in narration in crime number 133 of 2015 for offences punishable under section 324, 323, 447, 149 and 506 of the IPC. The petitioner is arraigned as accused number
4, my lord.
Accused number 4. At the relevant, the police, after investigation, filed a charge sheet. The concerned court would try the other accused who were available for trial in CC 293 of 2016. On the score that the petitioner was not available for trial or had escaped trial, a split-up charge sheet is drawn against him in CC 14 of 2019. The concerned court, after drawing up of the split-up charge against the petitioner, acquits the other accused in terms of its order dated 17/1/2019. In terms of its order dated 8/2/2021. The accused who are acquitted are accused number 1, 2, 3, and 5. Who remains in the story of crime is the accused number 4, the present petitioner. The learned counsel for the petitioner submits that the reasons so rendered by the concerned court to acquit accused 1, 2, 3, and 5 would 1, 2, 3, and 4.
1, 2, 3, and
1, 2,
5.
3, and 5 would inure to the benefit of the petitioner, as what is alleged is a common act performed by all the accused. He would seek quashment of the proceedings. The learned HCGP would refute the submission, contending that the petitioner has escaped trial and should not be shown any indulgence. He should undergo the trial and come out clean, as the other accused have undergone trial and come out. I have given my source. The four narrated facts are not in dispute. The petitioner is the one who has escaped trial. In the normal circumstance, would not be shown any indulgence for quashment of the proceedings to a person who did not stand trial like the other accused. The permitting further proceedings against the petitioner on the aforesaid score would only result in wastage of precious judicial time, as eventually the petitioner would get acquitted, for the reason that others are acquitted due to lack of evidence. The lack of evidence qua other accused cannot spring as evidence in the case of the petitioner accused number 4. In that light, I deem it appropriate to obliterate the crime against the petitioner. The view of mine is also. Yes. Next.
51,
Covered, same, disposed.
52.
One submission.
You know,
There are two pending petitions. Only one of them has
Kodi,
been listed today.
Kodi, give that.
Much.
Number Kodi. To the experiment. Does not.
Much of it.
Therefore, the petition. Therefore, the petitioner, madam. Therefore, the petitioner. Petitioner is.
Amele.
Therefore, the petitioner.
Admele heli sir.
Petitioner is a student, my lord.
Student.
He is studying second year PUC. Have produced annexure A, my lord.
NDPS sir.
Pending case, my lord.
Yes. 27B Kodi. Yenide.
One submission.
Confession na.
One submission, my lord.
Heli sir.
Earlier, we have challenged the same FIR, my lord, that has been quashed on the ground of FSL report is not submitted, my lord.
Page number.
Para 6 of the annexure B, I have annexure B, my lord.
Number 4, my lord, of impugned judgment. There's no FSL report, my lord, on that cause.
Idrallo ilva. We'll say it is covered and close it.
One submission, it is a competent government doctor is not a competent authority to issue this medical certificate. They have not issued this certificate.
We will hold it is covered by what is written by the coordinate bench and close it. The petitioner is before this court calling in question registration of a crime in crime number 99 of 2024 registered for offences punishable under section 27B of the Narcotic, Drugs and Psychotropic Substances Act 1985. Here and after referred to as the Act for short. Then reference bekagala. Yes, so and so. The learned counsel appearing for the petitioner submits that against the is a different crime adu.
Same crime. Same crime.
1453 lane crime adu. FIR stage.
FIR states. FIR is quashed. Criminal proceedings.
Different crime.
Crime number.
It is a different crime, my lord, but
crime number 1.
The learned counsel appearing for the petitioner would seek to place reliance upon an order of the coordinate bench in criminal petition 1453 of 2023 by which the coordinate bench had obliterated the crime registered against this very petitioner in crime number 1 of 2023. The subject crime is different, but the finding rendered therein would inure to the benefit of the petitioner as the grounds urged and the grounds answered by grounds urged would cover the grounds answered by the coordinate bench in the aforesaid judgment. The coordinate bench has held as follows, para 3 to end. In that light, the following order allowed quashed. Next.
33.
A1 illa, bereyavarige matra. Yes, Kashkan. Yes, no A1. Next.
34.
List on 20th. Yes.
35.
Lord, fresh matter.
20.
Fresh matter.
Beda. List on 20th at 4 PM and Thakima. Dictation must.
35.
Forest. Appearing for the petitioner. Atrocity Act, my lords, make a recollection. Atrocity Act, my lords.
Yes, sir.
Petitioners are, my lord, 78, 76 and 69-year-old. There was an issue between petitioner and the complainant with regards to the car parking. That has now, my lord, ended up in filing the FIR and a counter FIR.
Counter FIR idea.
Please, my lord.
ಅದನ್ನ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ? ಯಾವ್ದದು? ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ ಅದು? ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ ನೀವು?
ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಎಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ? ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿ 2 ಕಾಸ್ಟ್ ಮಾಡೋಣ. ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಜಗಳ ಎಲ್ಲೆಲ್ಲಿಗೆ ಹೋಗಿದೆ? ಯಾವ್ದಕ್ಕೆ ಫೈಟ್ ಮಾಡಬೇಕು ಅಂತ?
Till then, there may 78-year-old. Kindly.
1 minute, sir. Yes. List the matter on 25th. ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿ. ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ. List the matter on 25th. There shall be an interim order of stay where these petitioners till the next in the impugned proceedings till the next date of hearing. You also file. Well,
great.
25th hakirtini. 25th in the fresh matters list.
46.
I appeal for the petition. Forest matter.
File our objections.
Huh?
We have filed our objection.
So I not serve the copies.
Normally send an email. I'll give a copy.
Yes. 18th.
Please, Lordship, have it on 19th.
19th. Interim order ಇದೆಯಾ?
Interim order not to proceed any further action at this point.
The issue is, my lord, he is challenged in this writ petition. Notice issued to him is under 64A proceedings.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. Forest Act.
The entire proceedings.
No. You have challenged that. Then you should go to the GM court.
He challenged the FOC, but the notice is produced or the notice issued under 64A proceedings.
Because the proceedings, my lords, which was initiated against the violation of the certain acts.
19th is the fresh matters list.
Because there are several sections have been levied, my lord. I have challenged that also.
Imposed. Imposed. Levied tax. Yes.
57.
Sawmill. ನಡೀತಾ ಇದೆಯಲ್ಲ sawmill? Yes, ಲತೀಫ್.
ನಡೀತಾ ಇದೆ.
ಹಾ. ಏನು ವುಡ್ ಕೇಳ್ತಾ ಇದಾರ? ಪೆಟಿಷನ್ ಕಾಪಿ ಕೊಡಿ. ನಿಮ್ sawmill ಇಂದ ಏನ್ ಕೇಳ್ತಾ ಇಲ್ಲ.
ಕೊಡ್ತೀವಿ.
Yes. Counsel for the petitioner is directed to serve complete set of papers upon the counsel case Bhimaya forthwith. Lest the matter in the third week of October, interim order subsisting shall continue till the next date of hearing. Next.
This case I am on the petitioner. Petitioner is a complaint before the trial court. He filed a complaint.
Post immediately after service of notice.
Take notice
What
for.
is not necessary?
Not necessary.
Because Millard, the complaint.
Party ಯಾಕೆ ಮಾಡಿದ್ರಿ?
Normal party ಮಾಡಿರೋದು, but
ಅವ್ರು ನಾರ್ಮಲ್ ಆಗಿ ಬಂದಿದ್ದಾರೆ ಇಲ್ಲಿ. Wait, yes sir.
I'll take notice for my lord 4, 5 and 6. Lord, in fact, in criminal revision petition, my lord, I have represented all the respondents. Now I have not received instructions.
1 minute, sir.
Kindly see Millard annexure B Millard for a moment. ನಾನು ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. PCR ಒಂದು ಸೋನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. ಸೋನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಆದ್ಮೇಲೆ 201 ಕಡೆ ರಿಟರ್ನ್ ಮಾಡಿದ್ದಾರೆ. It is not correct.
He's also challenged criminal RP order where I have been a party and it is dismissed on.
Revision petition ಏನಾಯ್ತು?
Revision petition dismiss ಆಗಿದೆ.
Confirm ಆಗಿದೆ order.
ಹೌದು. But Millard this.
Yes. The learned counsel. Kasif undertakes to enter appearance for respondents.
Lord, 3, 4, 5 and 6.
Respondents 4, 5 and 4, 5 and 6.
But I appeared for all the people in the trial court.
Take notice.
I'll take notice.
Learned
Except for respondent number 3, my lord, I'll take notice because
the
that I have
learned
not.
counsel would undertake to enter appearance for all the respondents except respondent number 3.
Please.
Registry to print the name of Kasif as appearing for all the respondents except respondent number 3. Respondent number 3 ಗೆ emergent notice ಮಾಡಿದೀವಾ? Emergent notice to the ಆಗಿದೆ already. Yes, so and so.
ಈ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 19th ಇದೆ.
ಇರ್ಲಿ ಏನಕ್ಕೆ? So what?
Until then ಅವರು ನಮ್ಮಲ್ಲಿ ಮತ್ತೆ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೋಸ್ಕರ
ಏನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ?
ಅವರು ರಿಟರ್ನ್ ಮಾಡಿದ್ದಾರೆ. 4th ASM ನಾವು ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ. ಲ್ಯಾಕ್ ಆಫ್ ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಅಂತ ಹೇಳಿ ಅದನ್ನ ನಮಗೆ ಮತ್ತೆ ರಿಟರ್ನ್ ಕೊಟ್ರು.
Complaint was returned, but he was represented it also.
List on 18th in the fresh matters. Next.
39.
A2.
A2 madam.
A1 gyara.
A1 yeah.
A1 what is the matter?
This is a crime against the petitioner matters for the offences under section 13(1)(a) of PC Act 468, 471 and 477. There was
why are you now before the court?
There was a departmental proceedings which was
ಅದರಲ್ಲಿ
exonerate ಆಗಿದ್ದಾರೆ.
13(1) ಇಲ್ಲಿ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ರಾ?
ಅಲ್ಲ, on consequence of this registering of the FIR there was a departmental inquiry.
Notice ಆಗಿಲ್ವಾ?
Notice ಆಗಿಲ್ಲ.
First time.
Okay.
Learned counsel B.B. Patil is directed to accept notice for the respondent petitioner to serve 2 sets of papers upon counsel Sri B.B. Patil. List the matter on 20th, madam. List on 20th.
Until then,
yes, next. On 20th, please.
Date from.
Freeze. Yes, government. Why freezing of the account?
He has registered the complaint online, my lord. While registering the complaint, he has given his own account number for freezing. On account of which it has mistake ಮಾಡಿದಾರೆ. But the IO, he has brought to the notice of the IO. IO has also intimated the concerned bank to defreeze it. They have to do it. The respondent bank has to do it.
Who is the respondent bank?
Lord, primary and secondary.
ಯಾವ bank, sir?
Citibank and SBI.
Who represents them?
Notice ಹೋಗ್ಬೇಕು.
The investigating officer has frozen certain accounts on account of a complaint being registered by the petitioner. Inadvertently, the petitioner has mentioned his own account to be frozen while seeking freezement of the account. The investigating officer has so done is the submission of the learned HCGP on verification of the records. He would further submit that the account of the petitioner is directed to be defrozen by the investigating officer. The banks have not acted so. Therefore, though the banks are represented, notice ಆಗಿಲ್ವರ್ಗೆ?
ಇಲ್ಲ, notice has not been
The emergent notice to the respondent banks, the petitioner is at liberty to produce the said order which would enable the banks to refreeze the account of the petitioner by the next date of hearing. List the matter on.
Lien is being marked on a daily basis. I'm running at 30 lakhs.
I think they will do it. List the matter on Wednesday in the fresh matters list. It produce ಮಾಡಿ ಬಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ will direct what is to be done.
Please.
Yes. Next. Prepare ಆಗಿಲ್ಲ. PF ಕಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ, ನೋಟಿಸ್ ಆಗಿರಲಿಲ್ಲ.
ಆಗಿದೆ ನೋಟಿಸ್. ಇವತ್ತೇ ಕಟ್ಟಿ. Yes. Next.
41.
Post immediately after service of notice. Idira.
Respondent number 2 in the
Learned counsel so and so undertakes to enter
I've
appearance.
already filed wakalat yesterday.
Submits that he has entered appearance for the second respondent. Registered to print the name of so and so is appearing for the second respondent. Objections?
I'll file it on the next week, my lords.
Learned counsel seeks 10 days time to file interim order.
No, man.
Seeks 10 days time to file statement of objections. Objections, if any, in the next 2 weeks. List the matter after 2 weeks. Next.
42. Charge sheet is filed in this case, my lordship. They have filed the prime lordships.
Charge sheet.
Charge sheet is filed, my lord, during pendency of this.
Amend interim order ಇದೆಯಾ?
Interim order ಇಲ್ಲ, ಅದೇನಾಗಿದೆ?
Amend ಮಾಡ್ತೀರಾ?
I will.
Amend ಮಾಡ್ತೀರಾ?
Amend ಮಾಡ್ತೀನಿ.
ಬೇರೆ ಹಾಕ್ತೀರಾ?
Amend ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. Until then, my lordship.
No.
Stay me.
I will not.
This matter was listed on 2nd, my lordships.
You said you will amend, you will file an amended petition.
Please, my lords, allow me to make submission, please, my lords. ಒಂದೇ ಒಂದು submission ಇದೆ.
ಅದಕ್ಕೆ ವಿಡ್ರಾ ಮಾಡಿ ಇಮಿಡಿಯೇಟ್ ಹೊಸದ ಹಾಕಿದ್ರೆ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ. ಇಲ್ಲ ಯು ವಾಂಟ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಓನ್ಲಿ ಅಂದ್ರೆ ಇಟ್ ವಿಲ್ ಕಮ್ ಇನ್ ಅಪ್ಲಿಕೇಶನ್ಸ್.
ಇಲ್ಲ, ಅದು ಮೊನ್ನೆ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಲಾಸ್ಟ್ 2nd ನೀವೇನು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರೆ ಸೆಕ್ಯೂರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರಿ. ಅದಕ್ಕೋಸ್ಕರ ಇನ್ ಸ್ಟೇ ಕೊಟ್ರೆ ಇನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕೋದಕ್ಕಾಗಲ್ಲ ಅಂತ ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಇವತ್ತು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿದೆ.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಆಮೇಲೆ ಸ್ಟೇ ಕೊಡಬಾರ್ದು ಅಂತಿಲ್ವಲ್ಲ. ಏನು ಒಫೆನ್ಸ್?
498A 304B, my lordship. ಅಲ್ಲ, ಟೋಟಲ್ ಎಲ್ಲ ಇನ್ಲಾಸ್, ಎಲ್ಲ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಕಂಪ್ಲೀಟ್ಲಿ ರೋಪ್ಡ್ ಇನ್, my lords, falsely roped in.
ಪರವಾಗಿಲ್ಲ, ಆರಾಮಾಗಿ ಹಾಕಿ, ತೊಂದರೆ ಇಲ್ಲ.
Permit to withdraw, my lords.
All right.
With liberty.
With liberty. File it immediately. No
Please,
problem. We'll consider.
Please. Oblige.
Get the latest judgment of Supreme Court.
Please.
Unless demand of dowry is established, 304B will not come.
Please.
That you should travel in that.
ಇಲ್ಲ ತಗೊಂಬಂದಿದ್ದೀನಿ.
ತಗೊಂಬಂದಿರಾ? Yes. Justice Pardiwala.
ನಿಮ್ದು ಒಂದು
ಬೇರೆ
ನಿಮ್ದು ಜಡ್ಜ್ಮೆಂಟ್.
ಸರಿ ಆಯ್ತು, ಕೊಡಿ, ಚಾಲೆಂಜ್ ಮಾಡಿ.
Please.
ಆಮೇಲೆ ಮೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಹೇಳಿ, ಐ ವಿಡ್ರಾನ್ ಸಿನ್ಸ್ ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ಫೈಲ್ಡ್ ಅಂಡ್ ವಿಲ್ ಟೇಕ್ ಇಟ್ ದಿ ವೆರಿ ನೆಕ್ಸ್ಟ್ ಡೇ.
43.
My lords, I appear for the petitioner, my lords. My lords, I seek, my lords, 1 week's accommodation, my lords, in the matter. Need to seek some instruction, my lords, from the party.
Only committal procedure, man. Only committal procedure is not followed. There is a contention.
This has to be allowed and sent back ಅಷ್ಟೇ sir.
My lords, a week's accommodation, my lords, to seek instructions.
List
My lords,
on
a week's
material instruction.
Please.
List on 19th in the fresh matters list as a last chance. Interim order subsisting shall continue to the next date of hearing.
In both the petitions.
ಎರಡಿದೆಯಾ? ಆಯ್ತು.
ಎರಡು.
We will allow
Same
it and
issue.
send it back.
Please.
Yes.
44.
But in this case, my lord, on a
Freezement.
It
In this
pertains to
case,
Kalburgi branch.
account defreeze, my lord, savings bank account. In the annexure,
ಅಲ್ಲ ಆಯ್ತು, ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದೆ. ಈಗ ವೈಫ್ಸ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದೇ ತಾನೇ ಇದು.
Yes,
ಸುನಿಲ್
ma'am.
ರಾವ್
Yes,
ಅಪಿಯರ್
ma'am.
ಆಗಿದೆ. ಸರಿ ಅದು ಆರ್ಡರ್. Yes,
copy
Jagdish.
along with the,
The amount of 50,000 rupees has been, 5 lakh rupees has been received in this account. There.
my lord,
Whatever, lien is marked and other accounts ಅಲ್ಲಿ ಇದೆ. ತಗೊಳ್ಳಿ.
That can be done.
my lord, here in the complaint, my lord,
Just look into it. ನೀವೇ ಆರ್ ಕಂಪ್ಲೇನೆಂಟ್. ಅಂಡರ್ಟೇಕ್. ಅಲ್ಲ ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸೇ ಬಿಡೋಣ.
my lord, here, I just read the complaint, my lord. Page number 47. It is the interim order passed by this honorable court along with the updated annexure G. Annexure G ಅಲ್ಲಿ ತೋರಿಸ್ತಾ ಇರೋದು ಮೈನಸ್ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಅವರದ್ದು 20,000 ರೂಪಾಯಿ ಬ್ಯಾಲೆನ್ಸ್ ಇರ್ತದೆ. ಆ 20,000ವನ್ನು ಸಹ ಮೈನಸ್ ಮಾಡಿ 2,51 lakhs ಅಗೇನ್ ಬ್ಯಾಲೆನ್ಸ್ ಮೈನಸ್ ಬ್ಯಾಲೆನ್ಸ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ. ಅಂದ್ರೆ ಇಲ್ಲಿ FIR ಫೈಲ್ ಆಗುತ್ತೆ 1,26 lakhs ಅಂತ ಹೇಳಿ. ಆ 1,26 lakhs ಅಲ್ಲಿ my lord 72 lakhs ಕ್ಯಾಶ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಮತ್ತೆ 5 lakhs ಬೇರೊಬ್ಬರ ಅಕೌಂಟ್ ಇಂದ, ನಾಟ್ ಇವನ್ ಬೈ ಫ್ರಮ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್.
This was the case of your husband, is it?
Not even from this complainant, but from the other person. 5 lakhs ಇವರ ಅಕೌಂಟಿಗೆ, ದಿಸ್ ಪಿಟಿಷನರ್ಸ್ ಅಕೌಂಟಿಗೆ ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಬೇಕಾದ್ರೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೇನೆ ನೋಡಿ.
ಎಸ್,
ನಾಳೆ ತಗೊಳ್ಳಿ.
5 lakhs ಹೋಗಿದೆ. That lien can be marked.
that too, my lord, I'll read the page number.
So we'll mark lien on that 5 lakhs.
My lord, I'll read the complainant.
ಅದು ಬೇಡವಾ?
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಇದೆ my lord. ಅದರಲ್ಲಿ
ಅಲ್ಲಿ ಇವರು
ಗೆಳೆಯನಾದ ಬಸಪ್ಪ ತಂದೆ ಉಪಾಶಪ್ಪ ಅವರ ಅಕೌಂಟ್ ಇಂದ 5 lakhs ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
No, that's
ಇವ್ರ
the
ಅಕೌಂಟ್ ಇಂದನೂ ಅಲ್ಲ, ನಾಟ್ ಇವನ್ ಫ್ರಮ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್ ಅಕೌಂಟ್.
No, that's the matter.
And the same 9 lakhs rupees, so same Siddhap, this complainant's friend, ಅವರೇ ಅದರಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ, ದೇರ್ ಇಸ್ ಸಪರೇಟ್ ಅಗ್ರಿಮೆಂಟ್ ಇರುತ್ತೆ. 9 lakhs ಅವರಿಗೆ ಹೋಗುತ್ತೆ ಈ ಕಂಪ್ಲೇನೆಂಟ್ ಕಡೆಯಿಂದ, ಈ ವಿಕ್ಟಿಮ್
These
ಕಡೆಯಿಂದ.
things you should investigate fast
Yes.
and finish it.
No.
How long will you keep this maze of facts?
My lord, here 1,26 lakhs ಗೆ ಕಂಪ್ಲೇಂಟ್.
ಒಂದು ನಿಮಿಷ. Yes. Yes, sir.
Now they collected all the documents, my lord, which shows the financial trail between all these people. Between the petitioner and other people. Basically, my lord, the farmers.
ನಿಮ್ದು ಎಷ್ಟು ದುಡ್ಡು ಹೋಗಿದೆ?
My lords, we are the president of a Basavana Vadagadi horticulture farming production company. These are all members. We have collected the money and we have transferred them. They are told they will build a poly house and they'll statutory income will come, monthly income will get it. It was promised, my lord. Based on that, we have transferred the money.
How much money you transferred?
I'll undertake, my lord.
Sir. My lords, on different occasions, I have transferred the money, my lords. In the complaint only, I have stated that on 28/8, 5 lakhs was transferred. And the Galia is honors a member of the company only, my lord.
Total 1.2.
ಗೆಳೆಯನಾದ ಬಸಪ್ಪ
ಪರವಾಗಿಲ್ಲ.
ಅಕೌಂಟ್ ಇಂದ 5 lakhs ಬಂದಿದೆ.
ನಿಮಗೆ ಬಂದಿದೆ ಅಲ್ವಾ?
ಪರವಾಗಿಲ್ಲ. And 9 lakhs rupees has been given to same member. ಅದೇ ಸೊಸೈಟಿ ಮತ್ತೊಬ್ಬರು ಮೆಂಬರಿಗೆ ಹೋಗಿದೆ.
ಈಗ
ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಸಪರೇಟ್ ಅಗ್ರಿಮೆಂಟ್ ಸಹ ಇದೆ, my lord.
ಪಾಲಿ ಹೌಸ್ ಏನ್ ಮಾಡಿದ್ರಿ?
That is my lord, their own, they have invested in the same neighboring village. They invested around 18 lakhs. And when this company, that is
have you taken money?
1,80 lakhs has.
Have you taken money from these people?
No, my lord.
Why?
That is actually, my lord, here only
Who has taken
42
money?
lakhs. Only with regard to 42 lakhs rupees.
Now 5 lakhs lien will be marked. Yes. ಅದು ಮೈನಸ್ ಅಲ್ಲಿ ಇದ್ರೂ ಪರವಾಗಿಲ್ಲ, ಹೆಂಗ್ ಬರುತ್ತೆ ಅವಾಗ ಲೀನ್ ಮಾರ್ಕ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ. The petitioner is before this court seeking defreezement of the account that is frozen on account of idyavadu Kalburgi bench. I've considered on account of certain crimes being registered against the petitioner. Against this petitioner, the allegation is that there is a transfer of 5 lakhs for construction of a poly house. The learned counsel for the petitioner would submit that the amount is not received from the hands of the complainant, but his friend. Be that as it may, since the freezement of the account of the petitioner would cause hindrance to the transactions and to the property of the petitioner, as the account held is akin to a property held. Therefore, I deem it appropriate to direct marking of a lien of 5 lakhs that has come into the account of the petitioner and permit defreezement of the account for it to become operational as usual. Yes. Operational in the normal way. Yes. And delivery. Ideyake ಬರುತ್ತೆ ಬಿಡಿ. Yes. Next. Or register to print the name of so and so anta.
Petition.
Yes, fine.
Petition can be disposed of. That's
I will, all right.
other prayers are saying that police should not arrest him, harass him, and other things. Main prayer is
Will dispose it or what?
Yes, my lord, here,
ಮತ್ತೆ ಈಗ argument as let it come. Yes, next.
my lord, based on one small complaint, 2 crore, ಅದರಲ್ಲಿ 42 lakhs ಮಾತ್ರ ಬ್ಯಾಂಕ್ ಟ್ರಾನ್ಸ್ಫರ್ ಅಂತ
That's all right, sir.
2
Yes.
crore 52 lakhs ಲೀನ್ ಮಾಡ್ತಾರೆ.
No, no. Yes, next.
45.
45, I'm requesting for passover, my lord.
45 are requesting passover.
My senior has to.
Passed over by 1 week, 20th. Yes.
Kindly, my
next.
lord. My lord, at
In
2:30.
7A alva?
Please, my lord. I'm requesting for interim order, my
No,
lord.
7A, 20th. Yes.
My lord, I'll take one chance, my lord, in the afternoon.
20th.
In the
You can
afternoon.
take a chance. Yes. 46 to 7A.
Illa, my lord. Matter pertains to disproportionate asset, my lord.
13.
Please.
Yes, sir.
The alleged properties,
20th. Yes.
my lord, there is a threat of suspension, my lord. Your lordships have granted interim order in similar circumstances. The alleged properties,
ನೆನ್ನೆ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಕೇಸಲ್ಲಿ ಅವ್ರು ಮಾಡಿದ್ವಲ್ಲ.
alleged properties
No
are
coercive. The list on 20th, no coercive or precipitative action. will be
Annexure
taken.
J, my lord, in
No.
similar circumstances, my lord.
Service matter mail ಮಾಡಬೇಡಿ ಅಲ್ಲ. No coercive or precipitative action shall be taken against these parties. ನೆನ್ನೆ ಮಾಡಿರೋದು ಅದೇ ಅಷ್ಟೇ.
Annexure J, my lord, kindly see.
Indirect ಆಗಿ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಸ್ಟೇ ಕೇಳ್ದಂಗೆ ಕೇಳಬೇಡಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Please.
ಎಸ್ ಸರೌಂಡ್.
Okay, for the petitioner. Now, the third respondent entertains a complaint from the fifth respondent on the allegation that he had deposited a sum of rupees 3,05,000 in a link which is forwarded by his brother, and the company has not refunded the amount. Not what this investigating officer does is he freezes the bank account of 116 persons and liens not 3 lakhs in every account, 116 accounts.
We'll see. Yes. Learned additional SPP is directed to accept notice, secure the investigation papers and the role of this petitioner in the alleged episode of crime. By ಈಗ respondents ಯಾಕೆ ಮಾಡಿದ್ರಿ ಇವ್ರನ್ನೆಲ್ಲ?
Not sir, amounts are freezed. My bank accounts are freezed.
ಅವ್ರ respondents da?
ಹೌದು. From 6 and 7, we have the bank accounts. Petitioner number 2 is the wife of the first petitioner. She is also having a bank account. That account is also freezed.
Oh, Axis Bank. Yes. So get the papers. Petitioner to serve 2 sets of papers upon the learned additional SPP, 18th fresh matters. Next. 18th ಇಲ್ಲ 19th fresh matters.
ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದಾರೆ. He is the only employee. ಅವನೇನು ರೋಲೇ ಇಲ್ಲ.
ಕಸ್ಟಡಿ ಇರಕ್ಕೂ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ಗೆ ಏನ್ ಫ್ರೀಸ್ಮೆಂಟ್ಗೆ ಏನ್ ಸಂಬಂಧ?
ಅಲ್ಲ ಅದು ಇರ್ಲಿ ಮತ್ತೆ ಬಟ್ ಈಸ್
ಬೇಲ್ ತಗೊಳ್ಳಿ. ಸೆಕ್ಯೂರ್ ಬೇಲ್. ಎಸ್.
18th ಸಂದೇಶ 19th minutes.
19th fresh matters.
But I seek a week's time, Lord. We are happy for R2.
Entry order ಇದೆಯಾ?
Covered by decision, Eesanjenews court martial.
ಏನ್ ಸ್ಯಾಂಕ್ಷನ್ ನಾ?
ಅಲ್ಲ 498A.
It's between the colleague advocates, Lord.
Petitioner 1 and 2 is the husband and wife martial.
Today only I received the paper.
Today
Giant and I'll file.
ಇಲ್ವಾ? Learned Counsel appearing for the second respondent seeks a week's time.
My last one submission.
Seeks a week's time. List the matter on 20th.
My last one submission. Covered by decision ತಾವೇ ಮಾಡಿರ್ತಕ್ಕಂಥ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ಯಾಕಂದ್ರೆ ಅವ್ರ ಮದ್ವೆನೇ ಮಾಡ್ಕೊಂಡಿಲ್ಲ, ನಾನು ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
20th ನಾನೇ ಮಾಡ್ತೀನಿ. Yes. List the matter on 20th in the fresh matters list. Yes. Objections square the office the statement of objections be complied by then.
Interim order
Interim order subsisting shall continue till the disposal of the petition. Next.
49.
For petitioner in this matter, my lord, needful has been done.
Learned Counsel submits needful has been done, office to verify. Next.
Stay this.
Interim order subsisting shall continue. Next. Vacating stay, Siddharth.
Online transaction through bank only they have received the tune of 33 lakhs and order. And by suppressing material facts, These people have obtained the interim order of stay. My lord,
Yes.
there are
Interim
several
order by
complaints.
coordinate bench.
Coordinate bench.
Yes, sir.
My lord, there are several complaints registered by the IVO. That is the reason why from Kuvembinagar police station to CCB it has been transferred. Even this de facto complaint has been taken for granted by taking away money through bank transfer itself. In the guise of getting some help from the government and other things, these people have cheated. There are the
How much money, sir?
33 lakhs and odd, my lord.
ನಿಮ್ ದುಡ್ಡ?
ಹೌದು ನನ್ನ ಬ್ಯಾಂಕ್ ಇಂದ ಹೋಗಿರೋ ಸ್ವಾಮಿ.
ಬ್ಯಾಂಕ್ ಇಂದ ಹೋಗಿರೋದ?
ಹೌದು, ಬ್ಯಾಂಕ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್.
ಯಾರಿಗೆ ಹೋಗಿರೋದು?
ಅವ್ರಿಗೆ ಅಕ್ಯೂಸ್ಗಳಿಗೆ. The accused number 1 is absconding now. Till today he is not traceable.
Who is accused? You are accused number?
I am accused number 2 and 3, please.
Your account ಹೋಗಿದ್ಯಾ?
Yes. 2 is also recipient of the amount.
How much money has gone to his account?
My lord, that is a Nikita, that is A2 has received around 12,65,000 rupees.
Your account ಈಗ?
Your account is
one ನಿಮಿಷ. You have received that amount?
A3, my lord, the accused number 3, that's a daughter who was, my lord, at that point of time a student.
It's all right. Who has received the amount?
12 lakhs has come to the daughter's account. To the wife's account, my lord, accused
You
number.
You are the wife, is it?
Wife and daughter, my lord.
Wife and daughter.
Wife and daughter.
Right.
May I explain to you?
No explanation. Have you received the amount?
Amount is received to the account of accused number 3, that's a daughter.
All right.
My lord, she is according to them, my lord, 12,65,000 is received to her account.
All right.
Insofar as, my
Accused
lord,
number 1 ಯಾರು?
accused number husband. Lord,
Oh,
he is
family, yeah?
family.
All right.
Lord, he is gone absconding.
Yes, sir.
My lord, the issue,
ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇದ್ಬಿಟ್ರೆ ನಾನು
Yes, please.
Yes.
Lord, the issue, my lord, is that
ನೀವು ವಾಪಸ್ ಕೊಡ್ತೀರಾ ಇಲ್ಲ?
Lord, my sub,
Are you returning the amount or not?
Lord, my only sub,
Not family cannot indulge in all this.
Lord, may I not make submission, Lord, I produced several documents. Lord, I have milk.
To show what?
Lord, the problem is not the father, my lord, has taken money. Lord, he's absconded, he's gone away, deserted me. I have, my lord, filed proceedings against him. The matters are pending. And what he, my lord, modus is,
Let the trial go on.
Lord, insofar as these people, Lord, women, Lord, concerned, Lord,
What account ದುಡ್ಡು ಬಂದಿಲ್ವಾ?
only insofar as the daughter is concerned.
Give it back.
And she, Lord, she was a student, Lord. at
Give
point of
it
time.
back, sir.
She was
You have
about-
received amount.
about 18
Don't
years.
project this woman and daughter in a cheating case. You have received the amount. Daughter has received the amount.
What is account? It is
Return it.
Lord, what is mentioned in, my lord,
You forget about the husband. You return the amount.
Lord, what is they have taken, my lord, 33 odd lakhs, my lord. 12 lakhs is what has come to their account.
Sir, 12 lakhs daughter account ಬಂದಿದ್ಯಾ ಇಲ್ಲ?
Lord, I will make, my lord, may request, my lord, to the client.
Give it back.
And may post it, my lord, next week sometime, Lord.
I'll post
So
it
that-
next week.
that
You
portion
first
of-
you give that back, then I will consider.
Lord, that particular portion, my lord, I will, my lord, seek instructions. Kindly post next
Give
week,
it
any day,
back.
my lord.
Yes. ಒಂದ್
Because
ಸ್ವಲ್ಪ ಸ್ವಲ್ಪ ಬರ್ಲಿ. ಇರಿ.
ಏನಾಗಿದೆ ಅಂದ್ರೆ that's, my lord, I will not, that I will not pursue. What's happened, my lord, he is gone up. So he's promised many people and several people, my lord, have
I am not
contacted me.
worried about the person who is gone absconding.
Please.
You or your daughter has received, student or whatever you're trying to project, has received 12.5 lakhs.
That is, my lord,
ಹೌದಾ?
ಅದೇನಾಗಿದೆ, he has, my lord, misused her account also. I have not given
Don't
stop payment
project
check
all
and-
this. Otherwise, I will permit trial to go on.
I understand, my lord.
12.5 lakhs next week ಅಷ್ಟೊಂದು ಬಂದ್ರೆ okay.
And I will not persuade
Yes.
my client to not on that pass.
This
Next
is
week,
not.
any date may kindly be fixed.
Ah,
my lord.
20th, sir.
Please.
Or better, I'll post it on 24th. List on 24th in the fresh matters list. The learned counsel for the petitioner, learned counsel for the complainant would submit that the accused number 3, the daughter, has received 12,65,000. The accused number 3 is not the petitioner in the case at hand.
Lord, accused number, she also petitioned.
Idara? Okay, all right. 3 received so and so saku. Received. The projection by the mother and the daughter is that the father has hoodwinked several people and is now absconding. But the fact remains that 12,65,000 is received to the account of the accused number 3. Therefore, the counsel to seek instructions with regard to when the amount of 12,65,000 which is alleged, which is in the account of this accused number 3 would be returned to the complainant. List on 24th in the fresh matters list.
Then, my lord, interim order may until then.
Interim order subject to the aforesaid condition shall continue to the next date of hearing. Yes.
51.
End Latif.
Lord, I'll report the settlement in the next week.
20th, 2:30 PM to report settlement. Yes, next.
52.
Furnishing of PF to R2. Order, Kudiman. Not complied, why waiting?
My lordship, please permit to R to delete it.
No, why have you not paid process?
My lordship, decreased R2 illa my lordship idರಲ್ಲಿ. They may
ಅದೇ
not
R
made the
ಆಗಿದೆ.
complaint as party.
Delete ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ my lordship, ಇವತ್ತು ಮಾಡ್ತೀನಿ my lordship.
I'll vacate the entry order now.
Please,
Yes.
permission.
Needful, ಈಗ ಮಾಡಿ. Delete it right away. Yes. What do you have? Entry order stands extended till the next date of hearing. Delete it now. Yes.
53.
In terms of
4.
For the petition, 53, my lords, 53, my lords.
50?
53, my lords.
You want to argue the matter?
No, my lords. I want to make a small submission, my lord.
I have withdrawn, sir.
Yes, yes, my lord.
Disposed as withdrawn.
Yes,
In
my
terms of
lords.
the memo.
My lords.
You want to make
Withdrawn,
submission in that?
Nothing, my lords. I wanted to say that.
Reserve it for a better case.
Much,
Yes.
much obliged, my
Huh?
lords.
And I appeal for the petitioner's counsel in seal number 54,
Huh?
wherein we are seeking further investigation. The matter is posted.
You are seeking 54
Yes,
further investigation.
yes. The office note is not relevant because my lord did not order notice for the other respondent. Maybe
Add
office
their
has
hands
posted
to the
that.
charge sheet. Yes, sir. Comment.
They want to convert into 302.
Huh? ಅದೇ 302 convert ಮಾಡ್ಬೇಕು ಅಂತ. It's not that easy to say convert into 302 unless I have
We
material.
are seeking 306. Sorry, we are not seeking 302.
What is the offense now?
The offense now is only the 324,
498 A, sir.
Oh, yes, ma'am. 498.
You are, who are you?
I am the deceased father. She has written a diary at page number 169, my feelings and my story, which is running into 66 pages. The investigation officer, in spite of offering this, did not take at all.
ಇದನ್ನೇ ಕೇಳಿದ್ ನಾನು last time. Who is the IO? Yes, sir. ಇದು ಕೊಡ್ಲಿಲ್ವಾ ನಿಮಗೆ?
Page number 48.
I have made specific.
Page one,
Page number 48.
48 of what, sir?
Complainant further statement. What
Of
the,
charge sheet.
48 of the charge sheet, ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಎಷ್ಟು ಪೇಜ್ ಇಲ್ಲಿ ಹೇಳಿ.
48.
No, what is alleged is 498A and 304B.
Charge sheet is filed for that.
ಅದಕ್ಕೂ ಅದೇ punishment.
Ignoring 306. Abatement
ಅದಕ್ಕೂ
of
ಅದೇ
suicide.
punishment.
My lord, kindly appreciate abatement of suicide, wherein the material, the father went to the police station. In fact, he reported the matter to the higher ups also by writing a letter, which I have.
ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಹೇಳಿದಿರಾ ಇದ್ರ ಬಗ್ಗೆ?
Yes, ma'am.
ಡೈರಿ ಬಗ್ಗೆ ಹೇಳಿದಿರಾ?
Yes, madam.
ಎಲ್ಲಿದೆ?
Yes, ma'am.
Show me one document.
Yes. Put the representation copy. Representation copy. 335, page number 335. 335 in the review. How did it? Page number 335, yes, ma'am. I'm looking at diary. What do you?
Date ಏನಿದು?
This is.
What is the date of the incident, date of filing of the charge sheet?
Yes. The date of the incident, charge sheet was filed on 28/4/2023.
28/4/23.
28/4/2023.
All right, this letter is the 3/10/23.
Yes, my lord, that is.
No, show me something, some communication that is prior to 28/4/23.
The prior to 28/4/2023, in fact, I visited the police station.
You visited ಅಲ್ಲ, ಏನಾರ ಒಂದು letter saying that this diary ಇರೋದಕ್ಕೆ ಎಲ್ಲಿದೆ? Proof. You may have produced it. You have given it to the IO ಅಂತ ಎಲ್ಲಿದೆ?
My lord, he refused to take it. In fact, if he files an affidavit, if he files an affidavit, I will be able to counter.
Who will file an
the
affidavit?
risk of perjury if the IO were to file an affidavit that nothing was offered to me. In fact, he
is here, sir, saying before the court.
My lord, saying that it was not, my lord, it is a case for rising out of an illicit relationship, an influential person.
Ask him.
Even this report, my lord, even this letter, in this letter, they are not saying that they have made a representation in the earlier.
ಎಲ್ಲಿದೆ?
335.
Communication ಕೊಡಿ sir.
335 at page number 335.
Yes.
I write to request for fair and proper investigation to the Commissioner of Police.
All right.
And I go on narrating the events.
All right.
And then at para 11, at para 9 is relevant. The investigation officer has not summoned and recorded the statement of Raju, who is the husband of Srimati Kalavati, who knew about the illicit relationship which his wife Srimati Kalavati had with Guru Prasad, and took suitable measures to prevent Guru Prasad from indulging in immoral and illegal activity affecting the interest of both the families. His statement is just and necessary to show and establish the guilt of the accused, number one. In the aforesaid circumstances, it is very clear that the investigation officer has not been, done in a fair, proper and unbiased manner.
Why did you not say that there are story written or diary that is
Para
there?
6. The said illicit relationship gets established by the diary maintained by Srimati Madhuri, which even though tendered
Yes,
to the
sir.
My lord, the issue is, my lord, that there is no representation given in the past. It is only post.
Post ಗೊತ್ತಾಯ್ತು. ಮುಂಚೆ, where is your statement recorded?
as per the charge sheet. my lord.
In your statement, have you said you have a diary?
Yes, my lord.
ಹೇಳಿದೆ ಕೊಡಿ. ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಿ, will pass some order.
My lord, that statement was recorded by the police as per their liking.
Don't
Police-
tell me all
May-
this.
Here is-
Diary ಇದೆ ಅಂತ ಎಲ್ಲಾದ್ರೂ ಹೇಳಿದೀರಾ?
My lord, that could be that question. Because the statement of in a charge sheet, all statements.
Do you have
are
the
recorded.
specimen handwriting of the deceased?
No, they didn't do that investigation. in
We
that
can,
regard.
even now we can send it, my lord.
That is why you have the specimen handwriting of the
We
deceased.
have to provide.
In fact, the deceased has given a complaint to have the specimen handwriting.
Give that, sir. Where is it?
Complaint.
Produce it, send it to FSL and get to know the.
May I just draw my lord's attention to
Let
the
them hand over the original, we will send it.
Original of what?
Diary, my lord. Annexure C.
I
FSL.
am ready to hand over the diary. I am.
Do it, sir.
Yes. They summon me or I can hand over in the what if they
Send
summon
it,
me, I am-
send it to FSL.
We'll send it.
The
Sending it.
the petition is preferred on the score that there is a shoddy investigation by the investigating officer who has filed a charge sheet only for offense punishable under section 498A, 304B read with 34 and 4 of the Dowry Prohibition Act, of the IPC and Dowry Prohibition Act. The learned senior counsel B.V. Shankarnarayan Rao would take this court through the documents appended to the petition with particular reference to a diary alleged to have been scribed by the deceased. The same is not a part of the charge sheet. The learned senior counsel would submit that the investigating officer has refused to take it as a material at the time of investigation, though none of the statements of the petitioner would refer to a diary, but a subsequent communication on 3/10/2023 would make reference to the
May I
said
just
diary.
interrupt for a minute, my lord. My sincere apologies. Statement is at page number 89 of Chandra.
ಅದರಲ್ಲಿದೆಯಾ?
Yes.
All right. Though ಅಂತ ನಾನು ತೆಗಿತೇನೆ.
Fact.
ನೋಡು.
It
Therefore, the petitioner shall hand over.
It refers to a
One minute.
statement which Madhuri gave in the hospital.
I don't know who is it. Wait. The petitioner shall hand over the diary to the hands of the investigating officer, who shall forthwith after receipt of the diary, send the same to the FSL for to the handwriting expert along with the specimen signature or the writing of the deceased.
May I make one submission? I'm not resting my case not only on the diary, even mobile phones were not seized.
ಅದ್ ಮಾಡ ಫಸ್ಟ್ ಒಂದೊಂದಾಗ ಮಾಡ.
Yes.
Even let them hand over that all.
Because
Send it, sir.
It will be a part of further
ಎಲ್ಲಿ
investigation.
ಮೊಬೈಲ್ ಫೋನ್ ಎಲ್ಲಿದೆ?
ಇಲ್ಲ ಅವ್ರಿಗೆ ಏನು ಮಾಡ್ಲಿಲ್ಲ ನಾವು
ಕೊಡಿ
ಅಲ್ಲ ನಾವು ಕೊಡ್ಲಿಕ್ಕೆ ಹೋದಾಗ ರಿಪೀಟೆಡ್ ಆಗಿ ಕೊಡ್ಲಿಕ್ಕೆ
ಕೊಡಿ ಸರ್ ಈಗ. Give it now. The learned counsel would
further investigation.
wait, sir. The learned counsel would further submit that the mobile phones were also not taken by the investigating officer. Those also shall be handed over to the investigating officer, who shall submit the FSL who shall send it to the FSL, and the FSL shall report the same back to this court through the additional SPP within 4 weeks. No. Within 4 weeks. Otherwise, I will order further investigation by somebody else.
Further investigation would be a better.
Why?
For the reason that there is so much of incriminating material. Raju's statement is not recorded. If I go on, I will be giving a list. Kalavati with.
Adhika, I told you to prepare a list and give what. See, if you want further investigation for the asking, it cannot be
No,
done.
it cannot be. I have made out
So,
a prima facie.
you should give me the list of lacunae
Yes,
That is in the investigation, which according to you is shoddy.
Yes, ma'am. I
Ah,
can
ಇಲ್ಲಿ
provide that.
ಕೊಡಿ.
I can provide that.
No, then ಏನು ಬೇಡ, let him give it.
My lord, open further investigation would be a better approach for the reason
You
that.
first produce that, sir.
My lord, I have produced the diary.
Give me the list of lacunae that you are seeking to project.
Yes, my lord.
Without that, I will not pass any order for further investigation.
Yes.
ಯಾವಾಗ?
Friday or Monday, whatever, Tuesday.
Give
whatever
it
my
on
lord
Tuesday.
said. Or if they agree for open further investigation, it would.
They need not agree, sir. If you give the material, if it is to be given, we will give it further investigation.
Because Raju, who is the
Because ಬೇಡ, first ಅದು ಕೊಟ್ಬಿಡಿ. ಆಮೇಲೆ ಕೊಟ್ಮೇಲೆ we will see.
Tuesday.
Yes.
That office note may be overruled. because
Wednesday
every
in fresh
time-
matters list, yes.
65.
He need not be present.
Yeah.
Yes. Yes, Abraham, what is this?
Objection raised yesterday. But I'll
Respondent ಅಲ್ವಾ? ಈ ಕಡೆ ಬನ್ನಿ.
filing the objection to the petition. Lord, in spite of the order, Lord,
Oh.
he is not cooperating the investigation.
Abraham is the complainant.
Please, I am the complainant.
Please,
Reason.
Your Lordship may kindly grant a short date.
Lord, there is an order.
You applied before the committee?
Yes, you are.
Committee has granted permission?
No, Your Lordship.
It's pending.
They called me day first day and told me my Form A is not.
All right,
Not
then
raised.
we will hear you after the,
2 days. I'll
no
do that.
problem, yes.
On
Lord,
25th
there
or
is an order.
24th,
Wait.
there is an order to cooperate to the investigation, that the petitioner is not cooperating the investigation.
Yes, sir, why?
Your Lordship, I personally am not aware of the
You
non.
need not be aware personally. But this is the allegation.
Lordship, I'll seek instructions regarding that.
The learned counsel representing, the learned counsel B. Latif representing the Lokayukta has alleges that the petitioner is not cooperating with the investigation. The 13(1),
Please.
as a disproportionate.
Your Lordship, a lot of offences have been alleged.
No, all right, disproportionate asset.
Please.
Then the BDA official.
BD office.
Oh, yes, sir.
Including the offence of PMLA, which falls under the PMLA Act, had also been alleged. The matter has been referred for investigation by the Lokayukta court, despite not having the jurisdiction as well. Also, section 17A approval is not there.
ಬೇಕಾಗೇ ಇಲ್ಲ ಇದಕ್ಕೆ. If it is amassing wealth disproportionate to the known source of income, 17A need not be followed.
In fact, 17.
TV Ashok, I have myself held that except in disproportionate asset cases, 17A is mandatory.
Your Lordship, disproportionate asset is not the only offence alleged, Your Lordship.
If it is amassing wealth disproportionate, no 17A.
Your Lordship, then section 17 sanction. So section 17.
Sanction?
No. The second proviso to section 17 has also been has not been complied with.
Application of mind while registering the crime.
Please, Your Lordship.
We'll see, we'll answer all that. Yes. Objections ಹಾಕಿದ್ದೀರಾ?
I'm filing the objection.
File. ಈಗ ಬರ್ಕೊಳ್ಳಿ.
Him cooperate the
1 minute.
investigation.
The learned counsel appearing for the learned counsel B. Latif submits that the petitioner is not cooperating with the investigation. The learned counsel of the petitioner seeks to project certain statutory aberrations in the case at hand, all of which would be considered on the next date. The petitioner shall cooperate with the investigation during the pendency of the petition. Interim order ilvalla? ಮತ್ತೆ ಯಾಕೆ cooperation?
Not to file the charge sheet, that was an order.
ಇಲ್ಲ,
Not
that
the
order
last
also
date
not
also,
filed.
Lordship,
No,
I
that is
directed
very
them to cooperate the investigation.
Oh, correctly ಬರ್ದಿದ್ದು ಮಾಡಿ.
In spite of that order.
So and so. In the event the petitioner would not cooperate with the investigation, the order dated 8/8/2024 would stand vacated. Cooperate with the investigation. That this order is passed, as I have passed orders in every case. I don't think this case deserves that order even. We'll see. Yes. The case officer.
Case officer, Your Lordship.
Yes. List on, by then your form C, you correct it.
Yes.
List on, what date? 24th in the fresh matters list. Yes.
56.
Steps already taken.
Counsel for the petitioner submits needful has been done, office to verify.
Interim protection.
Interim order / protection, if any, shall continue till the next date of hearing. We'll continue at 2:30. Yes.
Submission में था. Submission में. Serial number 119.
Adjournment ಬೇಕಾದ್ರೆ court of session.
Parties has
Settlement ಎಲ್ಲ ಮಧ್ಯಾಹ್ನ.
Yesterday's matter is law. It is settled.
Settle ಆಗಿದೆಯಾ?
ಈಗ ಒಂದು
ತಗೊಳ್ಳಿ. Settlement ಎಲ್ಲ ತಗೊಳ್ಳಿ ಮೇಡಮ್.
4 ಗಂಟೆಗೆ.
ಸೆಟಲ್ಮೆಂಟ್ ಯಾವ್ದು ತಗೊಂತಾರೆ ತಗೊಳ್ಳಿ, ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಯಾವ್ದು ತಗೊಂಡು ಕೊಟ್ಬಿಡಿ, ಕಂಪ್ಲೈನ್ಸ್ ಇದ್ರೆ ಮಾಡಿ.
ನಿನ್ನೆ ಇತ್ತು
serial number
The approval being granted would be for the purpose of conduct of inquiry. And if the preliminary inquiry would pin down these petitioners, appropriate action be taken by the Lokaayukta at a later point in time. If the complainant is guilty of impersonation, the complainant also be proceeded against in accordance with law. For the aforesaid reasons, the following order. The petitions are allowed. The crime number 17 of 2024 stands obliterated. The liberty is reserved to the Lokaayukta to seek approval from the hands of the competent authority and proceed further, bearing in mind the observations made in the course of the order. Ordered accordingly. Yes. Huh? ಅದನ್ನ ಹೇಳ, inquiry or investigation, all three circumstances. Next.
Lord, this is a case for not arising out of an agreement. I had given by way of separate memos, Lord, for the
Interim order ಕೊಟ್ಟಿದೀವಲ್ಲ?
ಇದೆ.
ಸರಿ. ಕೊಡಿ. Tag this petition along with heard the learned counsel Nitin Ramesh appearing for the petitioner. FR number. I will not connect FR numbers. Correct. 82 and 185 and 82.
190.
190, sorry.
82 becomes 185.
190. ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಾ?
ಅಲ್ಲ, ಅದು ಇನ್ನು FR ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಹಾಗಾದ್ರೆ ವಿಲ್ ಪರ್ಮಿಟ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಇನ್ ದಟ್ ಕೇಸ್.
ಅಲ್ಲ, ಅದರಲ್ಲಿ may I read that, my lord? It's a check bounce case. If it's a check bounce case, clearly they're saying I'm providing the compilation.
Why don't you comply with the office objection?
My lord, we'll move it, my lord.
You have just kept it.
My lord, may I say what happened?
Yes.
They instigate another complainant in Kerala and file a POXO case against all this against this petitioner.
ಯಾವ್ದ್ರಲ್ಲಿದೆ POXO?
ಅಲ್ಲಿ ಕೇರಳ ಕೋರ್ಟಲ್ಲಿ ಪಾಕ್ಸೋನು ಹಾಕಿದ್ದಾರೆ ಇದಾದ ನಂತರ.
ಅದು ಅಲ್ಲಿ ನಡೀತಾ ಇದೆ.
ಅಲ್ಲ, ಅವನು ಬೇಲ್ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಅಲ್ಲಿ ಇದ್ದ. That is the reason why we were not able to get proper instructions in that. In urgency we had filed it. We will move it, my lords. We will get the FIR cleared and we will.
No, I will direct the matter to be listed along with that.
Please.
And if objections are not complied, interim order will get vacated.
Please.
Yes.
Very well.
The counsel for the CBI complainant. The counsel for the complainant would submit that crime number 19 ಇದು Nitin Ramesh sir, ಇದು 190 185 ಇದು.
ಇದು 185.
The crime number 190 of 2024 is also called in question in FR number 8312 criminal petition ಅಂತಾನೆ ಇದೆ, filing number so and so 12 of 2024, and the matter has been kept without complying with the office objections.
The learned counsel for the petitioner would refute the said submission, contending that they would immediately comply with the office objections. List the matter on Wednesday in the fresh matters list along with the said so and so 8312. Yes, interim order subsisting shall continue till the next date of hearing.
My lord, 19th, my lords.
19th, all right.
19th.
20th.
20th. Very well.
20th afternoon.
20th. Can be passed over. Great.
Seventeen and 80 of KP Act, my lords.
KP Act.
Yes, my lords. Without, my lord, permission, they conducted raid and seized the income, seized the articles and arrested the petitioners. Thereafterwards, my lord, sought permission from the jurisdiction magistrate.
Yes, sir. Correct, Ado.
And produced the.
Subsequent or
Section A is the, my lord, NCR.
look into it. List on 26th, there shall be an interim order of stay of further proceedings, quay the petitioner to the next date of hearing.
Stay is
Idi
there.
already.
Stay is there.
Interim, list after 2 weeks, interim order granted earlier stands extended to the next date of hearing.
70.
No passover, no adjournment. Last time also. Maybe, yes. No. Senior counsel should be present when the matter is listed. We will not grant time for the purpose of senior counsel to come. Passover, that's fine. Yes. Next.
18.
Lord. Suicide.
Huh?
He's already placed.
Yes, sir.
Lord, the complaint, my lord. Kindly come to page 19.
Your accused
Sorry,
number?
sir, 16. Accused number 6, my lord. Totally 13 accused are there. Against all
He
the
is
allegations.
one of those persons who demanded his money back. Suicide.
There was just a demand of money.
Demand of
But
money, yes.
Allegation is not against any specific person. Allegation is general allegation, all 13.
The petitioner is before this court calling in question registration of a crime in crime number 90 of 2024. The crime is registered for offense punishable under section 149 and 306 of the IPC. The learned additional SPP has produced the entire papers of investigation for a perusal of the court. Perusal of which would indicate that the petitioner had in cricket betting guide.
ಅಲ್ಲ IPL betting ಅಂತ ಅದಕ್ಕೆ ಅವ್ರು ಸಾಲ ತಗೊಂಡಿದ್ರು ಅಂತ.
It would indicate that the deceased son of the complainant.
ಅಲ್ಲ. Deceased is the wife of the person who has indulged in betting. He had borrowed loan from the all this.
All right. They had borrowed money from several. Don't disturb. Perusal of which would indicate that the son-in-law,
son-in-law had
son-in-law of the complainant had borrowed monies from the market for the purpose of investing it into IPL betting. The persons who had lent money started demanding the money back. It is then the wife of the daughter of the complainant, commits suicide. The allegation is abetment is attributed to the accused several petitioners, including accused number 6. The investigation papers would not reveal anything further than what is narrated here in above. In that light, permitting further investigation, this petitioner would run foul of the judgment of the apex court in the case of Kanchan Sharma versus State of. File ಆಗಿದೆಯಾ? ಎಲ್ಲಿದೆ?
ಇಲ್ಲ ಆಗಿಲ್ಲ.
ಚಾರ್ಜ್ ಶೀಟ್ ಏನಾದ್ರು? It's all right. So Kanchan Sharma was ಇನ್ನೂ ಒಳ್ಳೇದು. Kanchan Sharma versus State of Uttar Pradesh, reported in 2021 SEC online SC page 737. Therefore, there shall be an interim order of stay of further proceedings, quay this petition to the next date of hearing. Now all five will come to you. Yes.
19.
ನೆನ್ನೆದಲ್ಲ ಸುನಿಲ್ ಗವಾಸ್ಕರ್. ಎಸ್ ಮೇಡಮ್, ಇಂಟರ್ ಆರ್ಡರ್ ಇದೆ. ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಎಸ್ ಸರ್, ಹೇಳಿ.
Mother filed a DV case against the son.
Mother filed a domestic violence case. Against the son.
But kindly see the para 1 and 2.
Para 1 and
2. Facts of the case.
Complaint the end.
Complaint. At ink page, annexure E, ink page 30, the relevant para is 31.
Yes, sir.
The petitioner has married one Narayan Reddy on 19/11/82 at Narsitirtha Mantapa, Mulva.
ಏನ್ ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ?
ಸಮಯ
ಏನ್ ಕೇಸ್ ಹಾಕಿ? ಮೇಂಟೆನೆನ್ಸ್
ಅಲ್ಲ,
ಮತ್ತೆ ಏನ್ ಕೇಸ್?
as per their own statement.
Okay, what is the case that the mother has filed against the son?
Son, Domestic Violence Act.
What are the legal grounds?
As per their own pleading, clearly states that the petitioner is staying at K.R.Puram.
So what?
The petitioner is staying at Mulbagi. The respondent is number 1 is the son of the petitioner, and Srimati Deepa, Mamata and Kumari Asha are the daughters of petitioner, and Deepa and Mamata are married and are residing with their husbands and the matrimonial homes. Kumari Asha is residing at Bangalore, working as an engineer. Next, madam. The respondent herein has completed the MA graduation, post-graduation in MA from Bangalore University, and the petitioner and her husband has taken care of all educational expenses of the respondent number 1. He got a job Revenue Department at Parandalli Gram Panchayat, and he is working as a secretary and earning more than 35,000 month. Further, the respondent has married one Srimati Nandini, who is the respondent number 2 herein. Marriage held at KVR Chowdhury.
Prayer ಏನ್ ಓದಿ ಸರ್? ಏನ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಲ್ಲ, ಪ್ರೇಯರ್ ಏನ್ ಓದಿ?
Prayer.
Ilder I will hear the respondent.
Prayer. Wherefore the most respectfully praise that this honorable court may be pleased to grant a relief as claimed herein and pass such other orders as this honorable court deems fit and proper to given circumstances the case of the protection the aggrieved persons from domestic violence in the interest of justice and equity relieves the committing any act of domestic violence, aiding or abetting the.
ಆಯ್ತು, ನೋಡ್ದೆ ಬಿಡಿ ನಾನು.
ಸಮಯ
ನಾನು ನೋಡ್ದೆ. Wait. Yes, sir.
They will forcefully obtain a big deal from the respondent.
You should have gone before the assistant commissioner. Wait, sir.
What he does is, he will tell the respondent to gift the property which she is residing right now in the present scheduled property. What he does is, once they deny to execute gift deed with respect to the shared household part, he tries to dispose the respondent from the property.
Then you approach the court.
Whatever.
ಈಗ ಮೇಂಟೆನೆನ್ಸ್ ಅವಾರ್ಡ್ ಮಾಡಿದಾರಾ? What shared household? Anything else, sir? You are the son. You are a son.
Yes.
Take care of your mother.
That's what I am paying every month.
This is I will dismiss the petition with costs.
No. Because.
No, illa. If son cannot take care of the mother, who else? Yes.
No, my lad. 1 second on the video ತೋರಿಸ್ಬಿಡ್ತೀನಿ. They don't want to come the daughter-in-law into the house. When daughter-in-law gone out of the house, they were visited to the house.
Register a separate crime, sir.
ಅಲ್ಲ ಯಾವ್ದಾರ ಹಬ್ಬಗಳಿಗೆ ಊರಿಗೆ ಹೋದ್ರೆ ಸೊಸೆ ಮನೆ ಹೊರಗಡೆ ಬರಬಾರ್ದು ಅಂತ, ಸೊಸೆ ಹೊರಗಡೆ ಹೋದ್ರೆ ಗೇಟ್ ಬೀಗ ಹಾಕ್ತಾ ಇದ್ದಾರೆ. ದಟ್ ಈಸ್ ದ
What is this ಕ್ಯೂಂಕಿ ಸಾಸ್ ಬಿ ಕಭಿ ಬಹುತ್?
ಒಂದು 2 ಸೆಕೆಂಡ್ ವಿಡಿಯೋ ನೋಡಿದ್ರೆ ತಮಗೆ ಗೊತ್ತಾಗುತ್ತೆ ಸ್ವಾಮಿ.
ವಿಡಿಯೋ ನೋಡೋದು ಬೇಡ.
ಅಲ್ಲ ಏನೆಲ್ಲ ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಇದೆಯೋ, 1 ಸೆಕೆಂಡ್, ಏನೆಲ್ಲ ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಇದೆಯೋ ಅದನ್ನೆಲ್ಲ ದೇ ಮೇಕ್ ಯೂಸ್ ಆಫ್ ಇಟ್.
That is presumed to be true. She would have approached the police and she would have filed a complaint alleging that this is the incident. Until this case is being filed, there was no certain allegation at all. Ega, there is nothing that you have challenged here. There is no order passed by the concerned court. You have challenged the entire proceeding. All right. I am not going to.
My wife also filed a case against the complainant and it is also passed the orders.
ಈಗ 1 minute. ಡಾಟರ್ ಇನ್ ಲಾ, ಮದರ್ ಇನ್ ಲಾ ಕೂತ್ಕೊಂಡು ಸೆಟಲ್ ಮಾಡ್ತೀರಾ ಅಥವಾ ಆಗದೇ ಇಲ್ವಾ?
ಅಲ್ಲ ಆಗುತ್ತೆ.
ಏನಾಗುತ್ತೆ?
One of the daughter is a advocate. She make use of all the law against the brother. ತಂಗಿ ಹೆಸರಲ್ಲಿ ಒಂದು ಡೊಮೆಸ್ಟಿಕ್ ಅಲಯನ್ಸ್, ಅಪ್ಪನ ಹೆಸರಲ್ಲಿ ಒಂದು ಸೀನಿಯರ್ ಸಿಟಿಜನ್. She is the only the.
Sit across. You are all in the same family. Don't fight.
Yes. They
don't fight and close everything.
Advocate. She make use of all the provision of law against the brother.
Correct.
ತಂಗಿ ಹೆಸರಲ್ಲಿ ಒಂದು ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಆಕ್ಟ್, ಅಪ್ಪನ ಹೆಸರಲ್ಲಿ ಸೀನಿಯರ್ ಸಿಟಿಜನ್ಶಿಪ್ ಇದರಲ್ಲಿ ಬಿಫೋರ್ ದ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್.
ಅಷ್ಟೆಲ್ಲ ಯಾಕೆ ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಏನಾಗಲ್ಲ?
ನಾವು ಅಲ್ಲಿ ಊರಲ್ಲೇ ಇಲ್ಲ. ಆಸ್ ಫಾರ್ ದೇರ್ ಓನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಐ ಆಮ್ ರಿಸೈಡಿಂಗ್ ಇನ್ ಕೇರ್ಪುರಂ. ಯಾವತ್ತಾದ್ರೂ ಹಬ್ಬಕ್ಕೆ ಊರಿಗೆ ಹೋದ್ರೆ ಮನೆಗೆ ಸೊಸೆ ಮನೆಗೆ ಬರ್ಬೋದು ಬೀಗ ಆಗ್ತಾ ಇದಾರೆ.
ಅಲ್ಲ ಅವರೆಲ್ಲಿರೋದು?
ಅವ್ರು ಕೇರ್ಪುರಂ ಪಕ್ಕದಲ್ಲೇ. ಅಲ್ಲ ಇಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲೇ. ಅವ್ರಿರೋದು ಮುಲ್ಬಾಗ್ಲಲ್ಲಿ.
ತುಂಬಾ ದೂರ.
ಮುಲ್ಬಾಗ್ಲಲ್ಲಿ ಊರಲ್ಲಿ ಇರೋದು.
ಎಸ್ ಎಸ್.
ವಿಲೇಜ್ ಅಲ್ಲಿ.
ನಥಿಂಗ್. ಸಿಟ್ ಅಕ್ರಾಸ್ ಅಂಡ್ ಸೆಟಲ್ ಎವ್ರಿಥಿಂಗ್.
ಇನ್ನೊಂದು ಸಿಸ್ಟರ್ ಹೆಸರಲ್ಲಿ ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಆಕ್ಟ್ ಹಾಕಿದ್ದಾರೆ.
ರೆಡಿ ಒಂದು ನಿಮಿಷ. ನಾವು 1 minute. What do you want? What does the mother want? Tell me. All right. That is what you want. What do you want?
ನಾವ್ ಯಾವತ್ತಾದ್ರೂ ಹಬ್ಬಕ್ಕೆ ಊರಿಗೆ ಹೋದ್ರೆ ಮನೆಗೆ ಒಳಗಡೆ
ಹೋಗ್ಬೇಕು ಅಷ್ಟೇನಾ?
ಹಬ್ಬಕ್ಕೆ ಯಾವ್ದಾರ ವೀಕೆಂಡ್ ಅಲ್ಲಿ ಮನೆಗೆ ಹೋದ್ರೆ ಮನೆ ಒಳಗಡೆ ಬಿಡಲ್ಲ, ಗೇಟ್ ಬೀಗ ಹಾಕ್ತಾ ಇದ್ದಾರೆ ಸುಮ್ಮನೆ.
ಆಲ್ ರೈಟ್. ಒಂದ್ ನಿಮಿಷ, ಇನ್ಮೇಲೆ ಬೀಗ ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ. I'll take it after 14 days. All of you sit together and settle. ನೀವು ಬೀಗ ಹಾಕಿದ್ರೆ ಆಮೇಲೆ ನಾನು ಬೇರೆ ಇಲ್ಲ. ಬೀಗ ಹಾಕಕ್ಕ ಸೆಟಲ್ಮೆಂಟ್ ಟ್ರೈ ಮಾಡಿ.
ಅಲ್ಲ
ಯಾರು ಹೇಳ್ತಾ ಇದಾರೆ ಅಷ್ಟೇ. ಗೊತ್ತಾಯ್ತಲ್ಲ ಏನಂತ ಈಗ? ಇವ್ರು ಬರೀ ಹಬ್ಬಕ್ ಬರಕ್ ಕೇಳ್ತಾ ಇದಾರೆ ಅವಾಗಿಂದ. ನಿಮ್ಗೆ ಏನ್
ಮನೆ ಒಳಗಡೆ ಬಿಡಲ್ಲ, ಬೀಗ ಹಾಕ್ತಾ ಇದಾರೆ. ಅತ್ತೆ ಸೊಸೆ ಮನೆಗೆ ಬರಬಾರ್ದು.
ಗ್ರೀವೆನ್ಸ್ ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ
ಗ್ರೀವೆನ್ಸ್. ಅವ್ರೇನ್ ಕೇಳ್ತಾನೆ ಇಲ್ಲ ಬೇರೆ. ಮದರ್ ಇನ್ ಲಾ ಶುಡ್ ಅಲೋ ದಿ ಡಾಟರ್ ಇನ್ ಲಾ ಇನ್ಸೈಡ್ ದಿ ಹೌಸ್. ಅದಕ್ಕೆ ಡೋಂಟ್ ಪ್ಲೇ ದಿಸ್ ಕ್ಯೂಂಕಿ ಸಾಸ್ ಬಿ ಕಭಿ ಬಹುತಿ.
ಇದೆಲ್ಲದಕ್ಕೂ ಕಾರಣ ಒನ್ ಆಫ್ ದ ಡಾಕ್ಟರ್ ಇಸ್ ಎ ಅಡ್ವೊಕೇಟ್. ಶಿ ಇಸ್ make use of all the provisions against the brother.
Don't tell anything against advocates.
This is the documents.
Don't tell anything against advocates.
That is really the
obvious things ಹೇಳ್ಬೇಡಿ ಸರ್. ಎಸ್, ಈಗ ಅರ್ಥ ಆಯ್ತಾ? All right. Yes. List this matter on 25th. The parties, the squabbling petitioner and the respondent are mother and son. The allegation of the petitioner is that when the festivities happen, the daughter-in-law is not let into the house of the mother-in-law. The mother-in-law alleges that the son is insisting that he should part. That the mother-in-law mother should part with the property in which she is residing, which is disputed by the petitioner. The dispute appears to be on the periphery. Therefore, the parties to sit across and strike out a settlement to live peacefully ever after. Yes. Now the cat is out of the bag. Yes, sir. Gadari? What do you mean Gadari? Crowbar. Yes. ನೀವು ವಿಡಿಯೋ ಮಾಡಿಲ್ವಾ ಅದೆಲ್ಲ? ಆಲ್ ರೈಟ್. ನೀವೇನ್ ಕಮ್ಮಿ ಇಲ್ಲ, ಇವರು ಏನ್ ಕಮ್ಮಿ ಇಲ್ಲ.
ಎಲ್ಲರೂ ಎಜುಕೇಟೆಡ್. ಅಪ್ಪನ ಫಾದರ್ ಟೀಚರ್, ರಿಟೈರ್ಡ್ ಟೀಚರ್. ಈ ಮಕ್ಕಳೆಲ್ಲ ಡಬಲ್ ಡಿಗ್ರಿ ಗ್ರಾಜುಯೇಟ್ಸ್.
ಅದಕ್ಕೆ ಹಿಂಗ್ ಆಡ್ತಾ ಇರೋದು.
ಅದೇ.
ಎಸ್. ಸಿಟ್ ಅಕ್ರಾಸ್. ಡೋಂಟ್ ಕ್ಯಾರಿ ಯುವರ್ ಏನದು ಗಡಾರಿ.
ಅದೇ ಇಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಜಾಬ್ ಅಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲಿ ಇದಾರೆ, ಇಲ್ಲಿ ಗಡಾರಿ ತಗೊಂಡೋಗು. ವೀಕೆಂಡ್ ಅಲ್ಲಿ ಎಲ್ಲಾದ್ರೂ ತಂದೆ
ವೀಕೆಂಡ್ ಅಲ್ಲಿ ತಗೊಂಡ್ ಹೋಗ್ತೀರಾ?
ಅಲ್ಲೆಲ್ಲ ಮನೆಗೆ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ಮನೆಗೆ ಬಿಡ್ಲಿಲ್ಲ.
ಸುಮ್ನೆ ಹೋಗಿ ಡೋಂಟ್ ಕ್ಯಾರಿ ದಟ್ ಗಡಾರಿ.
ಹೆಂಡ್ತಿನ ಒಳಗಡೆ ಬಿಡಲ್ಲ ಅಂತಂದ್ರೆ
ಪ್ರಾಬ್ಲಮ್ ಅದು.
ಗೇಟ್
you must understand, he has to go back home. If you don't allow the daughter-in-law, he will not be allowed inside the house. Sit across and settle. Yes. Entry mode ಇದೆಯಲ್ಲ, ಇದೆ. Entry mode ಇದೆ ಅಂತ don't indulge in anything. Then I will see the video ಆಮೇಲೆ. Yes. Yes. Yes, sir. Next.
The petitioner has challenged the order passed under section 19. Direction, no, Lord, section 91.
91.
Please, Lord. Lord, the case of the prosecution, Lord, the complainant filed a complaint on 29/11/2021. The complaint allegation that the accused number 1 and 2 had been to the shop. Who is the
in a 7A proceeding?
Please,
who is the respondent? Government servant?
Yes, Lord.
All right. Yeah, trial start agidya.
The charge sheet is filed before, during the investigation, they filed an application for seeking information about the call details of the investigation officer.
91 right would spring to you only after the commencement of the trial. You can seek that document at the commencement once the trial commences. Mic use ಮಾಡಿ.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ 3 ವರ್ಷ ಮಾಡಿದ್ರೆ ಡಿಜಿಟಲ್ ಡಾಟಾ ಡಿಲೀಟ್ ಆಗಿರುತ್ತಲ್ಲ ಲಾರ್ಡ್ಶಿಪ್, ಕ್ಲೈಮ್ ಮಾಡಕ್ಕೆ ಹೇಗೆ ಸಾಧ್ಯ?
I will reserve liberty and direct conclusion of the trial within a time frame.
Yes, Lordship. But parties judgment ಅಲ್ಲಿ ಇರೋ restrictions ಬರೀ ಪ್ರೊಡಕ್ಷನ್ ಮಾತ್ರ, ನಾವು ಪ್ರಿಸರ್ವೇಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀವಿ Lordship.
No, not parties judgment. 2004 you're talking of. There's Nitya Dharmananda in 2018, which distinguishes parties judgment, saying that that right would flow only after Nitya Dharmananda. Would flow after the commencement of the trial. Will reserve your right, but that would run counter to, see, parties judgment went on a footing that if that was of a sterling quality, then yes, it can be produced in 482 also.
Yes.
So that would not inure to your benefit. Now, ಈಗ ಯಾವ ಸ್ಟೇಜ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ?
Charge sheet is filed.
3 ವರ್ಷ ಯಾಕೆ ತಗೊಂಡ್ರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ?
Lord, initially it was.
That is why I say you should put your house in order. ಏನ್ ACB ಇಂದ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಬೇಕಾಯ್ತಾ?
House.
ACB did nothing?
Lord, the initial trap and the sanction was pending for the obtaining sanction.
Sanction ಎಲ್ಲ ಆಗಿದೆ.
Charge sheet was filed.
Whatever application is now pending, what's your name?
Avinash.
Avinash ಅವರೇ. Whatever application is pending, you can revive that the moment trial commences.
But digital data ಯಾವ ತರ?
Digital data ಏನು?
2 years ಆದ್ಮೇಲೆ ಡಿಲೀಟ್ ಆಗುತ್ತೆ ಲಾರ್ಡ್ಶಿಪ್.
ಏನ್ ಡಿಜಿಟಲ್ ಡಾಟಾ ಕೇಳ್ತಾ ಇದೆ?
CDR.
CDR of whom?
Investigation officer and the raiding party there is asking. Lord, the trap was successfully laid, and he is claiming that, Lord, he had demanded 10 lakhs initial 10,000.
I don't think CDR gets deleted.
ಇಲ್ಲ ಲಾರ್ಡ್ಶಿಪ್.
Deleted? 1 ವರ್ಷನ?
ಗವರ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ಇದೆ, 2 years ಆದ್ಮೇಲೆ ಡಿಲೀಟ್ ಆಗುತ್ತೆ.
ಮತ್ತೆ ವಾಟ್ ಡು ಯು ಡು? ಇವಾಗ
2 years ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ.
ಈಗ ಅಲೋ ಮಾಡಿದ್ರು ಏನಾಗುತ್ತೆ?
ವಿತಿನ್ 2 years ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ ಲಾರ್ಡ್ಶಿಪ್.
ಅಲ್ಲ, ಆರ್ಡರ್ ಆಗಿದೆ, ಬಟ್ ಈಗ ಅಲೋ ಮಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ ಹೇಳಿ? ಟುಡೇ ಐ allow your application. If the data is deleted as per the government direction, and what is the use of the
sessions court order within 2 years all order?
It's now gone. Today we are at a stage where it is 3 years. Does the sessions court say that it should be preserved?
Production order ಮಾಡಿದೆ.
Production order ಮಾಡಿದ್ದಾರೆ. Production order ಯಾವಾಗ ಆರ್ಡರ್ ಮಾಡಿದ? 2 years ಒಳಗಿತ್ತ ಅದು?
Within 2 years. At least production ಆರ್ಡರ್ ಮಾಡಿದಾಗ ಒಪ್ಟೈನ್ ಆದ್ರೂ ಮಾಡಿರ್ತಾರೆ, ಅದನ್ನ ಸೀಲ್ಡ್ ಕವರ್ ಅಲ್ಲಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕಸ್ಟಡಿಗೆ ಆದ್ರೂ ಕೊಡಬಹುದಲ್ಲ.
The trap was laid in the 2020.
When did the court direct production of that CDR?
Lord,
November 2023.
17/11/2023.
17/11? Date of trap in?
date of draft, my lord, on 1.
2/12/2021. All right. 17/11/23 is the allowing of the
9/11.
application.
9/11/23, Lordship.
9/11/23. So it is within 2 years.
In 2 years.
All right.
Please.
When did you file this petition? 14 June 24.
Please.
What have you done with the data now?
Lord, what the information he sought, Lord. Lord, as per the complainant, Lord.
If you have deleted the data, adverse inference will be drawn because order was passed prior to 2 years. You have challenged it only after 6 months, 7 months after the passage of the order.
Lord, the application was filed in the year 2023.
ಹೌದು ಸರ್ 9/11/23 is the order.
Please.
Correct. 7 ತಿಂಗಳಾದ್ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ನೀವು.
Yes.
He is right in saying that data should be preserved.
Lord, it is our case, Lord. I have to prove the case, our case, Lord. He can take a defense at the stage of defense when it is posted for defense.
So preserve the data. In terms of the order, data should be produced at the stage of evidence. I will order that.
Lord, what the information, kindly see the order, Lord.
Sir,
He is seeking the
if you are
tower
pleading
location.
impossibility of production of a data on the score that it would be deleted in terms of the government order or government circular, you cannot now do it because you're 6 months late.
I'll verify it, Lord.
What verify?
Whether it is preserved or
ಇದೆ ನಿಮ್ಮ ಇವ್ರ ಹತ್ರ ಇದೆ ನೋಡಿ. He will have everything ಕೊಡಿ.
2021 ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. 1 year ಇದ್ದಿದ್ದು 2 years ಸ್ಟೋರ್
2 years ಮಾಡಿದಾರಾ? Anything else, sir?
I'll cross verify it.
ಇದನ್ನ
whether
verify
it is
ಮಾಡ್ತೀರಾ?
No, Lord. Whether they preserved or now it is available or not.
ಅಲ್ಲ, if it is not preserved, deleted ಅಂತ if you come, that will run counter to the order.
I'll make submission.
ಈಗ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವ ಇದರಲ್ಲಿ?
There is a stay.
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದು?
Lord, interim order was granted.
7/8/2024.
7/8/2024.
2024.
8/7/24.
Please.
All right. So much water has flown. 23 ಆಗಿರೋದು order. You better will preserve it because interim order is granted after 7 months or 8 months. I'll take it on Friday.
Please.
If there is no information, we will dismiss this petition, directing its preservation till he files an application or revives it.
And next week.
Tuesday, yes, list on Tuesday in the fresh matter, Wednesday in the fresh matters list. Yes. Idu file ಅಲ್ಲಿ ಇರಲಿ madam. Yes, next.
21.
The petitioner speech.
ITP and 370, sir.
Yesterday, my lords had directed the state to they've employed the foreigner.
Huh?
They've employed a foreigner in the spa.
So foreigner idd takshana it is presumed.
No, that is not the only thing.
Then, sir.
There is also
But
a Mazar, my lord, which speaks about.
Give the records.
In the Mazar, my lord, it speaks about the.
List this on Wednesday in the fresh matters list. Madam. ಈ ರೆಕಾರ್ಡ್ ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿರ್ತೀರಲ್ಲ ಮಾತ್ರ ಕಳಿಸ್ಬೇಕು. ಸರಿ, CH3 ಜೊತೆಗೆ ಅದೊಂದು ನೋಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Await services. Await service.
Post immediately after service of notice upon the respondent.
Interim order.
ಇದೆಯಾ interim?
It is. Errorally.
Interim order, comma, if any subsisting shall continue to the next date of hearing.
In both.
ಇದ್ರೆ. Oh, sorry, list.
Here for the petitioner. My lord, it appears in this matter, the police will not file a B report. And then, my lord, a protest memo was filed. Protest memo has been accepted. And then, my lord, there is a further order for investigation by the magistrate. So, my lord, they have to tell your lordships what they have done. And
Where are the papers?
Last time that was what was required to be done.
Additional SPP is directed to.
Pass or my lord. Exactly.
Received the papers. Your Lordship.
You have received the papers. Anyway, I have granted some protective order.
No, my lord. Your lordship said after the. I'm seeking for a protective order.
Yes, we'll pass it over. Pass over. 4 o'clock. Yes.
Anyway, I have another matter, my lord.
Then comes. Yes. Oh, that further hearing matter.
Yes,
All
further. Yes.
24.
Petitioner. Lords, this is a matter wherein, my lords, initially there was an apprehension by the respondent number 3 that there is companies which are being floated in India where they are they have launched betting apps and they try to destabilize the economy. On that information, my lords, the respondent number 1 and 2 register an FIR against 9 companies.
Correct.
On the all the 9 companies, they call for records, and 7 of them are probably guilty, please, my lords. 2 of them, we, especially the petitioner herein.
Not guilty at all.
No, we give whatever documents are given, asked for. And we show our bona fide saying we are people who are manufacturing wheelbases and we are exporting it, importing it from China. Now we want to start a plant here, manufacturing plant here. We have acquired lands in Siri City. We showed them all those things. They defreeze the account. But only problem was, my lords, now they have not filed charge sheet. Because my name is reflected as an accused, nobody is doing business with me. It's a small market, please, my lords. We have only 2 customers, TVS and Honda. They are not doing business with me. On that pretext, my lords, we are come here.
What is your company? Chong Quing Jeli. What do you mean by that?
It's a name, please.
A name. All right. Yes.
That's why it's the only ground, please, my lords. 2.5 years have lapsed. They have asked for every documents. They defreeze the account. If they say now that there is nothing, I have nothing to do with the crime which has been reported, it may be quashed because they cannot file a charge sheet.
So you are dependent on his say. We will ask Shanti Bhushan.
They say of R1, R2.
My learned friend has
You're
to
the-
say why he is the investigation, my lord, with regard to the investigation.
2 ವರ್ಷದಿಂದ investigation
What
ಮಾಡ್ತಾರೆ.
happened, I believe, my lord, that number of complaints was given on the same day with respect to all these Chinese apps.
All right.
About 60 plus charge sheets have been filed.
ಇವ್ರದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
Not against him, in all the complaints which they have given on that day.
All right.
So some more cases are being investigated. But this case, my lord, it is not a Chinese app, loan app case.
If it's not, then why freezing of the account?
Freezing
No, freezing, they defreezed it. Now
Alright.
it is being showed as an accused. I have been showed as an accused, that's all.
Investigation officer says, my lord, since it is not a Chinese loan app case, they probably file a different report.
Please.
B report ಹಾಕ್ತೀನಿ ಅಂತ.
Only against me. If they file B report, I have no problem. But they are not filing it only against me.
ಅದೇ ಬೇರೆಯವ್ರಿಗೆ ಯಾಕೆ ನೀವು worry ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
No,
Only
they can't
against
file
you.
a partial final report. That's the only problem.
Why are you worried about others?
We have filed 60 plus charge sheets.
ಚಾರ್ಜ್ ಶೀಟ್ಸ್ ಹಾಕಿದ್ರೆ ನಿಮ್ಗೆ ಹಾಕಿಲ್ಲ ಅಲ್ವಾ ಇನ್ನು? ಆಯ್ತು, ಈ ಕಾಂಗ್ ಚಿಂಗ್ ಜೈಲಿಗೆ ಏನ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ?
Time, my lord, we will file a report.
ಯಾವತ್ತು when will
No, problem is time only, please, my lords.
ಪ್ರಾಬ್ಲಮ್ ಇಸ್ ಟೈಮ್.
Please. ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಜಾಸ್ತಿ ಕೊಡಲ್ಲ. Yes. Come up with whatever you have.
End of the month, my lord.
We'll take it on 25th. By then, if it is not there, I'll quash it.
Publish.
I'll consider quashing it. ಯಾಕಂದ್ರೆ ರೆಕಾರ್ಡ್ ಬೇರೆ ಆಗ್ಬಿಡುತ್ತಾರೆ. ಕ್ವಾಶ್ ಮಾಡ್ತೀರಿ ಅಂತ ಹೇಳಿದ್ರಿ ಅಂತ.
Yesterday, my learned friend told my lord,
No,
Petition
nice.
is not cooperating. That was when I don't know that I. I'm scared now.
ಎಲ್ಲ don't tell anything in the lighter way, sir. Yes.
I meant his client, not his.
ಗೊತ್ತಾಯ್ತು. But he will not mind. He knows what Jagdish is. Yes.
25.
My lord, I filed my wakalat in the counter yesterday, please, my lord, for R2.
ಯಾರಿಗೆ ಸರ್?
R2, respondent number 2. R2, I filed my wakalat in the counter yesterday.
Lord,
My name is not shown.
petitioner in criminal petitions.
Come this side. Come this side, sir. You are the petitioner, right? Now, why are you standing away from him? Yes.
Lord, there's a writ petition pending before your honors, writ petition number 7122 of 2024.
ಅದು 482 ನಾ ಏನು?
Read with 482, yeah.
711 ಇದೆಯಲ್ಲ already
On
connected.
the last occasion, your lordship had connected this matter with my matter, my lord.
All right.
Yes, sir.
ಏನ್
Lord,
ಪ್ರಾಬ್ಲಮ್?
In that, there's a stay operating.
ಏನ?
In my matter, there's no stay.
All
my lord.
right, sir.
It's
Yes,
upon my-
Tulsi Kumar sir.
I'll file my statement of
Every
official
case will
objection,
stay
my lord. My name may please be shown, please.
The learned counsel B.N. Tulsi Kumar submits that he has ಅವ್ರ ಹೆಸರು ತೋರಿಸಿ ಅನ್ಬಾರ್ದಾ? ಸ್ವಲ್ಪ ಇರಿ. Yes. The learned counsel B.N. Tulsi Kumar submits that he has entered appearance for the second respondent. Registry to print the name of B.N. Tulsi Kumar is appearing for the second respondent. ಏನ್ ಹೇಳಿ?
Case filed by name, you know, the petitioner in the cell number 25 is the complainant.
For the complainant.
My contention.
Why do you want to stay in that?
My lord, no, my lord. There's a counter blast.
Wherein he is.
It is arising out of the same crime, my lord.
That two different FIR.
But it's arising out
You
of
have
the
been
same.
protected, will protect him also. This court, ನಿಮ್ದು 7122 na?
7057.
This court in writ petition 7122 of 2024 on 27/3/2024 has passed the following order. In the light of the common facts obtaining in both these cases, there shall be an interim order of stay of further proceedings in criminal petition 7057 of 24 as well till the next date of hearing. List on 26th. Yes.
Great.
Interim order subsisting in so and so shall continue till the next date of hearing. Stay application alone. Yeah. Hmm.
26.
Next week. Okay, sir. List after 2 weeks. Yes, next. Next bench ಮುಂದೆ try ಮಾಡಿ. Yes.
During the course of the day, my lords.
Interim order ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ.
Learned counsel submits that needful would be done in the next 2 days. In the event needful is not done in the next 2 days, interim order subsisting will stand vacated. Yes, next. Subject to the aforesaid condition, interim order stands extended till the next date of hearing, list after 4 weeks. Next.
28.
For petition minutes. It's 138 proceeding minutes. Absolutely non-compliance of section 56. Without endorsing the payment made by the.
Without?
Endorsing any payment minutes, they have.
No, that's all right. Where? Counsel for the petitioner to serve on the counsel.
Already served, madam.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ. 6/9 ಅಲ್ಲಿ ಆಗಿದೆ.
List the matter after 2 weeks awaiting the representation of the counsel for the awaiting the representation of the respondent. There shall be an interim order of stay of further proceedings further proceedings before the concerned court till the next date of hearing. Next.
29.
354, my lord. Lord, there is a dispute with regard to property between the, my lord, the complainant's wife, sister, husband, family, and my lord, accused of 4.
Learned HCGP Tejesh to secure the investigation papers.
But in fact, I have placed all the records, my lord. Charge sheet is filed here.
The entire charge sheet material is not produced, my lord.
Well, if you go by this, then I will dismiss it. Wound certificate ಇದೆಯಾ?
ಇದೆ.
ಕೊಡಿ. Anything else?
Lord, wound certificate, my lord, that is against my lord, accused number 224, not against A1. As far as A1 is concerned. As far as my lord, allegation against A1 is concerned, my lord, he slapped my lord, on Uma Devi. She is the mother of my lord, no, that is allegation. My lord, as far as my lord, assault is concerned, my lord, that is against.
That's a matter of trial, sir. 354B is what is alleged.
Lord, hear the case, Lord. Kindly appreciate it. Lord, here.
A1 ಮೇಲೂ allegation ಇದೆ. A1 ಮೇಲೆ kindly see.
ಅಲ್ಲ, A1, Lord, as for the charge sheet allegation, Lord, as far as the A1 is concerned, Lord, ಸಾಕ್ಷಿ ಅವರ ಬಟ್ಟೆಯನ್ನು ಹಿಡಿದು ಎಳೆದಾಡಿ ಕಪಾಳಕ್ಕೆ ಹೊಡೆದಿದ್ದು. That is
ನಿಮ್ಮ ಮೇಲೆ.
As far as A1 is concerned.
ಸಾಕಲ್ಲ?
Anything else?
Kindly appreciate,
Anything else?
he being the police officer, he is nowhere concerned with the dispute with regard to the family of A4.
Take chance, October second week. Less than the second week of October, pendency of this petition
as
will
far as
not. be the
354
way of
is
further
concerned, there is
proceedings
no
before the
ingredients,
concerned
Lord.
court. Yes. Sorry. Papas ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
In so far as
Change ಆದ್ರೆ chance.
354 is concerned, Lord, there is no ingredients of 354.
ಇದಕ್ಕಿಂತ ಬೇಕಾ?
Lord, kindly see, Lord, in terms of the judgment of Apex Co.
Groped her and that's a matter after evidence. ಕೊಡಿ 482 354 ಕೊಡಿ.
482 ಆಯ್ತು. And in the appeal,
Yes.
Lord, some and substance, Lord, I just pass on this.
I will hold some and substance.
Lord, when Lord 354 Lord come into play, I just Lord, first Lord, in the bottom, what constitute?
No. ಇದರಲ್ಲಿ hair, the accused had dragged the hair and pulled her.
Here, Lord, in this case, what happened, Lord? Why, Lord? How, Lord? In what circumstances, Lord, 354 Lord gets attracted? That's Lord. It's Lord called out here.
Oh, yes, second week of October. Yes, next. Give the papers back.
My lord, petitioner is accused number 4, my lord. Accused number 1, 2, 3, and 5 have been acquitted, my lord. Split up charge.
Split,
Yes, my lord.
pages.
My lord, 116, my lord.
116,
6, my lord.
paragraph. ಅದೇನಾ?
Yes, my lord. First, but from page number 116, my lord.
As per prosecution, para 16.
Yes, my lord.
Is government?
Please.
Page 116. Okay, 116 to 118. The petitioner is accused number?
4, my lord.
Accused number 4. He, along with other accused, would get embroiled in a crime in narration in crime number 133 of 2015 for offences punishable under section 324, 323, 447, 149 and 506 of the IPC. The petitioner is arraigned as accused number
4, my lord.
Accused number 4. At the relevant, the police, after investigation, file a charge sheet. The concerned court would try the other accused who were available for trial in CC 293 of 2016. On the score that the petitioner was not available for trial or had escaped trial, a split-up charge sheet is drawn against him in CC 14 of 2019. The concerned court, after drawing up of the split-up charge against the petitioner, acquits the other accused in terms of its order dated 17/1/2019. In terms of its order dated 8/2/2021. The accused who are acquitted are accused number 1, 2, 3, and 5. Who remains in the story of crime is the accused number 4, the present petitioner. The learned counsel for the petitioner submits that the reasons so rendered by the concerned court to acquit accused 1, 2, 3, and 5 would 1, 2, 3, and 4.
1, 2, 3, and
1, 2,
5.
3, and 5 would inure to the benefit of the petitioner, as what is alleged is a common act performed by all the accused. He would seek quashment of the proceedings. The learned HCGP would refute the submission contending that the petitioner has escaped trial and should not be shown any indulgence. He should undergo the trial and come out clean, as the other accused have undergone trial and come out. I have given my source. The four narrated facts are not in dispute. The petitioner is the one who has escaped trial. In the normal circumstance, would not be shown any indulgence for quashment of the proceedings to a person who did not stand trial like the other accused. The permitting further proceedings against the petitioner on the aforesaid score would only result in wastage of precious judicial time, as eventually the petitioner would get acquitted. For the reason that others are acquitted due to lack of evidence. The lack of evidence qua other accused cannot spring as evidence in the case of the petitioner accused number 4. In that light, I deem it appropriate to obliterate the crime against the petitioner, the view of mine, so on. Yes. Next.
51,
Covered, same, disposed.
52.
One submission.
You know,
There are two pending petitions. Only one of them has
Kodi,
been
Kodi,
listed today.
Kodi, give that.
Much.
Number Kodi. To the experiment, does not.
Much of that.
Therefore, the petition,
32,
therefore the petitioner, madam.
Huh?
Therefore the petitioner, petitioner is,
ಆಮೇಲೆ
therefore the petitioner.
ಅದಾದ್ಮೇಲೆ ಹೇಳಿ ಸರ್.
Petitioner is a student, my lord.
Student.
He is studying second year PUC. Have produced annexure A, my lord.
NDPS sir.
Pending case, my lord.
Yes. 27B ಕೊಡಿ. ಏನಿದೆ?
One submission.
Confession ನಾ?
One submission, my lord.
ಹೇಳಿ ಸರ್.
Earlier, we have challenged the same FIR, my lord, that has been quashed on the ground of FSL report is not submitted, my lord.
Page number.
Para 6 of the annexure B, I have annexure B, my lord.
Number 4, my lord, impugned judgment. There's no FSL report, my lord, on that cause.
ಇದರಲ್ಲೂ ಇಲ್ವಾ? Will say it is covered and close it.
One submission, it is a competent, government doctor is not a competent authority to issue this medical certificate. They have not issued this certificate.
We will hold it is covered by what is written by the coordinate bench and close it. The petitioner is before this court calling in question registration of a crime in crime number 99 of 2024 registered for offences punishable under section 27B of the Narcotic, Drugs and Psychotropic Substances Act 1985, hereinafter referred to as the Act for short. Then reference ಬೇಕಾಗಲ್ಲ ಬಿಡಿ. Yes, so and so. The learned counsel appearing for the petitioner submits that against the is a different crime adu.
Same crime, same crime.
1453 lane crime adu. FIR stage.
FIR states. FIR is quashed.
ನಿಮಿಷ ಸರ್.
Criminal proceedings.
Different crime. ನೀವು ಹೇಳಲ್ಲ
Crime number.
It is a different crime, my lord, but
Crime number 1 of.
The learned counsel appearing for the petitioner would seek to place reliance upon an order of the coordinate bench in criminal petition 1453 of 2023, by which the coordinate bench had obliterated the crime registered against this very petitioner in crime number 1 of 2023. The subject crime is different, but the finding rendered therein would inure to the benefit of the petitioner as the grounds urged and the grounds answered by grounds urged would cover the grounds answered by the coordinate bench in the aforesaid judgment. The coordinate bench has held as follows, para 3 to end. In that light, the following order allowed quashed. Next.
33,
A1 ಇಲ್ಲ ಬೇರೆಯವ್ರಿಗೆ ಮಾತ್ರ. Yes, Kashkan. Yes, no A1. Next.
34,
List on 20th. Yes.
35,
Lord, fresh matter.
20.
Fresh matter.
ಬೇಡ. List on 20th at 4 PM ಅಂತ ಹಾಕಿ dictation.
35,
Appearing for the petitioner. Atrocity Act, my lords, make a recollection. Atrocity Act, my lords.
Yes, sir.
Petitioners are, my lord, 78, 76 and 69-year-old. There was an issue between petitioner and the complainant with regards to the car parking. That has now, my lord, ended up in filing the FIR and a counter FIR.
ಕೌಂಟರ್ FIR ಇದೆಯಾ?
Please, my lord.
ಅದನ್ನ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ? ಯಾವ್ದು? ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ ಅದು? ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ?
ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಎಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ? ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿ 2 ಕಾಸ್ಟ್ ಮಾಡೋಣ. ಕಾರ್ ಪಾರ್ಕಿಂಗ್ ಜಗಳ ಎಲ್ಲೆಲ್ಲಿಗೆ ಹೋಗಿದೆ? ಯಾವ್ದಕ್ಕೆ ಫೈಟ್ ಮಾಡಬೇಕು ಅಂತ?
Till then, there may 78-year-old, kindly.
1 minute, sir. Yes. List the matter on 25th. ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ. List the matter on 25th. There shall be an interim order of stay where these petitioners till the next, in the impugned proceedings till the next date of hearing. You also file? Well, good.
Great.
25th ಹಾಕಿರ್ತೀನಿ. 25th in the fresh matters list.
36.
I appeal for the petition. Forest matter. File our objections.
Huh?
We have filed our objection.
So I not serve the copies.
Normally send an email. I'll give a copy.
Yes. 18th.
Please, madam. Lordship, have it on 19th.
19th.
Madam.
Entry order ಇದೆಯಾ?
Interim order not to proceed any further action at this point.
The issue is, my lord, he is challenged the in this writ petition, notice issued to him is under 64A proceedings.
ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. Forest Act.
The entire proceedings.
No, you have challenged that. Then you should go to the GM court.
He challenged the FOC, but the notice is produced or the notice issued under 64A proceedings.
Because the proceedings, my lords, which was initiated against the violation of the certain acts.
19th is the fresh matters list.
Much. Because there are several sections have been levied, my lord. I have challenged that also.
Imposed. Imposed. Levied tax. Yes.
37.
Sawmill. ನಡೀತಾ ಇದೆಯಲ್ಲ sawmill? ಎಸ್ ಲತೀಫ್.
ನಡೀತಾ ಇದೆ.
ಹಾ. ಏನು ವುಡ್ ಕೇಳ್ತಾ ಇದಾರ? ಪೆಟಿಷನ್ ಕಾಪಿ ಕೊಡಿ. ನಿಮ್ sawmill ಇಂದ ಏನ್ ಕೇಳ್ತಾ ಇಲ್ಲ.
ಕೊಡ್ತೀವಿ.
Yes. Counsel for the petitioner is directed to serve complete set of papers upon the counsel case Bhimaya forthwith. Lest the matter in the third week of October, interim order subsisting shall continue till the next date of hearing. Next.
This case I am on the petitioner. Petitioner is a complaint before the trial court. He filed a complaint.
Post immediately after service of notice.
Take notice
What
for.
is not necessary?
ಇದರ ನಾಟ್ ನೆಸೆಸರಿ.
Because my lord, the complaint.
ಪಾರ್ಟಿ ಯಾಕೆ ಮಾಡಿದ್ರಿ?
Normal party ಮಾಡಿರೋದು, but
ಅವ್ರು ನಾರ್ಮಲ್ ಆಗಿ ಬಂದಿದ್ದಾರೆ ಇಲ್ಲಿ. ವೇಟ್. ಎಸ್ ಸರ್.
I'll take notice for, my lord, 4, 5 and 6. Lord, in fact, in criminal revision petition, my lord, I have represented all the respondents. Now I have not received instructions.
1 minute, sir.
Kindly see, my lord, annexure B, my lord, for a moment. ನಾನು ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ, PCR ಒಂದು ಸೋನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. ಸೋನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಆದ್ಮೇಲೆ 201 ಕಡೆ ರಿಟರ್ನ್ ಮಾಡಿದ್ದಾರೆ. It is not correct.
He's also challenged criminal RP order where I have been a party and it is dismissed on.
Revision petition ಏನಾಯ್ತು?
Revision petition dismiss ಆಗಿದೆ.
ಕನ್ಫರ್ಮ್ ಆಗಿದೆ ಆರ್ಡರ್.
ಹೌದು.
But my lord,
Yes. The learned counsel Kasif undertakes to enter appearance for respondents.
Lord, 3, 4, 5 and 6.
Respondents 4, 5 and 4, 5 and 6.
I had appeared for all the people in the trial court.
Take notice.
I'll take notice.
Learned
Except
counsel,
for respondent number 3, my lord, I'll take notice because
the
that I have
learned
not.
counsel would undertake to enter appearance for all the respondents except respondent number 3.
Please.
Registry to print the name of Kasif as appearing for all the respondents except respondent number 3. Respondent number 3 ಗೆ emergent notice ಮಾಡಿದೀವಾ? Emergent notice to the ಆಗಿದೆ already. Yes, so and so.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 19th ಇದೆ.
ಇರ್ಲಿ ಏನಕ್ಕೆ? So what?
Until then ಅವರು ನಮ್ಮಲ್ಲಿ ಮತ್ತೆ ಅಲ್ಲಿ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೋಸ್ಕರ
ಏನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ?
ಅವರು ರಿಟರ್ನ್ ಮಾಡಿದ್ದಾರೆ. 4th ASM ನಾವು ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ. ಲ್ಯಾಕ್ ಆಫ್ ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಅಂತ ಹೇಳಿ ಅದನ್ನ ನಮಗೆ ಮತ್ತೆ ರಿಟರ್ನ್ ಕೊಟ್ರು.
It was returned, but he is represented it also.
List on 18th in the fresh matters. Next.
39.
A2.
A2, madam.
A1 gyara.
A1, yeah.
A1 what is the matter?
This is a crime against the petitioner, madam, for the offences under section 13(1)(a) of PC Act 468, 471 and 477. There was
why are you now before the court?
There was a departmental proceedings, which was
ಅದರಲ್ಲಿ exonerate
ಆಗಿದ್ದಾರೆ.
13(1)(a) departmental inquiry ಮಾಡಿದ್ರಾ?
ಅಲ್ಲ, on consequence of this registering of the FIR, there was a departmental inquiry.
Notice ಆಗಿಲ್ವಾ?
Notice ಆಗಿಲ್ಲ.
First time.
Okay.
Learned counsel BB Patil is directed to accept notice for the respondent petitioner to serve 2 sets of papers upon counsel to BB Patil. List the matter on 20th, madam. List on 20th.
Until then,
yes, next. On 20th, please.
Wait for me.
Freeze. Yes, government, why freezing of the account?
He has registered the complaint online, my lord. While registering the complaint, he has given his own account number for
Freezing.
freezing. On
Right.
account of which it has
Mistakes.
mistake ಮಾಡಿದಾರೆ. But the IO, he has brought to the notice of the IO. IO has also intimated the concerned bank to defreeze it. They have to do it. The respondent bank has to do it.
Who is the respondent bank?
Lord, primary and secondary. accounts
ಯಾವ
are
bank, sir?
Citibank and SBI.
Who represents them?
Notice ಹೋಗ್ಬೇಕು.
The investigating officer has frozen certain accounts on account of a complaint being registered by the petitioner. Inadvertently, the petitioner has mentioned his own account to be frozen while seeking freezement of the account. The investigating officer has so done is the submission of the learned HCGP on verification of the records. He would further submit that the account of the petitioner is directed to be defrozen by the investigating officer. The banks have not acted so. Therefore, though the banks are represented, notice ಆಗಿಲ್ಲ ಅವ್ರಿಗೆ?
ಇಲ್ಲ, notice has not been notified.
The emergent notice to the respondent banks, the petitioner is at liberty to produce the said order, which would enable the banks to defreeze the account of the petitioner by the next date of hearing. List the matter on.
Lien is being marked on a daily basis. I'm running at 30 lakhs.
I think they will do it. List the matter on Wednesday in the fresh matters list. It produce ಮಾಡಿ ಬಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ will direct what is to be done.
Please.
Yes. Next. Prepare ಆಗಿಲ್ಲ. PF ಕಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ, ನೋಟಿಸ್ ಆಗಿರಲಿಲ್ಲ.
ಆಗಿದೆ ನೋಟಿಸ್. ಇವತ್ತೇ ಕಟ್ಟಿ. Yes. Next.
41.
Post immediately after service of notice. ಇದೀರಾ?
Respondent number 2 in the.
Learned counsel so and so undertakes to enter
I've
appearance.
already filed wakalat yesterday.
Submits that he has entered appearance for the second respondent. Registry to print the name of so and so is appearing for the second respondent. Objections?
I'll file it on the next week, my lords.
Learned counsel seeks 10 days time to file interim order.
No, man.
Seeks 10 days time to file statement of objections. Objections, if any, in the next 2 weeks. List the matter after 2 weeks. Next.
42.
Charge sheet is filed in this case, my lordship. They have filed the prime lordships.
Charge sheet.
Charge sheet is filed my lord during pendency of this.
Amend interim order ಇದೆಯಾ?
Interim order ಇಲ್ಲ, ಅದೇನಾಗಿದೆ?
Amend ಮಾಡ್ತೀರಾ?
I will.
Amend ಮಾಡ್ತೀರಾ?
Amend ಮಾಡ್ತೀನಿ.
ಬೇರೆ ಹಾಕ್ತೀರಾ?
Amend ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. Until then, my lordship.
No.
Stay me.
I
No,
will not.
this matter was listed on second, my lordships.
You
They
said you will amend, you will file an amended petition.
Please, my lords, allow me to my lords,
Yes.
make submission, please, my lords. ಒಂದೇ ಒಂದು submission ಇದೆ.
ಅದಕ್ಕೆ ವಿಡ್ರಾ ಮಾಡಿ ಇಮಿಡಿಯೇಟ್ ಹೊಸದು ಹಾಕಿದ್ರೆ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ. ಇಲ್ಲ ಯು ವಾಂಟ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಓನ್ಲಿ ಅಂದ್ರೆ ಇಟ್ ವಿಲ್ ಕಮ್ ಇನ್ ಅಪ್ಲಿಕೇಶನ್ಸ್.
ಇಲ್ಲ, ಅದು ಮೊನ್ನೆ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಲಾಸ್ಟ್ ಸೆಕೆಂಡ್ ನೀವೇನು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರೆ ಸೆಕ್ಯೂರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರಿ. ಅದಕ್ಕೋಸ್ಕರ ಇನ್ ಸ್ಟೇ ಕೊಟ್ರೆ ಇನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕೋದಕ್ಕಾಗಲ್ಲ ಅಂತ ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಇವತ್ತು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿದೆ.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಆಮೇಲೆ ಸ್ಟೇ ಕೊಡಬಾರ್ದು ಅಂತಿಲ್ವಲ್ಲ. ಏನು ಒಫೆನ್ಸ್?
498A 304B, my lordship. ಅಲ್ಲ, ಟೋಟಲ್ ಎಲ್ಲ ಇನ್ಲಾಸ್, ಎಲ್ಲ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಕಂಪ್ಲೀಟ್ಲಿ ರೋಪ್ಡ್ ಇನ್, my lords, falsely roped in.
ಪರವಾಗಿಲ್ಲ, ಆರಾಮಾಗಿ ಹಾಕಿ, ತೊಂದರೆ ಇಲ್ಲ. ಏನ್ ಮಾಡ್ತೀರಾ?
Permit to
Amendment
withdraw,
ಹಾಕ್ತೀರಾ?
permit to withdraw, my lords.
All right. Sir.
With liberty.
Yes. With liberty. File it immediately. No
Please,
problem. We'll consider.
Please. Oblige.
Get the latest judgment of Supreme Court.
Please.
Unless demand of dowry is established, 304B will not come.
Please.
That you should travel in that.
ಇಲ್ಲ ತಗೊಂಬಂದಿ.
ತಗೊಂಬಂದಿರಾ? Yes. Justice Pardiwala.
ನಿಮ್ದು ಒಂದು
ಬೇರೆ
ನಿಮ್ದು ಜಡ್ಜ್ಮೆಂಟ್.
ಸರಿ ಆಯ್ತು, ಕೊಡಿ, ಚಾಲೆಂಜ್ ಮಾಡಿ.
Please.
ಆಮೇಲೆ ಮೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಹೇಳಿ, ಐ ವಿಡ್ರಾನ್ ಸಿನ್ಸ್ ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ಫೈಲ್ಡ್, ವಿಲ್ ಟೇಕ್ ಇಟ್ ದಿ ವೆರಿ ನೆಕ್ಸ್ಟ್ ಡೇ.
43.
My lords, I appear for the petitioner, my lords. My lords, I seek, my lords, 1 week's accommodation, my lords, in the matter. Need to seek some instruction, my lords, from the party.
Only committal procedure, man. Only committal procedure is not followed. This is a contention.
This has to be allowed and sent back ಅಷ್ಟೇ sir.
My lords, a week's accommodation, my lords, to seek instructions.
List
My lords,
on
a week's.
material
Please.
instruction.
Please.
List on 19th in the fresh matters list as a last chance. Interim order subsisting shall continue to the next date of hearing.
In both the petitions.
ಎರಡಿದೆಯಾ? ಆಯ್ತು.
ಎರಡು.
We'll allow
Same
it and
issue.
send it back.
Please.
Yes.
44.
But in this case, my lord, on a
Freezement.
It
In this
pertains to
case,
Kalburgi branch.
account defreeze, my lord, savings bank account, in the annexure.
ಅಲ್ಲ ಆಯ್ತು, ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದೆ, ಈಗ ವೈಫ್ಸ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದೇ ತಾನೇ ಇದು.
Yes,
ಸುನಿಲ್
ma'am.
ರಾವ್
Yes,
appear
ma'am.
ಆಗಿದೆ.
Son-
ಕೊಡಿ ಅದು order. ಹಾ. Yes,
Copy
Jagdish.
along with the,
The amount of 50,000 rupees has been, 5 lakh rupees has been received in this account. There
my
are-
lord,
Whatever, lien is marked and other accounts ಅಲ್ಲಿ ಇದೆ. ತಗೊಳ್ಳಿ ಅದು.
That can be done.
my lord, here in the complaint, my lord.
ಅಲ್ಲ, just look into it. ನೀವೇ ಆರ್ ಕಂಪ್ಲೇನೆಂಟ್. ಅಂಡರ್ಟೇಕ್. ಅಲ್ಲ, ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸೇ ಬಿಡೋಣ.
My lord, here, I just read the complaint, my lord. Page number 47. It is the interim order passed by this honorable court, along with the updated annexure G. Annexure G ಅಲ್ಲಿ ತೋರಿಸ್ತಾ ಇರೋದು ಮೈನಸ್ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಅವರದ್ದು 20,000 ರೂಪಾಯಿ ಬ್ಯಾಲೆನ್ಸ್ ಇರ್ತದೆ. ಆ 20,000ವನ್ನು ಸಹ ಮೈನಸ್ ಮಾಡಿ 2,51 lakhs ಅಗೇನ್ ಬ್ಯಾಲೆನ್ಸ್ ಮೈನಸ್ ಬ್ಯಾಲೆನ್ಸ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ. ಅಂದ್ರೆ ಇಲ್ಲಿ FIR ಫೈಲ್ ಆಗುತ್ತೆ 1,26 lakhs ಅಂತ ಹೇಳಿ. ಆ 1,26 lakhs ಅಲ್ಲಿ my lord 72 lakhs ಕ್ಯಾಶ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಮತ್ತೆ 5 lakhs ಬೇರೊಬ್ಬರ ಅಕೌಂಟ್ ಇಂದ, ನಾಟ್ ಇವನ್ ಬೈ ಫ್ರಮ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್.
This was the case of your husband, is it?
Not even from this complainant, but from the other person. 5 lakhs ಇವ್ರ ಅಕೌಂಟಿಗೆ, ದಿಸ್ ಪಿಟಿಷನರ್ಸ್ ಅಕೌಂಟಿಗೆ ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಬೇಕಾದ್ರೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೇನೆ ನೋಡಿ.
Yes.
ನಾಳೆ ತಗೊಳ್ಳಿ.
5 lakhs ಹೋಗಿದೆ. That lien can be marked.
That too, my lord, I will read the page number.
So we'll mark lien on that 5 lakhs.
My lord, I will read the complainant.
ಅದು ಬೇಡವಾ?
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಇದೆ my lord. ಅದರಲ್ಲಿ
ಅಲ್ಲಿ ಇವ್ರು
ಗೆಳೆಯನಾದ ಬಸಪ್ಪ ತಂದೆ ಉಪಾಶಪ್ಪ ಅವರ ಅಕೌಂಟ್ ಇಂದ 5 lakhs ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
No, that's
ಇವ್ರ
a
ಅಕೌಂಟ್ ಇಂದನೂ ಅಲ್ಲ, ನಾಟ್ ಇವನ್ ಫ್ರಮ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್ ಅಕೌಂಟ್.
No, that's a matter.
And the same 9 lakhs rupees, so same Siddhap, this complainant's friend, ಅವರೇ ಅದರಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ, there is a separate agreement ಇರುತ್ತೆ. 9 lakhs ಅವರಿಗೆ ಹೋಗುತ್ತೆ ಈ ಕಂಪ್ಲೇನೆಂಟ್ ಕಡೆಯಿಂದ, ಈ victim
These
ಕಡೆಯಿಂದ.
things you should investigate fast and
Yes.
finish it.
No.
Till how long will you keep this maze of facts?
My lord, here 1,26 lakhs ಗೆ complaint.
ಒಂದು ನಿಮಿಷ. Yes. Yes, sir.
Now, we collected all the documents, my lord, which shows the financial trail between all these people. Between the petitioner and other people. Basically, my lord,
Complainant,
farmers.
ನಿಮ್ದು ಎಷ್ಟು ದುಡ್ಡು ಹೋಗಿದೆ?
My lords, we are the president of a Baswana Vadagadi Horticulture Farming Production Company. These are all members. We have collected the money and we have transferred them. They are told they will build a poly house and they'll statutory income will come, monthly income will get. It was promised, my lord. Based on that, we have transferred the money.
How much
Even
money you
if I'll undertake, my
Wait,
lord.
sir.
My lords, on different occasions, I have transferred the money, my lords. In the complaint only I have stated that on 28/8, 5 lakhs was transferred. And Galia is honors of member of the company only, my lords.
Total 1.2.
ಗೆಳೆಯನಾದ ಬಸಪ್ಪ
ಪರವಾಗಿಲ್ಲ.
ಅಕೌಂಟ್ ಇಂದ 5 lakhs ಬಂದಿದೆ.
ನಿಮಗೆ ಬಂದಿದೆ ಅಲ್ವಾ? ಪರವಾಗಿಲ್ಲ.
And 9 lakhs rupees has been given to same member. ಅದೇ ಸೊಸೈಟಿಯ ಮತ್ತೊಬ್ಬರು ಮೆಂಬರಿಗೆ ಹೋಗಿದೆ.
ಈಗ
ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಸಪರೇಟ್ ಅಗ್ರಿಮೆಂಟ್ ಸಹ ಇದೆ, my lord.
ಪಾಲಿ ಹೌಸ್ ಏನ್ ಮಾಡಿದ್ರಿ?
That is my lord, their own, they have invested in the same neighboring village. They invested around 18 lakhs. And when this company, that is
have you
from the
taken money?
accused company, 1,80 lakhs has.
Have you taken money from these people?
No, my lord.
Why?
That is actually, my lord, here only
Who has taken
42
money?
lakhs. Only with regard to 42 lakhs rupees.
Now 5 lakhs lien will be marked. Yes. ಅದು ಮೈನಸ್ ಅಲ್ಲಿ ಇದ್ರೂ ಪರವಾಗಿಲ್ಲ, ಹೆಂಗ್ ಬರುತ್ತೆ ಅವಾಗ ಲೀನ್ ಮಾರ್ಕ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ. The petitioner is before this court seeking defreezement of the account that is frozen on account of idyavud Kalburgi bench.
Yes.
I have considered on account of certain crimes being registered against the petitioner. Against this petitioner, the allegation is that there is a transfer of 5 lakhs for construction of a poly house. The learned counsel for the petitioner would submit that the amount is not received from the hands of the complainant, but his friend. Be that as it may, since the freezement of the account of the petitioner would cause hindrance to the transactions and to the property of the petitioner, as the account held is akin to a property held. Therefore, I deem it appropriate to direct marking of a lien of 5 lakhs that has come into the account of the petitioner and permit defreezement of the account for it to become operational as usual. Yes. Operational in the normal way, yes. And delivery, ಇದ್ಯಾಕೆ ಬರುತ್ತೆ ಬಿಡಿ, yes.
45.
Next. Or register to print the name of so and so ಅಂತ.
Petition,
Yes, fine.
petition can be disposed of. That's
I will, all right.
other prayers are saying that police should not arrest him, harass him and other thing. Main prayer is
Will dispose it or what?
Yes, my lord, here,
ಮತ್ತೆ ಈಗ argument, let it come, yes, next.
my lord, based on one small complaint, 2 crore, ಅದರಲ್ಲಿ 42 lakhs ಮಾತ್ರ ಬ್ಯಾಂಕ್ ಟ್ರಾನ್ಸ್ಫರ್ ಅಂತ
That's all right, sir.
2
Yes.
crore 52 lakhs
transaction
ಲೀನ್
in bank
ಮಾಡ್ತಾರೆ.
account.
No, no. Yes, next.
45.
45, I'm requesting for passover, my lord.
45 are requesting passover.
My senior has to.
Passed over by 1 week, 20th, yes.
Kindly, my
next.
lord. My lord, at
ಏನ್
2:30.
7A ಅಲ್ವಾ?
Please, ma'am. I'm requesting for interim order, my
No,
lord.
7A, 20th, yes.
My lord, I'll take one chance, my lord, in the afternoon.
20th,
In the
you can
afternoon.
take a chance, yes. 46 to 7A ne.
ಇಲ್ಲ, my lord. Matter pertains to disproportionate asset, my lord.
13.
Please.
Yes, sir.
The alleged properties,
20th, yes.
my lord, there is a threat of suspension, my lord. Your lordships have granted interim order in similar circumstances. The alleged properties,
ನೆನ್ನೆ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಕೇಸಲ್ಲಿ ಅವ್ರು ಮಾಡಿದ್ವಲ್ಲ.
alleged properties
No
are
coercive. The list on 20th, no coercive or precipitative action. will be
annexure
taken.
J, my lord, in
No.
similar circumstances, my lord.
Service matter ಇಲ್ಲಿ mail ಮಾಡಬೇಡಿ ಅಲ್ಲ. No coercive or precipitative action shall be taken against these parties. ನೆನ್ನೆ ಮಾಡಿರೋದು ಅದೇ ಅಷ್ಟೇ.
Annexure J, my lord, kindly see.
ಇಂಡೈರೆಕ್ಟ್ ಆಗಿ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಸ್ಟೇ ಕೇಳ್ದಂಗೆ ಕೇಳಬೇಡಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
57.
Please.
ಎಸ್, ಅರೌಂಡ್.
Okay, for the petitioner. Now, the third respondent entertains a complaint from the fifth respondent on the allegation that he had deposited a sum of rupees 3,05,000 in a link which is forwarded by his brother, and the company has not refunded the amount. Not what this investigating officer does is, he freezes the bank account of 116 persons and liens not 3 lakhs in every account, 116 accounts.
I will see, yes.
Not
Learned additional SPP is directed to accept notice, secure the investigation papers and the role of this petitioner in the alleged episode of crime. By ಈಗ respondents ಯಾಕೆ ಮಾಡಿದ್ರಿ ಇವ್ರನ್ನೆಲ್ಲ?
Not amounts are freezed. My bank accounts are freezed.
ಅವ್ರ respondents da?
ಹೌದು. From 6 and 7, we have the bank accounts. Petitioner number 2 is the wife of the first petitioner. She is also having a bank account. That account is also freezed.
Oh, Axis Bank. Yes. So get the papers. Petitioner to serve 2 sets of papers upon the learned additional SPP, 18th fresh matters. Next. 18th ಇಲ್ಲ 19th fresh matters.
ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದಾರೆ. He is the only employee. ಅವನೇನು ರೋಲೇ ಇಲ್ಲ.
ಕಸ್ಟಡಿ ಇರೋಕ್ಕೂ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ಗೆ ಏನು ಫ್ರೀಸ್ಮೆಂಟ್ಗೆ ಏನು ಸಂಬಂಧ?
ಅಲ್ಲ, ಅದು ಇರ್ಲಿ ಮತ್ತೆ, ಬಟ್ ಈಸ್
ಬೇಲ್ ತಗೊಳ್ಳಿ. ಸೆಕ್ಯೂರ್ ಬೇಲ್, ಎಸ್.
18th ಸಂದೇಶ 19th minutes.
19th fresh matters.
But I seek a week's time, Lord, we are happy for R2.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Covered by decision, the Isanjenews court martial.
ಏನ್ ಸ್ಯಾಂಕ್ಷನ್?
ಅಲ್ಲ, 498A.
Why at 2:30? Pending matter. Kodi. What urgency?
Petitioners are ready to repay. The police register something called an LP was upon the petitioners. And he said that yes, we are repaying money. Give us some time. And he registers the FIR under 420 without even issuing any notice. Primarily. And second petitioner's wife of the first petitioner is nowhere named in the company. And again, an FIR will be lodged against for no reason.
We'll see. Give it. Friday ತಗೊಳ್ಳಿ ಮೇಡಮ್. Friday sir. Yes. ಮತ್ತೆ FR ಅದಕ್ಕೆ ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. 2 ಸರಿ ಮೆಮೊ ಹೋಗಿರುತ್ತೆ, ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ. ಈಗ ಹೋಗಿ go and complain. Tomorrow why? Why apprehension of arrest? Bail ತಗೊಂಡಿಲ್ವಾ? ತಗೊಂಬಿಡಿ, ಪರವಾಗಿಲ್ಲ, ಬೇಲ್ ತಗೊಳ್ಳಿ. No sir, no madam. Take secure bail, we'll post it on Tuesday. Don't convert this to a bail court unless Atrocities Act is alleged. Yes. Good. I'm not yet made up my mind. We'll take it tomorrow. L. Sunil Kumar. No problem. She's a colleague. That's all right. But tell Jyota sir, I may have to hear him again for 5 minutes. I have some clarification. In that. So, bail Kodak, I have not yet made up my mind, so I have not passed the order today. You can also tell senior. Yes. Yes, Jesham? Nale ಹಾಕ್ತೀನಿ ಮಾಡಿ. ನಾಳೆ ಅಲ್ಲ, day after tomorrow I'll post. Yes. Day after tomorrow, Ashok. ಅದರಲ್ಲೂ ನೀವೇ ಇರೋದಾ? ಯಾವ್ದು ಆ ಮ್ಯಾಟರ್? ಬೇಲ್ ಮ್ಯಾಟರ್ಲಿಯಾ? ಗೊತ್ತಾಗಲಿಲ್ಲ. ವಾಟ್ ಇಸ್ ಇಟ್? 140? ಅದನ್ನ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹೇಳಿದ್ನಲ್ಲ.
ಒಂದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದು ಕೊಡ್ಬೋದು.
ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನನಗೆ ಕೊಡ್ಬೇಕಾ?
ಅಲ್ಲ, ಇಲ್ಲಿ ಫೈಲಲ್ಲಿ ಇಡ್ಬೋದು. ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರೂಲಿಂಗ್ ನಾನು ರಿಲೀವ್ ಮಾಡಿದ್ದೆ, ಒಂದು ಸಾಧ್ವಿ.
ಡೋಂಟ್ ವರಿ, 2011.
ಹೌದು, ಅದರಲ್ಲಿ ನಾವು ವಿದೌಟ್ ಕೋರ್ಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅದು ಸಪೋರ್ಟ್ ಆಗೋದಿಲ್ಲ ಅದಕ್ಕೆ. ಅದು ದಟ್ಸ್ ವೈ.
ಏನ್ ಪರವಾಗಿಲ್ಲ, ಡೋಂಟ್ ವರಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ಗೆ ಯಾರು ಏನು ಸಪೋರ್ಟ್ ಮಾಡಬೇಕಾಗಿಲ್ಲ.
ದೇ ಆರ್ ಟೇಕನ್ ಟು ಕನ್ಸಿಡರೇಷನ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್.
ವಿಲ್ ಸಿ, ಡೋಂಟ್ ವರಿ.
ಆಯ್ತು.
Why default bail is rejected? And why before this court? Procedural ಮಾಡಿದ್ದೀರಾ? Just challenge it in the bail jurisdiction. I have. That doesn't mean that I entertain every petition. Go before the bail court. You would have got bail by now. You go before the bail court and seek bail, sir. You need not challenge the order. You can seek enlargement of bail. See, ನಮ್ಮ ಮುಂದೆ ಇದ್ರೆ ಇದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗಲ್ಲ. If you go to the bail court, it will happen immediately. Tomorrow I doubt I will post it day after tomorrow. ಅದು in the fresh matters ಹಾಕಿ madam, day after tomorrow.
It is rejected on the ground that charge sheet has been. It is rejected on the ground that charge sheet has been filed.
There is a technical argument that has to be made.
Let's see. ಏನು offense ಏನು? ಏನಾಯ್ತು? Yes.
Body warrant and use ಮಾಡಿದ್ದಾರೆ. Charge sheet insofar as other accused. Against him there was no charge sheet.
That has been taken.
Oh, you are still being held under body warrant?
Yes.
All right. Yes, sir.
Therefore, no, he is in connection with custody in some other case.
Let's see.
138.
ಆಯ್ತು. We'll take it on 13th in the fresh matters list. Yes.
48 people yesterday for the further hearing. It was reserved for orders. I have given the
ಗೊತ್ತಾಯ್ತು, ಸರಿ.
Further hearing, document request to review. That's all.
ಹಂಗೆ ಇರ್ಲಿ, ತೊಂದರೆ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ರಿಸರ್ವ್ ಮಾಡ್ತೀನಿ.
20th ಹಾಕಿ ರಿಸರ್ವ್ ಮಾಡ್ತೀವಿ. ಅಲ್ಲಿವರೆಗೂ ಸ್ವಲ್ಪ ಪೈಲಪ್ ಆಗಿರೋದು ಕಮ್ಮಿ ಆಗಲಿ. ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ. 2:30 ಯಾವ್ದಾರು ಇದೆಯಾ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ? ಯಾವುದು? 2:30 orders. 2:30. ಯಾಕೆ 2:30 ಹಾಕ್ತಾ ಇದೆ? It's all right. Better continue the list.
Let's continue. Number 57.
One ನಿಮಿಷ, just one moment. Just call this, sir, ಒಂದೇ ನಿಮಿಷ.
Please, please.
146 on ಕರೆ.
One 46.
The dictating, heard reserved. Yes. Now continue the case. Yes. 47. 57. Ah, yes, sir. 2 points. Mike use ಮಾಡಿ sir.
The allegation is that on May 28, 2020, the petitioner has sent 24 emails containing company confidential documents from his official email ID to his personal email ID that was discovered on the next day, that is on May 29th. On May 29th itself, I have voluntarily handed over my laptop, my mobile phone, and my Google Mail user ID credentials. Now, complaint is filed on September 24th, 2020. No preliminary inquiry is done. FIR is registered on the same day.
For what offense are you saying preliminary inquiry should be done?
420 is alleged cheating.
All right.
Okay. Next, on October 15th, I'm issued a termination letter. On October 22nd, a civil suit is filed wherein an order of injunction is granted restraining me from disclosing any company confidential material to any third parties.
All right.
Now, the fact that a civil suit has been filed after the complaint, the allegations should be the same in both the complaint and in the plaint. Now, my lords, I'll walk through the embellishments that have been made in the complaint to make out the necessary ingredients of offenses under the IT Act and of cheating. Kindly come to page number 158, my lords.
Objections are filed?
Yes, my lords.
Summons issue agilla. We are at the stage of not even source statement is recorded. He comes before this court.
One moment, sir.
My lord, let me put it in just two
Is
or
it
three
correct?
sentences. Just 2 or 3 sentences. I am the informant to the police.
Yes.
I am his former employer. That he would stealthily remove certain confidential and proprietary
All right.
information. He would apologize to us and give us a letter also. I'm sorry, this is what has happened.
All right.
But the policeman, upon completion of investigation, would submit a B report to the court saying that nothing is found in his laptop. It has been erased. They ought to have probed further into the matter and got it retrieved and all that.
That's pending before the court.
No, but the Learned Trial Magistrate would reject the B final report and would take cognizance of the offence and would post a matter for recording of sworn statement.
That is
We are
not
at
yet
that stage.
happened.
Not even sworn statement is recorded. It is premature.
My contention is that this is primarily a civil dispute. I'll walk through the specific embellishments that have been made in the complaint vis-a-vis the plaint, my lords.
Let the magistrate do something.
Even that there is flaw in the order of taking cognizance. If I may point out, kindly come to page 71, my lords. Please come to page 71, my lords.
All right, you.
May I read out, my lords?
Our objections ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ. I've gone through the objections. I'm ready.
I have not gone through. Yes.
Sorry.
Let's see. This has come up in orders. We'll take it another days. Yes, list the matter on 19th in the fresh matters list.
He would question the order of taking cognizance and rejection of B report. How could he do it, my lord? He has not even been summoned before the court. But certainly an accused can question the order of taking cognizance in the event of there being a prohibition imposed upon the court for the purpose
Now,
of taking.
after taking of cognizance, sworn statement is recorded.
Not recorded.
No, 1 minute. Sworn statement is recorded. Would the court close the complaint?
No.
No, they will
It
issue.
has got to pass an order under
No,
204.
issue 204 order ಆಗ್ಬೇಕು.
It is
Prior to 204, it cannot be said that there is no right under 482. We'll see. Yes.
Great.
List on 19th in the fresh matters list.
Grateful.
60? 58 needful done anta. 58 learned counsel submits needful has been done. Office to verify. Next.
59.
Same order. Same order.
61.
For the petition, but the respondent is served. now.
Post immediately after service of notice upon the
No,
second.
she is present in this court. And I have produced the copy.
What copy?
For the, there's a petition.
You're
for the-
you're appearing?
For the respondent number 3, 6 and 11, my lord.
1 minute, sir.
Which one is it? 61.
498, yeah.
Please, my lord, 493 and 4 of the.
Who are you?
Lord, I am the
Husband?
husband, please.
Yes, sir.
No, I just,
Settlement.
ಅದರಲ್ಲಿ
Settlement.
marriage dissolve ಆಗಿದೆ.
ಹಾ.
I mean, dowry has been, I mean, permanent alimony is settled now.
Hmm.
Now they have said that I have no objection that, I know, I'll come before the court and see that matter being passed.
Where is the settlement?
I just produced it along the copy and the certified copy is now produced. And in, Lord, seal number 145.
One?
My lord has granted, in seal number 145, it's listed today. In this matter, interim order is granted by my lords. This petition is by father-in-law and.
So are we disposing both the petitions
See,
now
one-
by
the same,
account of a settlement?
It's on the same,
Excuse me, my lord. By mistake, I have appeared, I have another serial number, my lord. In the not case.
But who is appearing for the,
not,
she's the wife?
please, Lord, she is before the
Who's
court.
appearing for her? Not there? The matter is settled and closed?
Yes. This certified copy I've produced it, my lords.
Where?
That is the one now which I've handed out to my lords. Compromise petition as well as the order of the Honorable Family Court judge.
Madam, 498. ಇಲ್ಲಿ ಇದೆ, flag ಹಾಕಿದ್ದೀನಿ. Same, ಅಷ್ಟೇ.
The same crime.
145 is by whom?
By, my lord, the father-in-law, mother-in-law and the,
Who is the petitioner there?
there the petition again, the respondent before now, my lords.
No, the same complainant.
Yes, my lord, same complainant.
Who appears for the petitioner?
Now, I appear for the petition both the
ಅದರಲ್ಲೂ
cases.
ನೀವೇನಾ?
Please,
All
my lord.
right, same, 145 also. Respondent counsel is not there, ಅಲ್ಲೊಂದು ಬರ್ದ್ಬಿಡು. Respondent complainant has appeared before the court and accepts that the matter has been settled in the family court and no objection to close these proceedings on account of the said settlement before the family court. That's it. please.
Connected matter lawyer.
145 counsel ಇದರಾ?
I am appearing for the petitioner.
Respondent ಗೆ.
Respondent counsel idare, but, madam,
That's all right, you can do it. You tell your counsel.
okay.
Thank you.
Yes.
Madam, sign this.
Come on. $62.
2.
A week's time to comply with the post immediately after service of notice upon respondents 3 to 5.
Yes, sir.
Next.
My lord, I am appearing from 62.
ಇದರಲ್ಲಿ ನೀವಾ?
Yes, sir.
ಯಾರಿಗೆ?
Respondent number 2, 6 and 11.
2, 6 and?
11.
Learned counsel so and so submits that he has entered appearance for respondent 2, 6 and 11. Registry to print the name of so and so as appearing for respondent 2, 6 and 11. List after 2 weeks. Enter ಮಾಡಿದ್ರೆ continue ಮಾಡಿ.
63.
Point number 2, my lord.
Hmm.
In both the matters. in 63, my lords, it's the,
Post immediately after service of notice upon the second respondent remote ಉಂಟಾ?
I'm the respondent number 2, my lords, in both the matters. I
A
filed
registry to print the name of case Ponnappa is appearing for the respondent in 63.
And 63.1 also.
ಅದು already ಇದೀರಾ? So and so.
I'm ready, my lords.
Ready? What's the matter?
Lords, the first division assistant and the sub-register have approached this court saying that they've only registered a document, they have no part in it. The allegations, my lord, are at
All right. Wednesday in the fresh matters list, 18th. Interim order subsisting shall continue till the next date of hearing. Yes, next.
64.
Office objection in, sir.
Officer, compare this.
ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ? A week's time is granted to comply with the office objections, finally. Interim order, failing which the interim order subsisting would stand vacated. Subject to the aforesaid condition, the interim order subsisting shall continue till the next date of hearing.
Kindly extend the interim.
ಅದೇ ಮಾಡಿದ್ದು. Kindly comply with the office objection.
Foxco case, my lordship, on 20th it may be.
ಇದು ಸೆಟಲ್ಮೆಂಟಾ?
Yes.
ಏನಂದ್ರಿ?
Foxco case, my lordship.
ಏನಂದ್ರಿ?
Foxco.
Yes.
ಮದ್ವೆ ಆಗಿದೆ.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ. ಲಿಸ್ಟ್ ಆನ್ 20th.
65.
Post immediately after service of notice upon the second respondent. Interim order ಉಂಟಾ? ಇದೆಯಾ?
My lord, my lawyer advocate is not here actually because we need to hire a lawyer. So.
No, the advocate's name. Who is your advocate, madam?
Need to hire one.
All right, I'll give you 2 weeks' time.
My request, so we need government lawyer.
Then you'll have to approach the legal service authority, madam. I'll take it after 2 weeks. You approach the legal service authority in the meantime. Yes. 1 minute, sir. The respondent has appeared in person and would submit that she would approach the legal service authority for assistance of a counsel. List this matter on 24th. By then you do it. List the matter on 24th. Interim order subsisting shall continue till the next date of hearing. Next.
66.
Two weeks to comply with the office objections. Post immediately after service of notice upon the first respondent. Interim order.
For petitioners, yes, my lord.
A week, hello, madam.
Pencil.
Yeah.
4 and 6 of Foxco Act, my lord. Petitioner with him. They are
Settlement,
got back. Yes, my lord.
20th, list on 20th. Yes, next.
69.
Office objections. Same.
Not furnished the order sheet of the 30th of 19/20/24 till 31.
Office objections overruled. Post the matter in the fresh matters list on Tuesday. Yes.
Serial number 67, my lords. Serial number 67.
So?
ಅಲ್ಲ, 68 ಗೆ appear ಆಗಿದೆ.
ನೀವು 67 68 ಸರ್?
ಈ serial number 67, my serial number 68.
67. Post immediately after service of notice upon the second respondent. ಅದೇ order. Yes. ನೀವು ಹೇಳಿ ಸರ್ 68 ಏನು?
So, my lord.
ಅದು 20th, list on 20th. 69. Shrikant. Yes, office objections ಏನು?
Well, it's complied with all the objections except for filing of the certified copy of the charge sheet of the
ಮಾಡ್ಬಿಡಿ.
FIR and the complaint. Well,
List on
difficulty
Tuesday
is this.
in the fresh matters list in the event office objections would stand complied.
If I can submit. The difficulty is this, the petitioner, who is the president of a housing society, crime against him has been fastened against as against 406 and 420 minutes.
I'm not hearing it on merit, sir.
Minutes, they have notified my employer also minutes. They have notified
List
the
on,
postal department.
list on Tuesday in the fresh matters list in the event. Last time ಅದೇ order ಮಾಡಿದ್ದೀನಿ, I'll dismiss it. In the event the office objections would stand complied. Yes, next.
71.
It is not generated.
Huh?
It is not generated.
Overruled Tuesday, fresh matters.
Thank you.
72.
2 weeks time is granted to do the needful. Respondent.
For petition.
ಆಯ್ತು, yes. Entry order ಇದೆಯಾ?
Interim order ಇದೆ.
Continue, yes, next. ಶಾಂತಿ ಭೂಷಣ್.
23.
Post immediately after service of notice upon the respondent, interim order subsisting shall continue to the next date of hearing. Next.
4.
Current counsel submits needful has been done, office to verify. List after 2 weeks, IO. Next.
25.
Post immediately after service of notice upon the respondent, interim order subsisting shall continue to the next date of hearing.
76.
76 first time matters coming up.
First time either.
Time ಬರ್ತಾ ಇರೋದು, but in all fairness, this matter was, petition was filed earlier at the stage of FIR. Your lordship.
Then give it. Yes.
And passed an order, my lord, saying that this is even though it's civil in nature, it's a case for trial and therefore dismiss the petition. Now, my lords, we're on a very limited aspect. Charge sheet has now been filed. Now, why we're approaching your lordships once again is the charge sheet, my lords, is at page 525. It relies upon an FSL report. The offenses, my lords, are largely 420 and 464. 464 is regarding forgery and so on. My lords, may kindly see the FSL report.
This is that Prasanna Kumar had appeared for the respondent.
I think
Where is my order?
Your lordship's order is that the operative portion, my lords, will find at page 367. 367, 368. A brief background of facts, my lords. Now, the petitioners before your lordships today are the purchaser of a property. The owner says that I was never there when the sale deed was registered. It was purchased on the basis of a power of attorney. He says, I was not there. Those are not my signatures. That is the crux of the complaint, my lords. Now, charge sheet has been filed. Now, my lords, may kindly see the FSL report. Now, since one of the main allegations is that
Page.
Starts at page 557, the relevant, I'm sorry, that's right, 557, the relevant portion at 560. (561), if my lords were to kindly see. Now, he has compared the signatures upon analysis at point number 2, my lords. The question signature, my lords, has at 561. The
All right.
question signatures K1 to K10. K1 to K10 are the complainant signatures.
All right,
And the specimen signatures marked so and so, that is the first petitioners,
all right.
are not comparable one another since they are different patterns of execution. The same thing is for 3 to 9.
All
Of course,
right.
one of them is not a petitioner, but the remaining are petitioners before my lords.
All right.
Now, on the basis of this, my lords, charge sheet is filed.
Hmm.
Now, since the one of the main allegations that the complainant says I was never there, my signature was forged. Now, the FSL report says the signatures put by the petitioners before my lords today, and the signatures on the the specimen signatures of the complainant, they are totally different. So the question of forgery, my lords, now, so when the charge sheet is filed, this should have been.
Anyway, that this is a matter of trial again. Not that I can accept this and close it. It may be an added circumstance.
Correct.
Yes,
I understand. I'm only on this limited aspect. Of course, there's one aspect possibly, I can't agitate this now, but at the time, the first.
Anyway, yes, Shota sir is here only. We'll ask him to take notice. I mean, like the advocate on the side. Never appear I did last time. On the earlier occasion.
You were in.
Now you cannot take notice. Yaridru is. Who was the counsel on record? Serve on him, we'll see.
We'll serve on him.
Yes. Counsel for the petitioner to serve set of papers upon the counsel.
Akash Rao. Anish.
Counsel who represented the respondent complainant in the earlier proceedings. We'll take it on Thursday next, list on Thursday next.
Right.
Fresh matters list. Yes.
77.
Beyond dispensation.
For the petitioner, my lord. Pass over, my lord.
Pass over.
Seniors engaged in the other court, my lord.
13-1, 13-2, list on 20th. Yes.
78.
Tahir, ಬಂದಿದ್ಯಾ?
I was expecting disposal, lordship.
Yes, sir.
Senior Lords, for the special bench.
ನೀವು ಹೇಳಿ. I have heard you.
Lord, seniors before the special bench. 4 o'clock he'll come.
ಆಯ್ತು 4 o'clock ಬರ್ತೀನಿ. Yes. Next.
Lordship, IA order, IA may be disposed of.
Delay.
Delay.
ಬಿಡ್ಲಿ ಅವರೇ. Let him come. ಐಎಗೆ ಕೊಲಿಗೂ ಮೇನ್ಗೆ ಸೀನಿಯರ್ ಯಾಕೆ? ಎರಡು ಒಟ್ಟಿಗೆ ಬರ್ತೀವಿ. Next. ಐಎ ನಾಟ್ ಪ್ರೆಸ್ಡ್. ಸ್ಟೇ ಬೇಡವಾ?
No, I'm ready, my lord, but what they said was they wanted to settle. Our client said.
Settle.
Anta ಹೇಳ್ತಾ ಇದ್ರು, but I don't know if, they also say some, in fact, they have mail, there is a mail issued from them. It's okay, where they said that some terms are given, but I'm ready to argue also, if my learned friend says so. But
Yes,
if
sir.
it is to be always resolved, it is good. That is my,
A short date, my lords.
Settlement,
ಗೊತ್ತಿಲ್ಲ
ಗೊತ್ತಿಲ್ಲಲ್ಲ. I'm sorry, no, not ಗೊತ್ತಿಲ್ಲಲ್ಲ. You have not been instructed, your clients are regularly in touch.
ಅಲ್ಲ, when I say ಗೊತ್ತಿಲ್ಲ, ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ
ತಮಗೆ
ಅಂತ
ಗೊತ್ತಿಲ್ಲ ಅಷ್ಟೇ, because
ಹೇಳಿ ನಾನು.
No, ಅಷ್ಟೇ. No, it should not be that, Lord, that with this criminal petition, they are trying to settle. I'm ready to argue, not it's purely a civil dispute, but I honestly feel that when the clients not, they have shown interest to settle it, we should encourage them, only for that purpose.
we will encourage
Short date, my lords. Date will be short.
by granting a short date.
Tuesday, Lords, is my habit.
Tuesday ಆಗಲ್ಲ, Wednesday or Thursday.
Wednesday.
We'll take it on Wednesday.
Please.
Yes, less the mat, heard the learned senior counsel Prabhulang Nawadgi appearing for the petitioner and the learned senior counsel Sandesh Chowta representing the complainant. The learned senior counsel would submit that the petitioners, the complainant and the petitioners are in talks of settlement. List on, therefore list on Wednesday in the fresh matters.
They don't come to around any agreement, no, we'll argue
Yes,
the matter.
that
Please
is
pray.
obvious.
No, I'm just.
Don't take too long. Complaint ಓದಿದ್ರೆ ಆಯ್ತು, my lords. Both will be on the same footing. Please.
ಏನು same footing ಅಂದ್ರೆ?
Say, other than the complaint, nothing else to be read, my lords, whether it makes out a case of breach of trust or not. That's it, my lords. That's the bottom line.
Please.
Whether it is breach of trust or speech of trust. We'll see.
I'm not, I'll be in a
No, just
position.
a
to- No,
lighter
but
way
no,
it
it's,
ನಾನು
ಇಷ್ಟೇ ಹೇಳ್ತಾನೆ. If settle.
serious ಆಗಿದೆ.
ಸೆಟಲ್ಮೆಂಟ್ ಆದ್ರೆ ಯಾವತ್ತು ಒಳ್ಳೇದಂತ ನಾನು, that's my.
ಅದು ಕರೆಕ್ಟ್, ಬಟ್ ಅದು ಹೇಳಿದ್ದಕ್ಕೆ ನೀವು ಸೀರಿಯಸ್ ಆಗಿ.
ಇಲ್ಲ, I'm not serious on it. I'm not
It was in
serious.
the lighter ways.
Yes.
ಇಲ್ಲರ ಲಂಚ್ ಡೈಜೆಸ್ಟ್ ಆಗಲ್ಲ.
I'm not serious. Sorry.
ಹೌದು. Yes, sir.
Admission number 80.
The petition. 38 proceedings.
ಒಂದು ನಿಮಿಷ, ಒನ್ ಸೆಕೆಂಡ್. ಥರ್ಡ್ ಲಿಸ್ಟ್ ಒಂದು ಮ್ಯಾಟ್ರ್ ಇತ್ತಲ್ಲ ಮೇಡಮ್.
Number 3.
ಅಲ್ಲಿ nobody is there. ಬಸವರಾಜ್ ಸರ್, ಲಿಸ್ಟ್ ನಂಬರ್ 3 ನಿಮ್ದು.
Dictation.
ಹಾ, ಎಲ್ಲಿ ಇವರು ಪೆಟಿಷನರ್ಸ್ ಯಾರಲ್ಲಿ? ಐ ಹ್ಯಾವ್ ಹರ್ಡ್ ಇಟ್. ಡಿಕ್ಟೇಟ್ ಟೈಮ್ ಆಗಲ್ಲ, ಅಲ್ಲಿ ರಿಸರ್ವ್ ಇಟ್.
Yes.
ಉದಯಹೊಳ ಸರ್ಗೆ ಹೇಳಿ, ದೇರ್ ಇಸ್ ಎನಿಥಿಂಗ್
I shall inform.
ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬೇಡಿ ಅಷ್ಟೇ. ಎಸ್, ರಿಸರ್ವ್ಡ್ ಅಂತ ಹೇಳ್ಬಿಡಿ. ಎಸ್, ಹಾ, ಈಗ ಕರೆ.
Admission 80.
I have the petition. Out of 138 proceedings. Lord, the check pertains to a company. Lord, the company is not made a party.
Where is the checks?
Lord, the check is at page number 19.
Huh?
19.
19. For Manikya Spirits and Breweries.
Yes, ma'am. Private limited.
It's a company or
The
partnership?
company, my lord, I produced that document also.
Which?
It's at page number 49. Certificate of incorporation.
49.
Yes, ma'am.
All right.
Page 12 you will have to find.
Of what? Petition.
Petition. What my learned friend say, my lord, the company is shown there. The caste title itself.
Huh?
Caste title itself is shown.
You want your case to be dependent on the cost title?
ಕಂಪನಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರು,
ಹಾ,
ಅದಕ್ಕೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ
ಮಾಡಿದ್ದೀರಾ?
ಆಯ್ತು, ಅದೇ ಪೇಜ್ ನಂಬರ್ 12 ಅಲ್ಲಿ ಇದೆ ಅಲ್ಸೋ.
ಸುನಿಲ್,
ಬಾಟಮ್
ಎಲ್ಲಿದೆ ಕಂಪನಿ?
ಅದೇ ಕೆಳಗಡೆ ಬಾಟಮ್
ಅಲ್ಲಿ ಸುನಿಲ್ ಕುಮಾರ್ ಅಂತಿದೆ.
ಸುನಿಲ್ ಕುಮಾರ್ ಕೆಳಗಡೆ ಮಾಣಿಕ್ಯ ಸ್ಟ್ರೈಟ್ಸ್ ಅಂಡ್ ಬ್ರಿವರೇಜಸ್ ಪ್ರೈವೇಟ್
ದಟ್ ಈಸ್ ಸುನಿಲ್ ಕುಮಾರ್.
ಅದೇ ಸ್ವಾಮಿ, ಅದನ್ನ ತೋರಿಸಿ ಕಂಪನಿನೂ ಅಲ್ಲಿ ಹೇಳಿದ್ದೇವೆ ನಾವು, ಕಂಪನಿ ಇದೆ ಅಂತೇಳಿ.
No, you should make the company as independent accused.
ಇದೆ
ಇಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲ the situation is so complex is coming up. Now, it is not that totally, it's not given up. The company is shown as one of the parties there.
Where?
ಅಲ್ಲ, ಸ್ವಲ್ಪ ಒಂದ್ ನಿಮಿಷ. ಈ ಕಾಸ್ಟ್ ಗೆ ಅವರು ಹಾಕಿದಾಗ ಇದನ್ನು ತೋರಿಸೇ ಇಲ್ಲ
ಕಾಸ್ಟ್ ರೇಟ್ಲು
ಪಿಟಿಷನ್ ಅಲ್ಲಿ. ಅವರ ಪಾರ್ಟಿ ಹೆಸರನ್ನ ಪಿಟಿಷನ್ 1 ಅಂತ ಹೇಳಿ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಕ್ಯೂಸ್ಡ್.
ಹೌದು ಸರ್,
ಸೋಲ್ ಅಕ್ಯೂಸ್ಡ್ ಅಲ್ಲಿ 1 ಅಂತ ಯಾಕೆ ತೋರಿಸ್ಬೇಕು ಅವರು?
ನಮ್ಮ ಹೆಸರು ಇದೆಲ್ಲ ಇದ್ದಾರೆ ಅಂತ ಹೇಳೋದನ್ನ ಕಾಸ್ಟ್ ರೇಟ್ ಇಲ್ಲ ಅಂತ.
ಸರ್, ಎಂ ಗೋಪಾಲ್ ಇಸ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್. ಹೌದಾ? ಸುನಿಲ್ ಕುಮಾರ್ ಇಸ್ ದಿ ಅಕ್ಯೂಸ್ಡ್.
ಕರೆಕ್ಟ್.
You describe him as director of some so and so. The company is not a party.
ನಮ್ಗೆ ಸುನಿಲ್ ಕುಮಾರ್ ಡೈರೆಕ್ಟರ್ ಅಂತ ಹೇಳಿ ಕಂಪನಿನ ತೋರಿಸಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಿದ್ದೇನೆ. ಅಲ್ಲ, ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಇಟ್ಸ್ ನಾಟ್ ದಟ್ ಟೋಟಲಿ ಗಿವನ್ ಅಪ್ ಅಂತ ಹೇಳಿದ್ರೆ ತಮಗೆ.
This is what is considered in Godfather.
ತಮ್ಮದೇ ಆರ್ಡರ್ಗಳಿವೆ.
ಎಷ್ಟೋ ಇದೆ
ನೋಡಿದ್ದೇನೆ. ಸೊ ಹೊಸದಾಗಿ ಒಂದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಏನು ಬದಲಾವಣೆ ಆಗಿದೆ. ಕೆಲವು
ಏನ್ ಬದಲಾವಣೆ ಆಗಿದೆ?
ಅದನ್ನ ಮೊನ್ನೆ ಹೇಳಿದೆ ನಮ್ಮ
ಕಂಪನಿ ಬೇಕಾಗಿಲ್ಲ ಅಂತ.
ಬೇಕಾಗಿಲ್ಲ. ಎನಿ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಯು ಕ್ಯಾನ್ ರೇಸ್ ಇಟ್ ಅಂತ ಹೇಳಿ ಅಗೇನ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿ ಒಂದು ತೋರ್ಸ.
ಫೈಲ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಅಂಡರ್ 319.
ಅದನ್ನೇ ನನಗೆ ಅವಕಾಶ ಕೊಡ್ಲಿ.
ಅದು ಅವಕಾಶ ಇದ್ದೇ ಇದೆ. ಇಫ್ ಯು ವಾಂಟ್.
ಅದೇ ಅವಕಾಶ ಕೊಟ್ಟರೆ ನಾನು ಐ ಫಿನಿಶ್ ದಿಸ್ ಬಿಕಾಸ್ ನಾಟ್ ದಟ್ ಐ ಹ್ಯಾವ್ ಕೆಪ್ಟ್ ಇಟ್ ಸೈಲೆಂಟ್ ಆರ್ ಇಗ್ನೋರ್ಡ್.
It is tacit silence. Spirits and breweries.
138.
ಎಷ್ಟು ಕೊಡ್ಬೇಕು?
ಅವ್ರ ಪ್ರಕಾರ ಪ್ರಾಪರ್ಟಿ ಮಾರೋದಕ್ಕೆ ಅಂತ 70 ಲಕ್ಷ ತಗೊಂಡಿದ್ರು.
ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ವಾಪಸ್?
Malad, the property does not belong to me. I was only an agreement holder from the landlord.
Why did you issue the check?
Malad, that's what in the police station they register a FIR. In the police station they take the complaint, checks.
Which FIR?
Malad, at crime number.
ಚಾರ್ಜ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಇಂಪರ್ಸನೇಟ್ ಮಾಡಿದ್ದಾರೆ.
And Sarjapur crime number 28 of 2021.
ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಕ್ರೈಮ್
ಮಾಡ್ಬೋದು. ಇದ್ರಲ್ಲಿ ನಾನು 139 ಕೆಳಗಡೆ will have ಅವಕಾಶ ಮಾಡಿ ಕೊಟ್ಟರೆ
139 ಅಲ್ಲ 390.
ಸಾರಿ, the later judgment says so.
Yes. Where?
ತಾವು ಹೇಳಿದ್ರಲ್ಲ
ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
ಮೇಡಮ್
ಅದ ಹರ್ದೀಪ್ ಸಿಂಗ್ ಕೊಡ್ಬೇಡಿ
ಸ್ವಾಮಿ.
ಡೋಂಟ್ ಗಿವ್ ಮಿ ಹರ್ದೀಪ್ ಸಿಂಗ್ ನಾವು.
ಇಲ್ಲ, ಇದು MPP ಟೆಕ್ನಾಲಜೀಸ್
ಕೊಡಿ.
ಅದರಲ್ಲಿ several cases have been taken into account, not one.
Give it.
ಮೇಡಮ್ ಕಾಪಿ ಇದೆಯಾ? ಕಾಪಿ ಮಾಡಿ. Some new developments are coming up. ಅದಕ್ಕಾಗಿ ನಾನು ಇನ್ನೊಂದು ದಿವಸ ಅದನ್ನ ಅಪ್ರೈಸ್ ದಿಸ್ ಇಶ್ಯೂ.
ನನ್ನ ಆರ್ಡರ್ ನನಗೆ ಕೊಡ್ತಾರೆ. That is 319. Yes.
Sorry.
Their proprietorship concern was not made an accused.
Correct.
But proceedings were pending there. At that time, an application was filed. Permissible.
But in the company, Malad, the no notice was issued to the company.
That has to be now made. Look into the judgment and compass. Let me see. There is one more judgment where that is not a curable defect.
Yes.
319 bere. Other than 319, you can't, it's not a curable one. We'll list it on Tuesday. On Tuesday in the fresh matters list ಹಾಕಿರಿ. List on Tuesday. ಅದು ನಾನೇ ಕೊಡ್ತೀನಿ. Yes, both. Intermodal ಇದೆಯಾ? Intermodal subsisting shall continue till the next date of hearing. Next. Whereas
81.
There are petitioners in this case.
intermodal ಇದೆಯಾ? Intermodal ಇದೆಯಾ? Charge sheet is filed. How?
Subsequent tag, because after filing of the charge sheet, all the proceedings have been stayed by this.
No, that's all. Charge sheet challenge ಮಾಡಿರೋದಾ? Madam, what is this? Correct. List
Subsequently,
after-
is furnished that along with this memo.
All right, list after 4 weeks, interim order subsisting shall continue till the
Only
next
one
date of hearing.
submission. One submission. The agreement of sale was entered on 2013. The
Ah.
complaint was registered in 2022. my lord. In respect of that agreement of sale, already a suit has been filed, 2402 of 2016.
Let the
annexed date
respondent,
65.
respondent comes. Yes, stay ಕೊಟ್ಟಿದೆ.
Next week.
Continue ಆದ್ರೆ ತಗೋಣ. Yes,
As per in 2013 agreement ಗೆ 2022 ನಲ್ಲಿ ಕೇಸ್ ಹಾಕಿ.
ಅದಕ್ಕೆ stay ಕೊಟ್ರು.
82.
Rejection of B report, my lords, and taking of cognizance. Now, the incident has taken place in January 2021, my lords. A drug inspector and his team would come to the place of business of the petitioner. Allegation is unparliamentary words were used against them. They get the FIR registered, investigated, B report filed, placed before DYSP, approval taken. When it is placed before the court, my lords, the order passed by the court, my lords, there's no, my lords, the B report is not rejected, straight away cognizance taken. The impugned order, my lords, we have produced it along with a memo, my lords. So Ravi Kumar's case is directly applicable to this, my lords. My lords, has a memo dated 30/11/2022, my lords. The order
30/11.
impugned is at page 18.
Who is the complainant?
My lords, complainant is the drug inspector.
ಇವರೇ ಅಲ್ಲ.
ಹೌದು. ಈಗ ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ, my lords,
ಹಾ?
They filed in individual capacity.
ಎಲ್ಲಿ ಯಾರು ಹಾಕಿದ್ದಾರೆ?
ಅವ್ರ ಇನ್ಸ್ಪೆಕ್ಷನ್
SPP for R2, HCGP for R1.
ಈಗ ಆರ್ಡರ್ ಒಂದು
Drug
ನೋಡಿದ್ರೆ,
inspection.
my lords, ಆರ್ಡರ್ ಒಂದು ನೋಡಿದ್ರೆ ರವಿ ಕುಮಾರ್ಸ್ ಕೇಸ್, my lords. Order, my lords,
Page, sir.
page 18 ಅಲ್ಲಿ, along with the memo which we have produced. my lords. The reasons, my lords, would get at page 21.
ನಿಮಿಷ.
Sorry. This is a memo dated 30/11/2022, my lords.
ಹಾ.
ಅದರಲ್ಲಿ, my lords, page 21 ತಾವು ನೋಡಿದ್ದೇವೆ. Reasons ಅಂತ ಹಾಕಿದ್ದಾರೆ. B report is not rejected. And cognizance taken.
The petitioners,
Petitioners, my lords.
petitioners are before this court calling in question proceedings in CC 1041 of 2022. Calling in question an order dated 1/7/2022 passed in CC 1041 of 2022 by which the learned magistrate would take cognizance of the offense on rejection of the B report. They heard the learned senior counsel Sandesh Chowta appearing for the petitioner and the learned additional SPP. The second respondent, Inspector for Drugs, Bangalore, is the complainant. A complaint comes to be registered on an allegation that springs on 4/1/2021. The allegation is that when the Inspector of Drugs, the second respondent, would inspect other,
ಹೌದು, he comes to the premises, Ayur
would
Park Healthcare
inspect
Center.
the premises of the petitioners. The petitioners have spoken, have picked up a quarrel and used abusive language against the complainant. Based upon this incident, based upon the complaint, a crime in crime number 3 of 2021 comes to be registered for offense punishable under section 353(504), read with 34 of the IPC. The police conduct investigation and file a B report before the concerned court on 12/8/2021. 2021. The protest petition ಹಾಕಿದ್ರಾ?
ಹೌದು, British
The
petition on
second
16th.
respondent complainant is said to have filed a protest petition on the B report so filed by the police on 16/10/2021. The concerned court takes cognizance of the offense, appearing to be rejecting the B report, and issues summons to these petitioners. It is this that has driven the petitioners to this court in the subject petition. The learned senior counsel would submit that would take this court to the order passed on the B report to contend that it is in blatant violation of the law declared by this court in the case of Ravi Kumar versus KMC so and so, reported in ILR 2018 Karnataka 1725. The learned senior counsel would further contend that there is that even on the merit of the matter that there is no case made out for an offense punishable under section 353, and the police had rightly filed a B report on the investigation so made. Per contra.
Is 27, my lord. B report. Last pair.
27.
Last pair. ದಿನಾಂಕ 15/5/20.
ದಿನಾಂಕ
15/5/2021.
Which petition page 27?
Yes. B report, man.
ಏನ್ ಕಂಡು ಬಂದಿಲ್ಲ. Yes, so and so. Per contra, the learned additional SPP would defend the action of the police filing a B report. He would take this court to the contents of the B report that is placed before the concerned court, but would submit that in the event cognizance is now taken, that will go on in the court then, would defend the action of the police in filing the B report and leave the order to the hands of the court. The second respondent again, madam, separate.
I think there is a
Protest petition separate ಆಗಿ ಹಾಕಿರೋದ್ರಿಂದ
I will have to say, my lord, that this statement.
But my lord, I think state is representing the drug inspector.
No, he has filed the protest petition separately in his independent capacity.
No,
But probably as a drug, my lords, what happens is he inspects as a drug inspector,
No,
not in
true.
his individual capacity at all.
PO is issued to represent.
To represent ಆಗಿದೆಯಾ? Sorry. The learned additional SPP would however contend that the respondents have hurled used abusive language upon the second respondent inspector of drugs at the time of inspection of the property, and therefore would contend that it's a matter of trial for the petitioners to come out clean, as the offense is stopping a public servant from performing his public functions. I have given my source. The aforenarrated facts are not in dispute. The incident that leads to registration of the crime is as narrated herein above. The crime is investigated into, and the police, after investigation, file a B report. On the B report, the protest petition is preferred by the second respondent. And on the protest petition, the concerned court passes the following order, page 21 and 22 of the flag agreement. Pass the following order. The order, a perusal at the order would fly foul of the order passed by the coordinate bench in case Ravi Kumar so and so reported to and so on. Paragraph 5 extract. The coordinate bench has clearly held postulates of consideration of a case where a B report is filed before a concerned court, and the concerned court would take cognizance of the offense on rejecting the B report. The 5 postulates that are laid down are all given a go by the learned magistrate in the case at hand. Therefore, the order that rejects the B report and takes cognizance of the offense is rendered unsustainable. On the merit of the matter, the submission of the learned additional SPP in support of the allegation of the complainant is again unsustainable, for the reason that while filing the B report, the observation of the police is as follows. Page 27, marked portion. The recording that was made by one Shiv Kumara.
Shiv Kumar.
The recording that was made by one Shiv Kumar was examined at the time of investigation, which clearly indicated there is no abusive language used nor abuses hurled against the second respondent complainant. Therefore, the submission of the additional SPP that the petitioner should come out clean in a full-blown trial is unacceptable, as the offense laid against the petitioners is the one punishable under Section 353 of the IPC. The Section 353 would require use of criminal force by the accused upon the public servant, which would stop or deter him from performing public functions. This is not the allegation, that is not the evidence. Therefore, remitting the matter back to the hands of the concerned court to pass appropriate orders on the B report would be of no avail in the light of the ingredients not meeting the charge. Therefore, I deem it appropriate to obliterate the crime itself against these petitioners. For the aforesaid reasons, the following order allowed quashed.
Please, my lords, Ravi Kumar, it's 7 postulates, my lords, 5
Five
ಇದೆ,
ಅಲ್ವಾ?
7 ಇದೆ.
All right.
Obliged.
1725 then.
ಹೌದು, correct.
Para 5.
Para 5, in that 7 aspects, I believe.
Yes. Next.
83.
For petitioners in this case.
Vacating stay ಯಾರು ಹಾಕಿದ್ದಾರೆ?
Respondent number 2.
State
State, my lord. There is
ನೀವು
no
ಹಾಕಿದ್ದೀರಿ?
representation from respondent number 1 from
Sir,
past 6 years.
one is state, sir.
ನಮ್ಮವ್ರು ಹಾಕಿದ್ರು.
ನೀವು ಹಾಕಿದ್ದೀರಾ? ಸ್ಟೇಟ್ ಹಾಕಿರೋದು.
State.
ಎಸ್ ಎಸ್ ಸರ್. ಏನ್ ಒಫೆನ್ಸ್?
My lord, 465, 468, 471, 420.
Civil suit pending?
Please, my lord. My lord,
Civil suit by the complainant
my lord, there are multiple suits filed by both complainant
against
and
the
accused.
MOU.
Yes, my lord.
All right. Yes, government
Complaint, my lord.
heard the learned counsel appearing for the petitioner and the learned additional SPP. There is no representation on behalf of the second respondent. Awaiting his appearance, list the matter on 26th, list the matter on 1st October. Interim order subsisting shall continue till the next date.
Please, ma'am.
Yes.
84.
Not well. Kannadanews. Listen, oh, correct. Yes. Court notice, issue court notice in the light of the fact that the counsel representing the petitioner is no more. Notice hogli, party. Interim order subsisting shall continue to the next date of hearing.
85. ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಸೆಟ್ಲ್ ಆಗಿದೆ ಮ್ಯಾಟರ್.
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಸೆಟ್ಲ್ ಆಗಿದೆ.
ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆಯಾ?
ಸರ್ವ್ ಆಗಿದೆ.
ಸೆಟ್ಲ್ ಆಗಿರೋದು ಎಲ್ಲಿದೆ?
ಪೇಜ್ ನಂಬರ್ 27.
ಯಾವತ್ತು ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್.
28
ಒಂದು ಚಾನ್ಸ್ ಕೊಡು. ಲಿಸ್ಟ್ ಆನ್ 20th in the fresh matters list. Interim order ಇದೆಯಾ? ಏನಿಲ್ಲ. ಅವತ್ತು ಬರ್ಲಿ. Next, yes, Dhanesh. ಏನ್ 4 ಕೇಸ್ ಇದೆ?
In the sense, it is a case of.
ಏನ್ CCTV ಇದೆನಾ ಇದನ್ನು?
They are caught red-handed and he tried manipulating the thing by changing the IO by using his police powers. By 2 IOs he changed. Even then, his own department, considering the evidence on fact, on the case file, they have filed the charge sheet for me. And even none of the petitioners have filed entire charge sheet, but they are challenging the charge sheet. I have produced the certified copy of the charge sheet to your lordship last occasion.
All right. Yes, sir. Come on.
And everything is available on record. If you
Password.
Senior,
very time there, last time also it happened. Sir.
Don't worry. Wait. Yes.
Today
No passwords. ಅವರಿದ್ದಾರೆ ಮಾಡ್ತಾರೆ. ಪರವಾಗಿಲ್ಲ. ನಿಮ್ದು ಕ್ಯಾಮಲ್ ಕೇಳು. ನೀವು ಹೇಳಿ.
Tighten breath and come back. ತುಂಬಾ ಕಡೆ ಎಲ್ಲ ಇವತ್ತು ಇದೆ ತರ ಆಗುತ್ತೆ ಸರ್.
ಏನ್ ಮಾಡಕ್ಕೆ?
Sometimes it happens.
You're a very busy counsel, sir. ಏನ್ ಮಾಡಕ್ಕೆ? Yes, sir. No, ಅವ್ರ ಬಗ್ಗೆ ನೀವು ವರಿ ಮಾಡಿ. ನೀವು ಸ್ಟಾರ್ಟ್ ಮಾಡಿ. Yes. Yes, sir.
The allegation appears to be, my lord, little very
ಅವರು ಮೈಕ್ ಬಿಡಿ ಸರ್.
Complaint, my lord, at page 28.
Now petition remains only que petition number 2.
In my case. Only that.
In your case,
In my case,
your
it is
case ಅಲ್ಲಿ
It is not maintainable, sir. The other one.
ಯಾವ್ದು ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಅಲ್ಲ ಈ ಕೋರ್ಟ್
My
ಅಲ್ಲಿ.
lordship, only my
Maintainable.
respectful submission is they have played with the administration of justice by filing multiple petitions, suppressing the previous petition.
Yes.
There is a huge judicial
When
time
I-
has been wasted.
When I come to you, you can make your submission.
Please, my lordship, please.
ಹಾ ಎಸ್ ಕುಲ್ಕರ್ಣಿ ಸರ್ ಹೇಳಿ.
ಇವತ್ತೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ಬೇಕು.
ಹಾ ಅವ್ರದ್ದು ಪೆಟಿಷನ್ ಕೊಡಿ ಮೇಡಮ್.
86.2. Double it.
ಎಸ್ ಸರ್.
Lord, at page 61, my lords.
ಹ್ಮ್
Page 61. ಅವ್ರದ್ದು ಹೇಳಿಕೆ ಇದೆ ಅಲ್ಲಿ, ಅನುಪಮ ಅಂತ ಅವ್ರ ಹೇಳಿಕೆ ಇದೆ.
ಪೇಜ್ 61.
ಹಾ, page 61.
All
my lords. Para 1, my lords, I think in the middle of page. ಈ ಘಟನೆ ನಡೆದಿರೋದು ಸೆಪ್ಟೆಂಬರ್ 6ರಂದು ನಮ್ಮ ಲ್ಯಾಂಡ್ ಓನರ್ ಹೆಸರು ಯುವ ಶಿವಕುಮಾರ್ ಮತ್ತು ಅವರ ಮಗನು ಸಮಂತ್ ಆತನ ಸ್ನೇಹಿತರು 7 ಜನ ಸೇರಿ ಆ ದಿನ ಗಲಾಟೆ ಮಾಡಿರ್ತಾರೆ. ಆ ಹುಡುಗರನ್ನು ನಾನು ಮುಂಚೆ ಯಾವತ್ತೂ ನೋಡಿರಲಿಲ್ಲ. ನಾವು ಇರುವುದು 3ನೇ ಮಹಡಿಯಲ್ಲಿ, ಆರೋಪಿತರು 4ನೇ ಮಹಡಿಯಲ್ಲಿ ಅಕ್ರಮವಾಗಿ ಕಟ್ಟಿದ್ದು. ಆಗಸ್ಟ್ 25, 2020 ಬೆಸ್ಕಾಂ ರವರು ಕಟ್ಟು ಮಾಡುತ್ತಾರೆ. ಅದನ್ನು ನಾವು ಮಾಡಿದ್ದೇವೆ ಎಂದು ತಿಳಿದುಕೊಂಡು ಅವತ್ತಿನಿಂದಲೇ ನಮಗೆ MCB ಆಫ್ ಅಂಡ್ ಆನ್ ಮಾಡುವ ತೊಂದರೆ ಕೊಡುತ್ತಿದ್ದರು. ನಾವು 3 ರಿಂದ 4 ಬಾರಿ ತಿಳಿಸಿರುತ್ತೇವೆ. ನಮ್ಮದೇನು ತಪ್ಪು ಇರುವುದಿಲ್ಲ, ಬೆಸ್ಕಾಂ ರವರು ಮಾಡಿರುತ್ತಾರೆಂದು ಅದು ಅವರು ಮುಂದುವರಿಸಿದ್ದಾರೆ. 6ನೇ ತಾರೀಕಿನಿಂದ ನಾವು ಊಟ ಮಾಡಿ, ದಿಸ್ ಇಸ್ ದ
ಶ್ರೀಮತಿ ಅನುಪಮ
Is wife of my
your wife.
Yes.
All right.
6ನೇ ತಾರೀಕಿನ ನಾವು ಊಟ ಮಾಡಿ ಬಾಲ್ಕನಿಯಲ್ಲಿ, ದಿಸ್ ಇಸ್ ದ ರೆಲೆವೆಂಟ್ ಪೋರ್ಷನ್ ಐ ಥಿಂಕ್, ಬಾಲ್ಕನಿಯಲ್ಲಿ ಸುಮಾರು ರಾತ್ರಿ 11 ಗಂಟೆಗೆ ಕುಳಿತಿರುವಾಗ ಶಮಂತ್ ಮತ್ತು ಆತನ ಸ್ನೇಹಿತ ಗಲಾಟೆ ಮಾಡಿಕೊಂಡು ಕೆಳಗೆ ಬಂದರು. 2 ನಿಮಿಷಗಳೊಳಗೆ MCB ಯನ್ನು ಆಫ್ ಅಂಡ್ ಆನ್ ಮಾಡುತ್ತಿದ್ದರು. ನಾವು ಅವರಿಗೆ ಹೇಳೋಣ ಅಂತ ಮುಂದೆ ಮರದ ಬಾಗಿಲನ್ನು, ಮೆಟಲ್ ಗೇಟನ್ನು ಬಿಟ್ಟು ನಿಂತಿದ್ದೆವು. ಮೊದಲು ಒಬ್ಬ ಹುಡುಗ ಬಂದು, ಆತನ ಹೆಸರು ನನಗೆ ಗೊತ್ತಿರೋದು, ನೇಮ್ ಇಸ್ ನಾಟ್ ಮಾಡೋದು, ಮುಖ ತೋರಿಸಿರುತ್ತೇನೆ. ಆತನನ್ನ ಮಗನ ಸೈಕಲನ್ನು ಎತ್ತಿ ಕುಕ್ಕಿ ಜಪಗೊಳಿಸಿ ಮತ್ತೆ ಎತ್ತಿ ನಿಲ್ಲಿಸಿ ಹೋಗಿರುತ್ತಾನೆ. ಮತ್ತೆ 5 ಮತ್ತು 6 ಜನ ಬಂದರು. ಅವರ ಬಾಯಲ್ಲಿ ಕೆಟ್ಟ ಮಾತುಗಳು ಬಂದು, ಸೋ ಅಂಡ್ ಸೋ ಮುಂಡೆ ಸೋ ಅಂಡ್ ಸಮ್ ವರ್ಡ್ಸ್ ಆರ್ ದೇರ್, ಹೇಳೋದು ನನಗೆ ಕಷ್ಟವಾಗುತ್ತದೆ. ಅದರಲ್ಲಿ ಒಬ್ಬ ಹುಡುಗ ತನಗೆ ಖಾಸಿ ಅಂಗವನ್ನು ತಮಗೆ ತೋರಿಸಿದ್ದು ನಮಗೆ ಶಾಕ್ ಆಗಿ ಬಾಗಿಲು ಮುಚ್ಚಿಕೊಂಡು ಹೋದೆವು. ನಂತರ ಯಜಮಾನರು ಕಂಟ್ರೋಲ್ ರೂಮ್ ಫೋನ್ ಮಾಡಿರುತ್ತಾರೆ. ದೇ ಸೇಮ್ ಇನ್ಸೈಡ್ ದಿ ಗೇಟ್ ದೇ ಸೇಮ್ ದೇವರ್ ಎಲ್ಲಿದ್ದಾರೆ ಅಂದ್ರೆ ಮೊದಲು ಗೇಟನ್ನು ನೋಡಿ ಬಂದಿರುತ್ತಾರೆ. ಡಿಸ್ಟೆನ್ಸ್ ಲಾಟ್ ಡಿಸ್ಟೆನ್ಸ್ ದೇ ಆರ್ ನಾಟ್ ಏಬಲ್ ಟು ಶೋ ಅದು ವಾಟ್ ಆರ್ ಹ್ಯಾಪನ್ಡ್ ಅಂಡ್ ನಾಟ್ ನೇಮ್ಡ್. ಇವನ್ ಅದರಲ್ಲಿ ಒಬ್ಬನ ಹುಡುಗ ಅಂತ ಅಲ್ಲೂ ನಾಟ್ ನೇಮ್ಡ್ ಇದೆ. ಇನ್ಸೈಡ್ ಮೆಟಲ್ ಗೇಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. Therefore, there is one thing more. Secondly, my lords, there appears to be, my lord, as it is found from the other annexures, number of complaints are already filed. There appears to be, my lord, rival, there are daggers drawn. Iವರು ಮೊದಲಿಂದ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನೋ ಪ್ರಾಬ್ಲಮ್, ಇವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋದು ಬಿಡಿಸೋದು ಇದ್ದೇ ಇದೆ. Manifest is the first thing that is gone into, my lord. Records are already produced. The annexures are produced, which would show, my lord, number of complaints are already produced. ಬೇಕಾದಷ್ಟು ಕಂಪ್ಲೇಂಟ್ಸ್ ಮೊದಲಿಂದ ಇದೆ. ಎಷ್ಟೋ ಡ್ರಾಪ್ ಆಗಿದೆ, ಕೆಲವೊಂದು ಹಂಗೆ ಉಳಿದಿದೆ, ಕೆಲವೊಂದು FIR ಸ್ಟೇಜು, ಚಾರ್ಜ್ ಸ್ಟೇಜು, 6-7 ಕೇಸ್ಗಳಿದೆ. ಕಂಟಿನ್ಯೂಸ್ ದೇ ಹ್ಯಾವ್ ಬಿನ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಹಿಯರ್. ದಿಸ್ ಆಲ್ಸೋ ವುಡ್ ಗೋ ಶೋ, my lord, that the manipulation has been made, my lord. ಇನ್ನೊಂದು ಇದರಲ್ಲಿ
ಏನ್ ಮ್ಯಾನಿಪುಲೇಷನ್
ಅಲ್ಲ, ಮ್ಯಾನಿಪುಲೇಷನ್ ಅಂದ್ರೆ my lord made to say, my lord, that this has happened. ಆ ಗೇಟ್ ಅಲ್ಲಿ ಇವ್ರು ಇರೋದು ಎಲ್ಲಿ ಅಂತ ಓನ್ಲಿ ಆನ್ ದ ಬೇಸ್ ಆಫ್ ಅಲಿಗೇಷನ್ಸ್ ದೇ ಹ್ಯಾವ್ ಟು ಬಿ. ಆಮೇಲೆ ಪೇಜ್ 54 ಅಲ್ಲಿ ಮತ್ತೆ ಅದೇ ಬಂತಲ್ಲ, 161 ಸ್ಟೇಟ್ ಪೇಜ್ 54 ಮುಳ್ಳ ನೆಕ್ಸ್ಟ್ ಸಿ 25/8 ಶಿವಕುಮಾರ್ ಅವರು ನನ್ನ ಸಮಂತ ಸ್ನೇಹಿತರಾದ ಶ್ರೇಷ್ಠ ಅವರಿಗೆ ಜಯಸಿದ್ದವರವರು ಪ್ಲಾಟ್ ಬೆಸ್ಕಾಂ ಕಳಿಸಿಕೊಂಡಿದ್ದು ವಿದ್ಯುತ್ ಸಂಪರ್ಕವನ್ನು ಕಳಿಸಿಕೊಡುತ್ತೇವೆ ಎಂಬುದಾಗಿ ತಿಳಿದು ನಮ್ಮ ಮನೆ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ DP ಅನ್ನು ಅವರು ಉದ್ದೇಶಪೂರ್ವಕ ಆಫ್ ಮಾಡುತ್ತಿದ್ದರು. ನಾನು ಮತ್ತು ನಮ್ಮ ಯಜಮಾನರು ಹಲವಾರು ಏಕೆ ನಮ್ಮ ವಿದ್ಯುತ್ DP ಅನ್ನು ದಿಸ್ ಶೋಸ್ ಯಾಕೆ ಹಲವಾರು ಬಾರಿ DP ಅನ್ನು ಮಾಡುತ್ತಿದ್ದೀರಿ ಎಂದು ಪ್ರಶ್ನಿಸಿದಾಗ ಶಮಂತ್ ಮತ್ತು ಅವನ ಸ್ನೇಹಿತರು, ನೀವು ನಮ್ಮ ವಿದ್ಯುತ್ DP ಅನ್ನು ಆಫ್ ಮಾಡುತ್ತೀರಾ, ಅದಕ್ಕಾಗಿ ನಾವು ದಿಸ್ ಶೋಸ್ my lord there is a trust between them, my lord. There is quarrel fight. This has resulted into this complaint is the first thing. Number 1, my lord, there are other litigations, civil litigations, whatever it is, my lord. Construction, he has, my lord, he is able to secure from authorities. They say construction is not proper and all that. Those complaints, probably these fellows have, my lord, lodged. That has narration, my lord, I need not go into one aspect. Secondly, my lord, as it seems, my lord, of course, subject to one thing that narration, my lord, exact allegation appear, I can't say anything, my lord. Records are there. But that also would not be visible or may not be relied upon because she was at a distance, my lord, she was able to, yaro obbanu andare.
The matter of evidence, trial.
That is a matter of evidence, correct. 354A, I don't know, yet another very important ground is, why not they
Ella bit to come to 354.
That's what I wanted.
Ashte.
No, I wanted to come that. I know what I lordship should immediately catch the issue and
Yes, this.
354 hang barutte anta namagunu we are not able to.
ಹೆಂಗ್ ಬರುತ್ತೆ ಅಂತಲ್ಲ ಬಂದಿದೆ ಅಂತ.
ಅಲ್ಲಿ ಬಂದಿದೆ, that's not ಬಂದಿದೆ, but how at all they 354 ಅಲ್ಲ. Yes. 354, my lord.
Yes, sir.
May I read, my lord, that assault or criminal force to woman with intent to outrage her modesty. Whoever assaults or uses criminal force to any woman, intending to outrage or knowing it to be likely that he will thereby outrage her modesty, shall be punished in the prison for a description for a term which shall not be less than 1 year, but may be extended 5 years, and shall also find it fine. My lord, for all this, my lord, for the section to invoke, my lord, first concept is there shall be an assault or criminal force. Where are they? To invoke 354, my lord. The, my lord, very logic of that section is, my lord, legal logic, what you call as, my lord, the subject, the very contemplation of section should be, my lord. Section 354 says, there shall be an assault. There is no assault, my lord, nor criminal force.
Sir, 353 galla, 354 gali.
Alla 354 ge ಹೇಳ್ತಾ ಇದ್ದೀನಿ. 354, my lord. Gist of the section is, my lord, there shall be antada. Adu ಇಲ್ಲ, that's not there, my lord.
You are appearing for accused number 3 alla?
3 and 4.
Who is the prime suspect of 354?
Accused number 3 ಅಲ್ಲ.
Very nice.
Apologies.
ಅಲ್ಲಿ ನಮ್ಮದು ನಮ್ಮ petition, my lord, 8849.
Correct. Accused number 3.
Accused number 3.
If what you have done is not 354, I fail to understand what else can it be.
Assault or criminal
Assault alla sir, last 3 line ಓದಿ.
Or criminal force to.
Or ಎಲ್ಲ ಬಿಡಿ sir, last 3 line ಜೋರ ಓದ್ಬೇಡಿ. ಓದಕ್ಕಾಗಲ್ಲ.
Complaint ಅಲ್ಲಿ.
Charge sheets. Complaint.
Charge sheet.
Page 53.
Yes, I'm sorry. ಅದು ಗೊತ್ತಾಯ್ತು. That
ಅಲ್ವಾ?
I not read loudly.
Then we'll dismiss the petition.
No. My endeavor is only technical. I can't.
Technical alla sir.
No. We are, my lord, under 482 before lordship, my lord. I can't. No, I know where I stand. I can't go on saying no. This is
file discharge, sir.
Only, my lord.
With this allegation, I am not going to interfere.
No, I know. I never said regarding, my lord. But concept is. Law concept times 482, my lord. Whether 354 would be applicable.
It is applicable. I am saying what else can be 354 if this is not
criminal force ಅಂತ ಅದು
ಓದ್ಬೇಕಾ ಏನ್ ಮಾಡಿದೀರಾ ಅಂತ. ಕ್ರಿಮಿನಲ್ ಫೋರ್ಸ್ ಅಲ್ಲ, ಲಾಸ್ಟ್ 3 ಲೈನ್ ಓದಿ ಅಂತ ಪೇಜ್ 53 ಅಲ್ಲಿ. If that is not 354, what else?
Seeking discharge. I leave it to last. Seek for.
ಏನ್ leave it ಅಂದ್ರೆ I'll pass out some merits.
Seek for discharge.
You want to prefer discharge, you prefer. ನಿಮ್ದಕ್ಕೆ ಬರ್ತೀನಿ ತಾಳಿ.
Advocate and record, I am bound to ಕೇಳಬೇಕು.
I'll pass out some merits, not a problem. ಇದು ಮಾಡಿದ್ದು ಹೌದಾ?
100%, Swami. It is just a distance of 4 feet. All were drunk, my lordship.
All were drunk.
All were drunk, yes. This is the self-declaration. Quote, madam. See, all the.
Don't know how to behave with a lady.
Lordship, this is in continuation of the multiple criminal overtax by a police officer and an advocate and his family, just because legally protesting a illegal construction worth more than 3 crores, which is under demolition. And further going forward,
civility.
Let me. No. It is not a
pendency of civil litigation is not a license to do all this.
And going forward, BESCOM has disconnected the power.
ಅದೆಲ್ಲ ಹೇಳಿದ್ರ last time.
You know
I just wanted to.
The accused.
ಮಳೆ ಬರುತ್ತಿದ್ದ ಕಾರಣ ಆಟೋಕ್ಕೆ.
They meet in Levels pub before doing this overtax, and they were over drunk. Fully drunk for 7 people.
Where were they?
just say around 300 meters from my residence, there is one pub. That is Ali. Conveniently, they have written it as a Levels restaurant. It is not Levels restaurant. It is a Levels pub where all have met.
So
and with
it was a Levels pub. And you were drunk beyond level.
It is their own statement.
Yes.
Their own statement. And all are caught red-handed in CCTV footage of the apartment. And a person who can orchestrate an SC/ST Atrocity Act and a person, they can very well do it. You have already passed, your lordship has already passed an order on that. It's a repeated action. If I would like to
Great
kindly,
reluctance, I will make submission. Your lordship.
This
may
is the-
Take it, your lordship may take it as heard. Tomorrow I will file a memo with part, that's all. I will not argue any. Tomorrow, take it as heard.
You want to withdraw the petition? You can withdraw.
I can get this. Tomorrow.
Worship,
Without
this is one of the incident where I have objection. There is a 13-inch operation. How this? It is. I was about to die. It is a question of death and this one.
All right,
Not
wait.
this,
It's not here.
with the 13 screws.
Wait. Yes. The learned senior counsel, the SP Kulkarni, after arguing the matter at length, would seek leave of this court to get, to list the matter tomorrow. To seek instructions or a memo from the hands of the petitioner to withdraw the petition.
Either.
On that score, the matter is adjourned tomorrow, list tomorrow in the fresh matters list.
Lordship may not mistake us, only for how real.
ತೊಂದ್ರೆ ಇಲ್ಲ.
Very
Yes. While there merits ಮೇಲೆ ಬರಿಬೇಕು ಬರೀತಿ. Not a problem. Withdraw ಮಾಡ್ತಾರೆ ಮಾಡ್ಲಿ ಬಿಡಿ.
My humble submission before this honorable court is, first 5373 is filed before this honorable
First ಒಂದೊಂದಾಗಿ wait.
only to bring it to your kind attention. 5373, considering the severity of the problem, your lordship only has given only notice, issued only ordered for notice. Further, they suppress this and it is a huge judicial work is wasted. I have filed an IA for
ತಗೊಳಕ್ ಹೋದ್ರೆ ಎಲ್ಲ ಜುಡಿಷಿಯಲ್ ವರ್ಕ್ ಬೇಕಾದಷ್ಟು ಆಗಿರುತ್ತೆ. ಒಂದ್ ನಿಮಿಷ.
perjury. It is up.
Perjury. ಒಂದ್ ನಿಮಿಷ wait. ರಾಧಾಕೃಷ್ಣ ಅವರೇ, come to your petition.
In all 4 persons have filed. Subsequently, on 28,
ಇದರಲ್ಲಿ ವಿಡ್ರಾ ಆಗಿರೋದು ಯಾವ್ದು?
I have withdrawn 3 persons.
ಈಗ ಯಾರು ಉಳಿದಿದ್ದಾರೆ?
A2 is remain.
Who is A2?
A2 is this Malad
This A2 is the police officer.
Allegation against the A2 is concerned, Malad. Page 32, Malad. He was neither present by neither.
That finding I've already given in the other case, looking at the transcript of the CCTV footage that you were present and you have tampered with it.
So for present.
Where is that? Where is that judgment? Kudi.
Judgment is
The allegations were I think according to me.
Good, yes. You are not present ಅಂದ್ರಲ್ಲ ಅದಕ್ಕೆ ಹೇಳಿದೆ. If you are not present, then it is a matter of trial.
Turn to page number 25, Malad. Page
Yes.
25.
Yes.
May I, my lord, seek?
Column number
My lord, may I
17.
seek to other court?
Already, sir.
Sorry.
Column number 25, page number 25.
Yes, sir.
Column number 17.
Yes, sir.
Line for fifth, line formula. ಅಂಕಣ 12ರಲ್ಲಿ ನಮೂದಿಸಿರುವ A2 ಆರೋಪಿಯ ಪ್ರೇರಣೆಯಿಂದ. This is the allegation. He was
All right.
not present at this spot at all.
ತೊಂದ್ರೆ ಇಲ್ಲ. Not present ಅಂದ್ರೆ it's a matter of trial.
Lord, you accept my kindly in the case of this type. Lord, you accept my, I request to accept my kindly.
This, I have clearly observed in this matter that at your behest, everything has
My
happened.
petition, my lord, my petition, ground number 11.
Yes, sir.
These are all the cases filed by against this, the R2.
That may be. I am not on that.
That,
at all.
that
Sir,
is true, my lord.
he may have filed. You may have driven him to the wall to file so many cases. That's a different thing.
For a school, for example, my tenant, against the principal. This is, I request to ask me kindly. 1 second.
ಅದು ಪ್ರಿನ್ಸಿಪಲ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿ ಬಿಡಿ.
ಮಾಡಿದ್ದಾರೆ.
ಮಾಡ್ಲಿ. ಅದು ಸಪರೇಟ್ ಆಗಿ ನಡೀಲಿ.
ಇದೇ ಕೆಲಸನೇ.
Why are you worried?
I'm not worried about my
then
such a nature. ಇವರೇನಂದ್ರೆ 24 hours you will be in the court. ಈಗ ಇದ್ಕೊಂಡು ಎಲ್ಲಾರನ್ನು ಡ್ರಾಗಿಂಗ್.
ನೀವು ಅಡ್ವೊಕೇಟ್ ಅಲ್ವಾ?
I'm advocate. I have
ಕೋರ್ಟ್ ಇರಬೇಕು, ಇನ್ನೆಲ್ಲ ಇರ್ತಾರೆ.
For easy litigation, not for public litigation.
ಬೇರೆ ಕೇಸೇ ಇಲ್ವಾ?
I have filed 138 before your lordship and filed a memo also. He has no right to say that.
ಕ್ಷಮಿಸಿ, para 11
on that front, sir.
Over.
Para 11 ಬಂದ್ಬಿಡಿ. Para 11, page 5 of my petition. Total cases which I have stated. I request you, one second. Yes.
ಹೇಳಿ.
Para 5. Page 5, my petition. Para 11. Respond number 2, Roman 1, Mala. Respond number 2, CN Dinesh filed a case in crime number so and so against Spurti, Nikhil, who are tenants of petition number 2.
ಮೂರ್ತಿ ನಿಖಿಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಾ? ಮೂರ್ತಿ ಅಂಡ್ ನಿಖಿಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಾ?
ಕೆಲಸನೇ ಇದು. ಒಂದ್ ಚೂರು ಏನಾದ್ರು ಜೋರಾಗೆ ಕೆಮ್ಮಿದ್ರು ಗಲಾಟೆ ಮಾಡ್ತಾರೆ. ಒಂದು ಕೇಸ್ ಹಾಕ್ತಾರೆ.
Police officer.
ಲಾಯರ್ ಇಟ್ಕೊಂಡು ಲಾಯರ್ ಆದ ತಕ್ಷಣ ಎಲ್ಲಾರನ್ನ ಕೇಸ್ಗೆ ಹೇಳುದು ಕೋರ್ಟ್ಗೆ ಹೇಳ್ದು ಬಿಟ್ಟು ಕೇಸ್ ಹಾಕ್ತಾರೆ ಅದನ್ನ.
That is not the concern. I would not have entertained that at all. Just because he's a lawyer, it is not that.
My client is concerned, madam. He was not present at this part. My their main
Your-
case is
This is P.O. Shivakumar Alva,
that
your
is-
client. Yes, no problem. I have held, he was present in these, all arising out of the same incident.
so for that aspect I
If you are not present, adjournment illa.
I am not seeking for
If you are not present, it's a matter of trial.
ಕೇಸ್ ಡೀಟೇಲ್ಸ್
ತೊಂದ್ರೆ ಇಲ್ಲ.
ಇನ್ನೊಂದ್ಸಲ ನೋಡಿ ಸ್ವಾಮಿ.
ಅಲ್ಲ, para 5 ಅಲ್ಲಿ ಮತ್ತೆ he accepts that it is not that he is denying. He accepts that he has
There are
filed.
5 criminal cases pending as of today with the proofs, evidence on record. Your lordships have already dismissed 2 criminal petitions.
ಒಂದು ಇಲ್ಲಿ, ಒಂದು ಜಸ್ಟಿಸ್ ಸಂಜಯ್ ಗೌಡ್ರು ಇನ್ನೊಂದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. ಪಣೀಂದ್ರ ಸಾಹೇಬ್ರಿಗೆ ಗೊತ್ತು.
And also they are running a illegal brewery business in the apartment.
ಎಲ್ಲ ನೀವು ಬೇರೆ ಕಡೆ ಹೇಳಿ.
This is all being
Yes,
a police officer to protect the law. He has been misusing the laws.
ಬನ್ನಿ.
You have heard, your lordships have observed in one police versus police, a constable misusing the power.
Police versus police.
You highlighted that.
ನಂದೆಲ್ಲ ಹೇಳ್ತಾ ಇದ್ರೆ.
It was just observed a constable misusing the power. Imagine a 13-inch operation.
All right, yes. Yes, Pranindra sir.
I am in 86.1, accused number 5. This complaint, if your lordship says, so far as I am concerned, the vague statement is made so far as I am concerned.
What is your name?
Abhay.
You are petition number 1 in that petition which I dismissed.
Dismissed. We were there. my lord.
Abhay was not there in this.
Abhay, we were not there. My lords, the allegations made, my lords, against another person, yes, I can understand. So far as I am concerned, except making a
petition ಯಾವುದು ನಿಮ್ದು? Abhay.
that's 86 point, that is 6712 of
ಇದೆಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ?
82,
ಹಾಕಿದ್ದಾರೆ.
House.
You are accused number
5, my lords. A5. The statement is that I was
354 ಬರಲ್ಲ ನಿಮ್ಮ ಮೇಲೆ, but 447, 427.
and but so far as criminal trespass, now the incident, what they say is under, near the meter board. Now that, my lords, is not a trust. I can understand
That's all
if I trespass into their property.
427.
Lords,
It's
that's,
chief.
that, there should be some allegation, my lords.
ಇದೆಯಲ್ಲ,
If your lordship says, my lords, I can
ಪದೇ
understand.
ಪದೇ ಸ್ವಿಚ್ ಮಾಡು, ಏನಿದು
Switch off.
ಆಫ್ ಮಾಡಿ ಆನ್ ಮಾಡಿ, and at that point in time, this accused number 3 has done something that is of course
That's
horrendous.
why, my lords, I said,
Yes.
accused number 3, I
We're
can
all
understand.
together.
We are simply, we are staying there, we have been.
I'll
roped in.
adjourn it by 4 weeks.
No, my apologies.
But we are staying there, we are roped in because of saying that we were also present.
120
Otherwise, there's nothing.
120 ಬೀನು ಇದೆ.
Lords,
120 ಬೀನು ಇದೆ.
that's why, my lords, it's a general statement. Otherwise, there is no other allegation made against me that he only says I was present there. Now, my lords, everyone is present in the apartment. Can everyone be roped up?
Everyone are not. ಆ ಥರ ಇದ್ದಿದ್ರೆ he would have roped in everyone.
That's, no, that's what.
ಆ
is
ಥರ
happening
ಇದ್ದಿದ್ರೆ
there.
he would have roped in everyone.
I'm only
He
saying.
has roped in only a few against whom he has
that
a
is what
grievance.
He has a grievance.
Yes.
Now, my lords, that your lordships have, if your lordship.
Not
feels
only
he is-
me, even Justice Sanjay Gowda has written the same thing.
Right.
Yes.
That's the only thing, that there is nothing so far as I am concerned, but except. a
Better
vague
you
statement.
come out clean in a trial or file discharge, whatever you want.
Your lordship may give me that liberty.
All right, discharge. Yes. Same, yes, sir. Except SP Kulkarni ಅವರು ನಾಳೆ ಬಿಟ್ಟು ಮಿಕ್ಕಿದ ಹರ್ಡ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಂತ ಮಾಡಿ all contentions left open before discharge. ಎಲ್ಲ ಅಲ್ಲಿ ಕೊಡಿ. ಕ್ಲೋಸ್ ಆಯ್ತಲ್ಲ ಈಗ, ಅಲ್ಲಿ ಕೊಡಿ. ಎಸ್. ಮತ್ತೆ ನೀವು ಫೋಟೋ ಎಲ್ಲ ತೋರ್ಸಕ್ ಹೋಗ್ಬಿಡಿ.
No.
ಜಗದೀಶ್ ಅವ್ರಿಗೆ ತೋರಿಸಿ. All right. No, maybe he has gone overboard. That's not a thing. But definitely all of you have driven him to the wall. Prima facie, that is what I have held.
Who is the main kingpin accused?
Allah, that is what.
Mastermind.
P.O. Shivakumar. Yes.
With the proofs.
Yes.
Much obliged.
ಮತ್ತೆ ಇದನ್ನ ಮೂವ್ ಮಾಡಕ್ ಬರಬೇಡಿ.
ಇಲ್ಲ
ಎಸ್.
The respondent number 2, my lords.
For the petition.
331 ಮಾಡಿದ್ದಾರೆ.
This is
ತಗೊಂಬಿಡಿ.
clubbed with, this is a predicate offense, forms part of a ECIR registered against the accused.
PMLA ಇದೆಯಾ?
Yes, it is listed on 21st. We have challenged the summons issue.
87 list on 21st.
Mean-
330 matter
My
ತಗೊಳ್ಳಿ.
lords, if I may be permitted to file an amendment application.
File
in
it
this,
in the registry, madam. No problem.
Please.
I'll file
You
my
wanted, yeah?
objections also.
Huh?
Statement of objections is.
File
already-
ಮಾಡಿ list on 21st. Whatever you have to do, do it. 330 matter ತಗೊಳ್ಳಿ.
Other hearing. Interim order may be
Huh?
extended. Interim order may be extended.
That will be extra. Yeah, 152.
Petition.
Yes, madam. ನೀವಿಲ್ವಾ?
Yes, please.
ಇಲ್ಲಿ ರಾಘವನ್ ಸರ್ ಇಲ್ವಾ?
Yes, end up in another court.
You start. Yes. He has argued at length.
I have no problem. My only problem is if he comes now again, the
No
train
problem.
of.
Let him. All of them are coming except Raghavan sir.
I just check, he's on his legs in Quota
Yes,
13.
yes.
I just take my laws through, I think, if there's any repetition, my laws may kindly correct me. I just take my laws through the complaint. Now, I think the basis was set. The basis is just this. Now that in 2020, there was an application before the Russian consulate in Dubai. That certificate is produced. Now, as an afterthought, there is an allegation that it was never my signature. I never came to the consulate. In fact, oddly enough, in the complaint also, there is no such averment, even though she was, at that, I'll take my laws through the dates. She was aware of the fact that this was done because in fact, it is mentioned in our second MC case, which we had filed in 2023. There is a reference to this. I'll just, since I mentioned it, Malas, may kindly see in the petition, page 78 is the 23 petition.
2023 petition.
Yeah, that's right, Malas.
Page?
Page 78 of the writ petition.
All right.
Malas, may kindly see paragraph number 12, page 83.
Oh, this is the MC petition you filed.
That's it, the second one. The first one, Malas, of course, was filed in 2020.
All right.
This is the one which possibly as a matter of abundant caution to make sure that there is no loose ends left. This is filed. Paragraph number 12, page 83. On 23/12/2020, this is my averment. 23/12/2020, acceding to the respondent's request, the petitioner jointly applied for an administrative divorce before the Consul General of Russia in Dubai, UAE, with the respondent. Since the petitioner respondent did not have any children and had consented for the divorce, the Consulate General of Russia in Dubai, UAE, acting as a civil registry office under Russian law, registered the divorce and issued a divorce certificate on 24/1/2021. Now, let's just give me a list. The notice of this, my lords, was served on the respondent. This was filed on 16th of November 2023. Notice was issued in this on 17th of November 2023. Notice was served on 5th of December 2023. Filed on 16/11.
17/11 notice.
Notice issued on 17/11. Served on 5/12. And once again served through airmail on 4/3.
Once again served on?
I'm sorry,
Once
4/3, 4/3/24. And this complaint, my lords, was filed on what date was it? 11th. No, 7/3/24. This complaint was filed.
All right.
Now kindly see the complaint, my lords. Complaint starts at page 40.
Yes, sir.
I won't trouble my lords reading the entirety of the complaint, just some relevant paragraphs, but my lords may take it from me that there is no whisper about this, this afterthought of an argument, if I may call it, regarding the fact that that decree of in the Russian consulate was obtained due to fraud and a false signature and so on.
There is no averment.
No such averment in the complaint. Now, my lords may kindly see para 41. Sorry, page 41, para 3.
Yes.
The petitioner submits that the respondent had deserted and abandoned the petitioner for no rhyme and reason so far and has not made any efforts towards reconciliation. My lords may kindly mark this. The petitioner and the respondent are living separately since 2021.
All right.
But occasionally the respondent visited the residence of the petitioner in Dubai along with his friends, disconcerting the peace and harmony of the petitioner by partying all night and subjecting the petitioner to cruelty. The respondent from 2019 has subjected the petitioner to immense cruelty and humiliation throughout her stay with the respondent by casting aspersions on her conduct. The petitioner was put under constant stress from 2019 due to all the cruelty exerted by the respondent. The petitioner was employed in the business of the respondent, and since 2021, she has been laid off by the respondent, and the petitioner had to shoulder the financial burden of maintaining herself and would require substantial amount towards quality lifestyle, conveyance, so on, incidental expense, and so on. Then last, about 3 lines from the bottom, my lords. The respondent, being gainfully engaged in a profitable business, has not been supporting the petitioner since 2021, and therefore the petitioner is constrained to file this petition seeking an order of protection, so on. Now, 2 things emerge from this, my lords. One, that these allegations seem to be all relating to the period 2019 to 21. Admittedly, complaint filed in 2024. 2, there's an admission that since 2021, we have not been living together. Only sporadically, this person, the petitioner, used to visit and harass me. That's all. So, Manoj, there is no allegation also in the complaint that we had either a marital relationship or any relationship in the nature of a marriage. And now this seems to be the theme throughout, Manoj. Paragraph 6, my lords may kindly see on the next page, page 43. Now, this is the third point, Manoj. One is 2019 to 21. Since 2021, they've been living separately. Third aspect, Manoj, may kindly see at para 6.
Paragraph 6.
Paragraph 6, page 43.
Yes.
It is further stated that the petitioner and the respondent shared a better understanding and companionship until the year 2019 and had jointly purchased a house in Dubai in the year 2014, namely the Meadows House, in a joint name as the petitioner had invested to the extent of 50% of the sale consideration. It is further submitted the respondent had promised to transfer. I'm sorry, I'll just continue reading. It is further submitted the respondent.
What purpose are you reading this?
The purpose is, my lords, all of these allegations pertain to alleged acts committed in the United Arab Emirates, not even in India.
All right.
So those are the 3 aspects, my lords, which emerge from the complaint. I won't trouble my lords reading the entire thing. If my lords were to see it, throughout the theme appears to be 2019 to 21. We have lived separately since then, and all the acts that he has committed, when he comes to Dubai to visit me, all these acts are committed. So those are the 3. My lords may kindly see para 13 also.
Para
13, 1-3, page 49. It is further submitted, paragraph 13, it is further submitted that the respondent, that is the petitioner before your lordship, is representing to close family and friends that the marital bond between the respondent and the petitioner has been dissolved by virtue of a divorce decree, which is far from the truth and is fictitious. It is submitted that the said representation of the respondent is tarnishing the reputation and good name of the petitioner, as the respondent is representing the petitioner a negative connotation to the mutual close family and friends. It is submitted the respondent is soliciting illicit relationships from numerous women by representing himself as a divorced individual. It is further submitted that the act of the respondent is contrary to the marital obligation which was agreed upon. Now, once again, my lords, again, as I was submitting, all of these submissions pertain to acts in Dubai, again, from 2019 till about 2021.
Yes.
And finally, my lords, paragraph 22. 22. Paragraph 21, I'm sorry, previous page, page 52. It is further submitted that the petitioner had issued a comprehensive legal notice dated 27/11/23, calling upon the respondent to refrain from the acts of harassment and to dissolve the marriage by transferring 50% ownership in all the assets owned by the respondent, which the petitioner is rightfully entitled to. The respondent on receipt of the said legal notice has chosen not to reply for the same in the Meadows house, and the respondent would have the petitioner and her daughter killed. It is further submitted the petitioner had issued a second legal notice dated 6/12/2023, calling upon the respondent to refrain from harassing the petitioner and her daughter. So notices were issued in the year 2023. Again, there's a lull between 21 and now all of this seems to have been triggered by this 2023 MC petition. That's where it appears as if suddenly there is a second awakening. And now that I have filed petition on, as it was alleged, wrong advice, as the case may be, I still believe, my lord, it was the correct thing to do, because since there was a certificate subsisting, and certificate, as Mr. Raghavan pointed out on the last date, it was a certificate only certifying that the marriage had been solemnized as per Russian law. So as a matter of abundant caution, this MC petition was filed. Now all of this gets triggered by this. And all of these allegations, and conspicuously, there is no denial of the certificate of 2021, which was alleged in our complaint, which admittedly she had received notice of. So those are the aspects I'd like to point out. Now, my lord, of course, your lordship has seen the prayer. It's
Prayer I have seen.
prayer, not read. Yeah, my objection.
Lull has become the key word now.
Correct. I understand.
Taking cue.
No,
from-
no check period. No,
Ah, yes. It's lull period.
Now, my lords, my lords, may kindly see the objections to my writ petition that have now been filed. Now, how there is an improvement of the case on the allegations in the complaint. My lords, may kindly see the objections that was originally filed, not the sur rejoinder, but the
Objections of the petitioner. the respondent.
objections. Yeah, that's right. So objections, it's stylized.
Not the sir rejoinder.
Not the sir rejoinder.
Sir. ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ದಿನ ನಡೆದ್ರೆ
ಬರುತ್ತದೆ.
ಸರ್ ಟು ದಿ ಪವರ್ ಆಫ್ 2. 1 minute. The first objections, right?
That's right, my first objection.
Memo cited, madam, objections. First statement of objections.
Yeah, yes.
Objections copy. Page. Rejoinder to the statement. Objections.
Rejoinder. Page number illa, but paragraph number I'll just mention. Paragraph 6.
Then,
Now, just before taking my lords, one thing I'd like to point out was now mentioning during this lull period, after we filed the second MC case in 2023, there is, for lack of a better term, these package proceedings. One is this case. There's also a case, my lords, which she files for restitution of conjugal rights.
yes.
All of them, everything is done within a few dates of each other. 7th of March, this is filed. 12th of March for restitution of conjugal rights. And what else is filed? And 125 also. So there are 3 proceedings within 5 days of each other. As soon as notice is issued, it appears as if this is done as a reaction to it. Now, my lords, may kindly see the objections. Paragraph 6, my lords.
Yes.
Now, this is for the first time, she says, following the dismissal of the divorce petition by the family court in MC so-and-so, the petitioner also submitted an application seeking a divorce by mutual consent before the Consulate General of Russia in Dubai without the respondent's knowledge. The first time this government comes in. The respondent neither subjected herself to the jurisdiction of the Consulate General of Russia in Dubai, nor appeared in person. However, the Consulate General of Russia in Dubai has accepted the forged affidavit of the respondent presented fraudulently by the petitioner and granted dissolution of a marriage under Article 160, Clause 2 of the Family Code of the Russian Federation. So therefore, this is the first time this allegation is made. Now, again, Malas, just to see how another improvement. Paragraph 8. Upon repatriation from Russia in July 2023, the petitioner pressured the respondent to remain in Dubai. After the respondent arrived at their joint residence known as Meadows House, the respondent was surprised to discover all her belongings from Bangalore has been relocated there. When the respondent inquired about this petitioner falsely claimed to be on a business trip. The respondent subsequently joined the petitioner on his business travels, but inexplicably, prevented them from staying at their Bangalore home. The respondent asserts that while she had accompanied the petitioner on business trips, he was covertly taking steps. Now, next sentence. Further, the petitioner and the respondent cohabited in both Bangalore and Dubai until November 23. Again, just to point out, there's an improvement every time. Then paragraph 9.
In what?
In the original complaint,
Oh, yeah.
there's a specific government that
All right.
2021 onwards. That's what. So now again, there's a, just to establish, all of this finally is to establish that there is, even if there is, assuming no marriage, there's a relationship in the nature of marriage. Of course, she's denying the fact that the marriage is dissolved at all because of the fraud. But in essence, what, I'll come to the case law on the aspect, but in short, at least my submission would be this. The Russian divorce, there's a certificate. We have, in fact, to be safe, recently we applied for another certificate from the in Russia itself, in St. Petersburg. Oh. That also exactly the same. The divorce certificate number is the same. So it's not as if this certificate was cooked up. So just to make sure, the same certificate was obtained by us from Moscow also, or St. Petersburg. Now, sorry. No, if Lordships wants, we can file it. There's no denying the fact that there is a Russian divorce. Now, in essence, my submission is this. Rightly or wrongly, a court of, or rather an authority of competent jurisdiction as per Russian law.
Russian consulate in Dubai.
That's right.
Yes.
An authority, which I said,
All right.
Even if it's not a court, an appropriate authority of competent jurisdiction has granted a divorce certificate. Now, this divorce certificate is produced. There's a Russian lawyer's opinion also explaining the law on the aspect. Now, essentially what the respondent is asking this honorable court to do is to ignore it, or rather hold that to be fraudulent. Now, whether that is permissible is what your lordships would have to consider. Now, to hold that divorce certificate is not binding and that marriage still subsists, your lordships would necessarily have to hold that the Russian divorce certificate has been obtained by fraud. Now, my lords, there are serious allegations of fraud, who forged the signature, so on. Admittedly, no action taken between 21 to 24.
But if the respondent is able to show that she was not even present at the time, then
that, my lords, I would respectfully submit, assuming if she is able to show that she was not even in Dubai, she was in India or wherever, any other part of the world. Now, would it be appropriate for that to be raised before your lordships, or would it be appropriate for proceedings to be raised as per Russian law?
All right.
As per, because there, my lords, if let us assume there is a decree of divorce from the US. Now, to ask an Indian court to ignore that would, in my respectful submission, not be appropriate. One would have to go to the US court, convince the US court that it was a fraudulent decree, and then present that. Then, of course, your lordships would have to, in the interest of comity of courts, follow it. Now, in fact, my lords, may kindly see in our rejoinder, just to buttress the fact that this is all an afterthought, there are messages that we have produced. I think Mr. Raghavan read them out on the last date. I won't, this is the rejoinder to the statement of objections. My lords, may kindly see page 9. The messages themselves are reproduced, but we have extracted them just for the sake of convenience. Page 9 of the rejoinder. Kindly see, my lords, first in bold, you no more my husband. I'll decide what to sell. This was sent on 16th.
Raghavan sir has read this.
Yes, my lords. So basically, my lords, this is, it all falls into place that there was never any marriage. Now, after this MC case, this seems to be, everything seems to have now dawned upon them that they should start these proceedings. So that's just to show that, my lords. Now, may I take, my lords, through some of the judgments on the aspect.
Yes. You have copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy, I think we're having.
Memo of citations are here. You have it, madam? Memo ಕೊಟ್ಟಿಲ್ವಾ?
Well, I think we've given, I think there are 2 memo of citations that have been given. I think there is one more possibly. I think those have been given. That's all. That's all.
1 and 2.
1 and 2, that's it. I think there are 2. Now, all the propositions are laid out, my lords. I'll just read them out, and all the paragraph numbers also.
No, this Raghavan sir is already referred.
That's right, my lord. So then I won't trouble. I'm sorry. That's why at the outset I apologize if there's any repetition.
No, it's all right. Bird of passage.
That's right, correct.
He has referred to it, yes.
Then I think paragraph, sorry. No, that's okay. Then I think, my lords, may kindly come to, if possibly the judgments at 6 and 7, I'll just read the proposition.
Propositions,
I'll just read the proposition. It's
Mohammed
basically-
Ali.
That's right, the judgments on Mohammed Ali and Achin Gupta. If
Ah.
they're with the, your lordships knows it, so we've marked the paragraph.
Mohammed Ali is for the contention perhaps that it's a cleverly worded complaint. All right.
And also, my lords will have
Achin
to
Gupta,
read
498
between the
days.
lines and so on. So that's it. Which is why my lords, your lordships is well aware. So that's why we only extracted the proposition. Your lordships may see it at an appropriate time. Now, the second memo of citation, my lords, which are more pertinent to the.
I think second memo I have not seen. Yes. Second memo, yes, sir.
The second memo. I just. That's been served. Now, the first proposition, my lords, is regarding delay. Your lordships has it?
Yes.
That's right. So basically, all these allegations as I was submitting pertain to the period 21 to 23. The complaint,
Chanchalapati Das.
sorry, 19 to 21. I'm sorry, Chanchalapati Das. So therefore, any inordinate delay would have to be explained. So without any explanation, and there is admittedly no explanation as to why 3 years went by, 3.5 years went by, and still no action was taken. Then the second set of propositions, my lords, is that the provision of the DV Act can be invoked only when domestic relationship is in existence, and where the domestic relationship ceases, the provisions under the Act cannot be invoked.
Which is that?
Now, my lords, that will be the line of judgments from serial numbers 4 to 7. These are all various high courts. My lords may kindly see the first one, Ravel Singh, which starts at page 30. Now, if I may draw your lordship's attention to para 8 onwards, at page 32.
Yes.
Now, the question that arises for consideration in this case is as to whether the marriage between the parties stands dissolved and the complainant respondent herein has lost the status of wife, and that there is no domestic relationship between the parties in order to invoke the provision of the DV Act. Now, para 10, my lords, lays down the facts fairly similar to this, my lord. No, not, I'm sorry.
Para 10 of?
No, please.
Ravel Singh.
Mr. Raghavan has come.
I apologize to your lordships.
No,
and to
no
my
problem.
learned friend, my lord.
Okay, let him finish, or
Then-
you want to continue, you can.
My learned friend.
I'll just finish this slide of judgments,
yes.
and then now, para 10, my lords may kindly see.
Yes.
There is no dispute with regard to the fact that the petitioner number 4, Baldev Singh, was settled in Germany since 2002 on account of his employment. He married the complainant respondent herein, and after the marriage, she also went to Germany, and both of them were residing there. They became permanent residents of Germany, and after having stayed in Germany and becoming permanent residents of Germany, the relationship between them became hostile to each other, and both of them started living separately. Thereafter, petitioner number 4, Baldev Singh, approached the district court, Wisman, and filed a petition for divorce. The complainant herein contested the same, but petition number 4, Baldev Singh, succeeded in getting the marriage dissolved. The fact that the petition number 4, Baldev Singh, has approached the district court, Wisman, Germany, and the said court having dissolved the marriage by pronouncement of a judgment, petitioners have produced a certified copy of the judgment and decree dated 27/2017. Just pausing, my lords, the only difference, if at all, would be it's a court. Here, my lords, it's an appropriate authority. Now, the Russian law permits a divorce before an authority. I don't think anything can be read into the fact that it's an appropriate authority, which I'll leave it at that. Now, my lords may kindly see para 15. The complainant respondent herein in the complaint has nowhere stated that such decree of divorce has been obtained by fraud or has been passed in breach of any law enforced in India, nor any ground has been stated in clauses A to F of section so of CPC. In the absence of any condition as contained in clauses A to F, presumption regarding the fact that such judgment is conclusive is attached to the said judgment. Now, the findings, my lords, will find it para 21 onwards.
Yes.
From the aforesaid discussion, it is clear that the petition number 4, Baldev Singh and
Para 21.
Para 21, page 36.
Oh, yes.
From the aforesaid discussion, it is clear that the petition number 4, Baldev Singh, and the complainant respondent herein were permanent residents of Germany and were subjected to the laws of that country, and the district court, Wisman, Germany, having jurisdiction, had decided the petition filed by the petition number 4, Baldev Singh, for divorce, and has dissolved the marriage. By passing of the decree of divorce dated 27/2017, the marriage relationship between the petition number 4, Baldev Singh, and the complainant respondent herein came to an end and has ceased to exist. Now, paragraph 27, my lords, may kindly see. Therefore, for the reasons stated herein above, it is held that the judgment/decree of divorce dated so and so, passed by the District Court, Wismar, Germany, whereby the marriage has been dissolved, is conclusive and binding upon the parties. The said judgment decree has not been challenged, kindly mark this, has not been challenged by the complainant respondent herein. Therefore, it is held that the relationship of husband and wife between petition number 4, Baldev Singh, and respondent so and so, has come to an end. The complainant respondent herein, after passing of the aforesaid decree of divorce dated 27/17, filed a complaint against the petitioners without observing that the marriage has been dissolved by the District Court, Wismar, Germany. The relationship between petition number 4, Baldev Singh, and the complainant respondent herein has come to an end, and they are no more husband and wife after passing of the decree of divorce. Here also similar, which is why I was submitting. If at all any remedy has to be availed, they have to avail the remedy under Russian law to set aside that decree or as the case may be, this certificate of divorce. Then, my lords, paras 34 onwards, my lords, they come back to the DV Act, having established that there was no marriage subsisting.
Yes.
While having regard to the facts and circumstances of the case in hand falls under the rarest of rare cases in which discretion is required to be exercised, because there is no domestic relationship between the parties, and in the absence of such domestic relationship, provisions of Domestic Violence Act cannot be invoked. Therefore, the allegations made in the complaint would not constitute commission of any offense under the provisions of the DB Act, which requires existence of a domestic relationship. The allegations in the complaint thus are absurd and inherently improbable, and on the basis of such allegations, there is no sufficient ground for proceeding against the petitioner accused in the complaint. These criminal proceedings are thus manifestly attended with malignant and ulterior motive for wreaking vengeance on the petitioners. Thus, the grounds taken in the petition made out a case in favor of the petitioners of quashing the proceedings. Now, my lords, may kindly see one document. This is in the same compilation at page 82. This is a treaty between the Republic of India and the Russian Federation. Article 10, my lords, may kindly see at page 87. Article 10 at page 80. The treaty starts at page 82. It says, attaching importance to the development of cooperation in the field of legal assistance.
So the recognition of documents.
That's right. Documents issued or certified in the prescribed form and sealed with an official seal of the court or other legal authority, other competent body or official person in the territory of one contracting party shall not require any form of authentication in the territory of the other contracting party. Documents considered as official in the territory of one contracting party shall have the evidentiary force of official documents also in the territory of the other contracting party. And Article 24 speaks of judgments. Your lordships expressed a doubt whether it's a judgment or not, but this, of course, Article 10, I think, should cover the issue. I'll just ask Mr. Raghavan if I think all those judgments, I'll just close with this. Those judgments which I had read out at Ravel Singh, the remaining judgments in the same compilation follow Ravel Singh to the same extent. So where there is no subsisting marriage or any relationship in the nature of marriage, provisions, and so all Amit Agarwal, Santosh Kumar, Sanjay Singh Thakur, all follow.
All to the same effect.
All to the same effect. All right.
Yes, sir.
Yes. I want to point out, your lordships, Lord, one important aspect. My lord, in one of the points that we have raised, apart from the fact, my lord, that the marriage has been dissolved in accordance with the Russian law, even when your lordship looks at the averments in the petition that has been filed before the DV court, all the allegations are with respect to what has happened in Dubai. Now, the question that I place for your lordship's consideration is, the point that I place for your lordship's consideration is, in respect of acts, because we are in a 482, my lord, I will assume that whatever is said in the complaint is true. In respect of acts alleged to have taken place in Dubai, is a petition before the Bangalore court maintainable is a question. And in this regard, my lord, that's why, my lord, I want to show to your lordships what is the summum bonum of their complaint before, or the petition before the DV court. It is that in Dubai all this happened. And then, my lord, it will be my submission that their filing a petition here, coming, and even if they were staying for 1 day, 2 days, 3 days in Bangalore, they were birds of passage. She was a bird of passage. I am not using this term a lot. Supreme Court uses that word. That you can't say you will take a hotel room and then say, I am residing there. That's what happened in Delaware, in the United States. I am told it is easy to get divorce. So what persons do is to go from one state, even though they are permanent residents of that state.
No, you're talking of Newark?
Nevada.
Sorry.
Nevada. I am talking of Nevada. The state of Nevada. Yes, my lord. Not Delaware, Nevada. No, my lord. Nevada, it is very easy to get a divorce, I am told.
Both,
so they go,
both marriage and divorce.
So, my lord, what they do is
incorporate a company.
Yes, correct.
That's what.
Delaware is easy to incorporate a company. That was what is in my mind, my lord. Because we have so many Delaware companies where I am told, my lord, there are a series of boards there.
Delaware is, yes, that is company.
All companies are incorporated.
Our concept is only Nevada.
Nevada. I had that in my mind when I said Delaware. I made a mistake. I'm told, my lord, in Delaware there are some boards put, series of boards. Board matra. No, my lord, in Nevada, I'm given to understand, my lord, that it is very easy to get a divorce because the law in that state, my lord, allows that. So, my lord, people from different state where it is difficult to get a divorce because of the law of that state, go, my lord, and take a hotel room and then show that as the address and then get a decree. When that type of a decree which was obtained in a Nevada court was put before the Honorable Supreme Court here saying that the marriage has been dissolved, Supreme Court said you are a bird of passage. Therefore, we will not recognize that decree. My lord, insofar as the respondent here is concerned, insofar as the Bangalore court is concerned, she is a bird of passage. And therefore, my lord, I want to show to your lordships the averments in the petition that has been filed, which is very material.
Vikram sir has read it out.
There are, if it is shown, my lord, I will not repeat
Paragraph
it.
I'll tell you.
I will show.
Yes.
My lord, would your lordship kindly turn to the complaint, my lord?
Yes, sir.
My lord, please see page 40.
Page?
40, my lord. Which is shown.
Yes, sir.
Complaint also.
Paragraph?
My lord, I'm told, my lord, that paragraph 3, 4, and 6 have already been shown to your lordships.
Yes.
Therefore, I'm not going to repeat it.
Yes.
I'm going to show to your lordships a few other paragraphs, which according to me, my lord, would be material. My lord, please see paragraph number 7. It is submitted that since 2019, there was a sea change in the attitude and behavior of the respondent. The respondent started to behave rudely with the petitioner and also used to quarrel with the petitioner for own reason. And there always existed a difference of opinion between petitioner and the respondent ever since the petitioner confronted the respondent on an illicit relationship with one by name so-and-so, who is a close friend of the petitioner herein. It is further submitted that petitioner since 2019, the relationship between petitioner and respondent has deteriorated on the fact that the respondent had involved in an illicit relationship with a friend of the petitioner, namely so-and-so. Then, my lord, I'm going to skip that. Then kindly come to paragraph number 9. That is very crucial. It is further submitted that in the year 2021,
yes,
the respondent had placed African American securities at the entrance of the Meadows house and installed CCTV cameras inside the house. It is further submitted that upon arrival of the Meadows house is in Dubai, my lord, and the allegation of violence, domestic violence is there.
Yes.
Is supposed to have happened in that place. It is further submitted that upon arrival of the petitioner from a business trip, the said African-American securities prevented her from entering into her own house, obstructing her entry in an intimidating manner. The said act of the henchman hired by the respondent made the petitioner fear for her life and limb and left a deep psychological scar in the mind of the petitioner. It is further submitted that the petitioner could not enter into her own house and was allowed to enter only once. It is further submitted that the respondent had kept the petitioner's daughter out of the country on the pretext of her job, and when both the petitioner and her daughter traveled together, respondent had taken over the house and placed CCTV cameras in every nook and corner, including the bedrooms and common areas of the house. The daughter, my lord, here referred to is the daughter of the respondent through some other relationship. She is there's that.
Some other relation?
Yes. Yes, my lord. She doesn't say.
Not the daughter born from this wedlock. Not from this wedlock.
No. In fact, the divorce, my lord, that is granted is premised on the footing that the marriage did not, there was no offspring from this marriage. Because, my lord, the Dubai consulate, the Russian consulate in Dubai will get authority and jurisdiction only if from the marriage there are no children.
Oh, that's the
requirement of that law. That's what your lordship saw in that legal opinion given by the lawyer.
Yes.
No, madam, she is a daughter. In fact, she doesn't say which relationship also. She says from another relationship. Whatever, madam, I'm not going into all that. I'm not relevant. Not relevant. I'm not going.
Whether she says or not, you are aware. So leave it. Yes.
I'm not. Yes. In any event, madam, what is material? I wanted to point out that this is not a daughter born out of this marriage. That is all that is relevant for the purpose of this case. It is further submitted that the respondent had kept the petitioner's daughter out of the country on the pretext of her job, and when both the petitioner and the daughter traveled together, respondent had taken over the house and placed CCTV cameras in every nook and corner, including the bedrooms and common areas of the house. Additionally, placing 3 African American security guards to the house. It is further submitted that the respondent had informed the petitioner's daughter to pack her belongings in Bangalore and to return all her work equipment such as laptops, namely 1 MacBook. It is further submitted that when the petitioner and daughter were allowed to enter into her house, petitioner was barely allowed to rest and was not even allowed to freshen up as her belongings were kept packed in boxes. It is further submitted that the petitioner and her daughter were not allowed to consume food and were kept under hard, dire and threatening conditions with 3 African American security guards in the house round the clock.
Where?
All this is in Meadows. All this is in Meadows, my lord.
Yes.
That's why, my lord, I'm finding out, assuming everything is true, I ask myself, how does it become a domestic violence for the purpose of the DV Act here? It is further submitted. It is that the petitioner was made to follow the directions and dictum issued by henchmen hired by the respondent. Petitioner, being a title holder of the house, was put under command of African American security guards who dictated every move in the house and screened all the visitors for their IDs, which caused great embarrassment and caused the petitioner to suffer severe mental trauma. It is further submitted that there was an unidentified gentleman in the house on watch, assumingly from law enforcement, given the respondent's financial position and political influence in the vicinity.
Political influence?
Madam?
Political influence?
Anta our head.
In Dubai?
That's what they are saying. Yes. Yes, that's what they're saying. It is further submitted that 3 days subsequent to this event, petitioner was wrongfully confined in her own house, with every move and conversation being recorded and tracked by the respondent. And then, my lord, they say again, same thing, my lord, this African American allegation is repeated. Your lordship may kindly turn to page 47, line number 8. It is further submitted that the petitioner and her daughter at Meadows house spent sleepless nights by keeping their life on the hand with 3 unknown African American henchmen deployed by the respondent. The petitioner and the daughter were locked inside the room and threatened by the henchmen to sign on certain blank sheets of paper, failing which they put the life of the petitioner and daughter under dire consequences. When the petitioner declined to sign the blank papers, petitioner and the daughter had to face unpleasantness, humiliation, torture, and life threat, which shows the respondent's arrogance and atrocity towards women through henchmen. It is further submitted that the petitioner and daughter were left behind in the Meadows house by the respondent after the respondent had taken petitioner's jewels from the aforementioned safe. It is further submitted that the petitioner had spent a full month under supervision of cameras installed by the respondent in house, and additionally with 3 African-American security guards on watch round the clock, the petitioner and daughter faced severe mental pressure and a gross invasion of their private space and privacy. It is further submitted that petitioner and the daughter reluctantly decide to move out to the Meadows house as they could not bear the gross invasion of privacy and, more importantly, the life threat posed by the intimidating African-American security guards. It is further submitted the petitioner was threatened with dire consequences if she were to file a police report in Dubai
Against
against the respondent. Respondent threatened the petitioner that if
the
you
complaint is registered in Dubai?
no, ಏನು ಮಾಡಿಲ್ಲ ಇವರು. I showed your lordship, he comes today to Bangalore, tomorrow institutes a petition for restitution of conjugal rights. Next day files a petition under 125. Third day files a DV case, goes off.
Back to Dubai.
Back to Dubai. This is what she has done. All this in 3 days is over now. But there's clear abuse of process of court. I mean, in fact, my lord,
No, we are only examining whether the petitioner for under the domestic section 12 of the Act
Yes.
is maintainable for the reliefs that they are.
Maintainable is one issue. Second is it an abuse of process of court?
Only if it is abuse process of law. If I come to that conclusion, only then I can entertain this.
Yes. No, ma'am. There are 2 ways. One is if on the basis of the allegations in the complaint, it does not constitute, the DV Act does not apply. That is one ground. Secondly, taking the totality of circumstances and reading in between the lines, which is what your lordships will do, my lord, when all these complaints are filed day in and day out. And today, my lord, I saw something on bar and bench also. In a matter, my lord, his lordship Justice Gawai is sitting with 2 of the, of course, it's an observation, not that he has said the act which is totally misused in this country is the DV Act. Of course, it's a statement that was made. I'm just not that it has any bearing on the judicial aspect of the case.
Yes.
Then, my lord, now, my lord, kindly see para 13. That's very important.
1-3.
1-3. Oh, I'm told it is shown to your lordships. If it is shown, I'm not going to waste your lordship's time.
Shown, read and reread.
Very well. I will skip that. But if it is shown, I'm not. Shown. Shown. Para 15, your lordship.
That I have seen.
Your lordships.
It is not shown. It's all right. Okay. Yes.
It is submitted that after the said confrontation with the respondent, petitioner has been ill-treated by arrogance and sadist character of the respondent, but petitioner has tolerated all cruelty meted out by respondent for the sake of maintaining cordial family relationship with the fond hope that the respondent will correct himself, but by taking advantage of the same, respondent has tortured, harassed, and humiliated in all aspects since 2019. Then, my lord, then they come to the aspect of how rich the respondent is. The whole object of this is to extract money. Because the rest of it, my lord, is what a wealthy man he is. Now he is going to give me so much of money. Therefore,
alimony.
That's the prayer, my lord. Plus maintenance. Just 2 crores, no?
Compensation.
They ask for 2 crores maintenance.
2 crores monthly maintenance.
And then
500 crores compensation.
500 crores, my lord, compensation under section 22.
Will hear the respondent.
Yes. And there are a few authorities that I want to place.
Apart from what they...
My lord, my lord, I want to point out your lordships, my lord, on section 4. Kindly see, my lord, section 4 of the IPC as it then was. In where the law wanted to provide for extraterritorial operation, it specifically said so. Kindly see section 4.
You told me in the beginning.
Yeah, section 4, no?
Yes.
Of the IPC. Idu ಆಮೇಲೆ
argument ನೀವು first day ಮಾಡಿದಾಗ
ಮಾಡಿದೆ ಹೌದು ಇಲ್ಲ now my lord I'm substantiating with reference to the law.
Extension of the court.
Yes, to extraterritorial offences. Where the lawmakers intended that the law here should apply to acts which are committed outside the country, they specifically said so.
There's no IPC offense here.
Yes, such a provision is absent in DV Act, is what I'm pointing out. My lord, that is the contrast, my lord, that I want to point out, your lordships. In IPC, if I commit an offense outside, it's an offense under the IPC, a person can be tried here. But it is not so with respect to DV Act. Domestic violence committed outside does not attract the provisions of the DV Act within. That's the submission I'm making. Then, my lord, there are a few citations that I want to place for your lordship's consideration. Which are the ones we want to mention? Which one?
No, he has read a few.
Yes, my lord. My lord, please see, my lord. There is one judgment that I want to point out to your lordships, my lord, in 1963 Supreme Court, page 1. That is the famous Vishwanathan case, my lord. It is found, my lord, in which citation?
This you took me through, bird of passage.
No. Bird of passage, no, my lord. Vishwanathan's case is on how Section 13 of the CPC has to be construed and how it is to be done. Not for the purpose of birds of passage, I have already shown.
Orders passed by foreign courts.
Foreign courts. And your lordships will not look at the order passed by a foreign court with reference to the law in India.
Obviously, yes.
Your lordships will look at the enforceability of a foreign judgment with respect to the law in that country.
Yes.
That is what Lord Vishwanathan case lays down. It is a very famous case, Lord, right from...
and the concept is rudimentary. Concept is rudimentary.
But it has received the attention of
yes.
Such...
yes.
It's a judgment, my lord, which your lordship may just see these paragraphs, my lord.
19 and 20.
Yes, no, my lord. 2021.
All right.
If I may just read that, my lord.
Yes, sir.
Undoubtedly, in fact, this is a case where, my lord, Mysore state was a foreign state compared to Bombay. In that context, the enforceability of a judgment of the Mysore court was called in question. Undoubtedly, my lord, para 19, my lord. Undoubtedly, a court of a foreign country has jurisdiction to deliver a judgment in rem, which may be enforced or recognized in an Indian court, provided the subject matter of the action is property, whether movable or immovable within the foreign country. It is also well settled that the court of a foreign country has no jurisdiction to deliver a judgment capable of enforcement or recognition in another country in any proceeding, the subject matter of which is titled to immovable property outside the country. But there is no general rule of private international law that the court can in no event exercise jurisdiction in relation to persons, matters, and property outside jurisdiction. Express enactment of provisions like Section 20 CPC and Order 11 of the Supreme Court rules in England negative such assumption. The courts of a country generally impose a threefold restriction upon the exercise of their jurisdiction. Jurisdiction in rem by a court over res outside the jurisdiction will not be exercised because it will not be recognized by other courts. The courts will not deal directly or indirectly with titled immovable property outside the jurisdiction of the state from which it derives its authority. And 3, court will not assist in the enforcement within its jurisdiction of foreign penal or revenue laws. The suit filed by the plaintiff was possession of estates disposed of by the will of Ramalingam in para 3 of the plaintiff in Bangalore District Court suit. That's on the facts. I'm not going to...
That's on the facts.
I'm not going to...
That's why I said 1920.
Yes, kindly now see para 24. In an action in personam, the court has jurisdiction to make an order for delivery of movables where the party is submitted to jurisdiction. This is important. A person who institutes a suit in a foreign court and claims a decree in personam cannot, after the judgment is pronounced against him, say that the court had no jurisdiction which he invoked and which the court exercised, for it is well recognized that the party who is present within or who has submitted it to jurisdiction cannot afterwards question it. This is the point. Well, this is the case where both of them have gone and done it. And the order of divorce granted, my lord, records that it is a joint application. So, my lord, having regard to the law laid down in para 24 of this judgment, they cannot question it, having submitted themselves.
We'll hear the counsel.
Very well, my lord. If there's anything in reply, I'll point.
Anything.
Very
because both of you have extensively heard when the matter was taken up on the first time.
The first occasion.
And after my learned friend, if my learned friend is going to rely upon any of the subsequent pleadings, which has been filed in this case, post the petition that was filed before the DV court, I will point out, my lord, how they have purged themselves.
Might I
Yes, madam.
request your lordship, the Domestic Violence Act.
Huh.
Lordship, Section 3. Go to 3.3. Verbal and emotional, sorry. 3.3, verbal and emotional abuse includes insults, ridicule, humiliation, name calling, insults, ridicule, especially with regard to not having child, male child, whatever. Next, repeated threats cause physical harm. Next is economic abuse, which is also something we've raised. Deprivation of all or any economic or financial resources to which the aggrieved person is entitled to under law. The other one is last C, prohibition or restriction to continued access to resources or facilities which the aggrieved person is entitled to use, enjoy by virtue of domestic relationship, including shared household. Now they try to say that she's staying in a hotel, and probably birds of, I'd rather say paradise. So instead of passage.
Yes.
Lordship, if she's not allowed into her home, and they might find it amusing that we are trying to say that she's under constant threat, but a person who is worth 20,000 crores, as I mentioned to your lordships, that even the zeros that we cannot count, they're extremely powerful in Dubai. Even after her giving her initial complaint, and which proof of which by way of a WhatsApp message, of a message that she received on her phone, which is produced before your lordship, she was told very clearly after that, since there are several cases pending in Bangalore in India, why don't you address it there? After that, they will unwilling to take it up. Your lordship, in fact, I have noticed that even the metro stations there are named after top Indian builders. They have sufficient and tremendous power over there. With respect to her in her, the Dubai consulate, there are several occasions when they have gone to the Dubai consulate with respect to issues on passport, several issues, they have gone there. She has also gone there. Now she's unaware of this. Now what they're trying to take is bring out a certain message between the two there where she says, yes, I might not be your wife. Reason being he has told her that there's a provision and I have used that and I've gone and got myself a divorce is what he says. So I'm led to believe that there is one. But later, which I have taken your lordship through those messages, it says, give me a divorce, come to India and sign it, and then I will give you the Dubai house. That is when she realizes that that was a fabricated document or a lie or whatever she was led to believe. And now he's pushing her to give her the divorce in Dubai. The dates are critical here. What they're trying to say is that my DV is an afterthought. In fact, it's quite the contrary. I've sent 2 legal notices before any of this transpired. One in November 2023, asking him to refrain from all his threats and asking him to even provide some kind of assistance in monetarily. Second, the moment that notice came, he doesn't reply. Instead, he calls and says, both your daughter and you will find yourself dead. Better agree to what I have stated. Second notice then comes in. After the second notice comes, now the MC petition, your lordship, is served upon me on 23/20/24. That is in the record in the family court. On 20th, I'm served. The DV that I filed was on 7/3. So I have filed the DV.
After the filing of the DV petition, this is filed.
No, this was filed probably earlier, but I have received notice of it on 20th, whereas my DV was filed on 7th. But my legal notices were in the previous year in November, during which time they proceeded to file the MC petition, your lordship. So it's quite the contrary. Your lordship, might I also request your lordship to kindly see page 63 of the writ petition, your lordship.
Yes.
This is what they've referred to, stating, after the wedding in Russia in 2011, they straight away came here and registered under the Special Marriage Act. Kindly see the photograph. That itself reveals that there was a Hindu marriage.
Oh, and because he's wearing that. Okay.
And if it is a reception, they don't, Your Lordship. There's a difference in North Indian weddings. During the Bharat and the wedding is when they wear the peta and where the lady wears her head gear. That is not there during a reception. So as Your Lordship normally says, self-goal in certain matters, this is one of them. So there was a wedding. Subsequent to it, this was registered, and a wedding in Embassy School. Practically who's who of Bangalore were there. A very grand one to say.
2011.
2014.
What is 11?
11 is in Russia, it was registered. Your Lordship, from 2008, both of them have been
So
together.
2014, you get married here according to
In India. And it is under
Where,
the
where is
special.
the certificate of registration of that marriage?
That marriage, they have produced, Your Lordship.
2014.
2014.
Ah,
No, there's no.
that is what I'm asking. No. The senior counsel said 2014 you get married here. You don't register that marriage here.
After the Indian wedding, this is the marriage registration.
Indian wedding happens when?
A few days before this, Your Lordship. This is 16th. This is registered on 24th of
Oh,
May
this is
2014.
2014 itself. Correct,
Please.
you're right.
And they have a marriage about 16th.
All right.
16th of May.
The certificate
April-
is 2014 only.
Please,
Yes.
please.
This is of a marriage already solemnized.
No, that's all right.
And therefore, to state that that was the only wedding is untrue. This is the wedding that has taken place. Your Lordship, may I also kindly see page 72.
Yes.
Your Lordship, before that, page 63. Kindly see the witnesses. The hue and cry created last time, that I will come to.
Why witnesses what?
Necessary.
It is not unnecessary because this would be the entire crux of the matter, because we have to show that this mutual consent that they claim that was filed in India was not, Your Lordship. Kindly go to page 72.
No, why did you say about the witnesses?
Your Lordship, that would have a bearing on who filed this mutual consent case, even without her presence, Your Lordship.
But if that is being
Page
tested, I think
70.
it's a serious issue, my lord.
Page
Because
7.
if my learned friend is relying upon those paragraphs that I showed to your lordships about allegations made against counsel,
They
then
started
my
it.
lord, it's a serious issue.
They started it. I
I
want to
will
respond.
be
If they
clear
don't
about
want
that
to
one,
go
Lord.
into it,
I
I will also stop.
Yes.
I will not go further if they don't want to push it further.
No,
But if
where have they gone against the council?
No, they have not. All that they stated in their paragraphs is that entire MC petition was concocted. It was filed when she was not there and later conveniently withdrawn. And Your Lordship, I'll take Your Lordship to page 72. Your Lordship may kindly see. This is the MC petition in 2020. 17/6/2020, Your Lordship.
Yes.
Now, if Your Lordship turns to the next page, the verifying affidavit. 3/3/2020. 3/3/2020, she files her verifying affidavit, notarized before a notary, but it is filed on 17/6/2020, 3 months later. Reason being, 3/3 is the date given and this whole thing is registered and notarized in view of the fact that they calculate when she was in the country and therefore this date is put. But when it was filed, it was actually 17/6.
3/3?
3/3 and 17/6. 3 months later, normally a verifying affidavit.
From 24/3, for 3 months, courts were closed. COVID.
True, that is what I'm coming to. So 2020, now they say, in view of the COVID period, we could not proceed with it. And
They've said so, is it?
Your Lordship may go to their petition. Well, I will.
All right, yes.
So what they claim now is that we filed an MC petition, but it was upon her insistance. He claims that it's respondent who insisted, let's go to the embassy in Dubai and let us register it there. And then they say there was an application filed here in this MC petition, mutual consent, asking to be advanced. Then they say they did not pursue it in view of COVID. And then they say later on, it was dismissed for non-prosecution 2 years later. Now, if they say that it was upon her insistence that the embassy was filed, she would have come and completed this.
So the crux of his submission is the divorce has not happened in accordance with law.
Absolutely.
So
And your
the DV petition is maintainable.
DV is maintainable. Now, for a minute, let's assume that they say that there was some such the marriage which I have to dispute. Whether the courts have clearly held that whether there's a subsisting marriage or even after a divorce, if a lady is still troubled by her husband, she is still entitled to. So as a worst case scenario also, I would still be entitled to maintain the domestic violence petition. Here is a matter where now they have read only paragraphs where it says that there was torture only in Dubai, nothing in India. She very clearly states that she caught him red-handed. This whole issue is only because of his infidelity, nothing else. And your lordship, if they seem to portray this lady in one of those typical stereotypes of a Russian woman, stating that she is after his money. No, she has filed a restitution. If there is a restitution, where is the question of any of this amount, your lordship? If he consents to that, I have not asked for any of that. We have filed the restitution. Now they claim that the restitution also was an afterthought. No, she filed her domestic violence. She's just asked him to refrain. But going by all the documents, it just seems to be a very toxic marriage, which is on and off. They seem to have a very good time. They seem to have a very bad face. In my sir, your lordship may kindly take.
Sir, rebuttal.
Please, your lordship.
Sir, rebuttal.
Please.
Uh,
Go to the
Photograph.
judgments later, your lordship. This is,
judgments idea.
I have extracted portions of it in the sir, but I will hand it over separately, your lordship. Your lordship, contrary to their claims that I never came to India later, and their stated, each of those paragraphs have been addressed with proof. Page 37 onwards are all the seals and stamps every time she entered India. Your lordship, next is at page 44 onwards, your lordship.
Photographs.
Your lordship, this is on his birthday on 18/2/2023. 18/2/2023. The next one is, this is when they arrived back from Maldives, your lordship. Earlier in our memo of documents, I had showed that this is after her return. Now they claim that the flight details that I've produced is incorrect. She did not land in Bangalore. She landed in Delhi. And this, your lordship, is arrival in Bangalore from Delhi on 25th June. And these are the photographs where their friend had a baby. And both of them have gone there to congratulate them at page 45. Both of them are husband and wife with a small baby there.
All right.
Next is page 46. 28 June 2023. Attended a family gathering. This is with the family, your lordship, all of them together at Ganganagar on 28th June, your lordship, 2023. Have you written this? You're not written?
Yes.
If your lordship permits later, I will just ask him to write down the dates to the side, your lordship, just to
No,
assist.
you just give a synopsis of
Please,
dates and events.
I shall do that. Below that at page 46 is on 10/12/2022. This was again in Four Seasons, Bangalore. Next one at 47 is Maldives at June 2023 together. From this, after this is when they arrived in Delhi. The next one, your lordship, is 10th of February 2023, your lordship, last year. This is 48. 49, your lordship, may kindly see.
I'm at 49.
This is at Dubai, they have a holiday. Now trying to say that she separated, she went and she lived separately in Dubai and claiming desertion. Your lordship, page 51.
WhatsApp messages.
This is what now they have selectively given.
The whole thing you have produced.
We have produced this.
Yes.
And your lordship may kindly see. Beating me, asking me for a divorce at page 53. And when we're going to consulate, I knew it's not their responsibility. That's why I went. You paid the guys to get it done. She states it very clearly. And she knows later on, by way of the memo of documents that I've produced, which are subsequent to this, where he tells her, give me a divorce. Now, Your Lordship, the memo of documents to show the domestic violence, Your Lordship, that should be sufficient to establish prima facie. As we say, Your Lordship, they have taken us extensively towards whether there was a marriage, whether there was no marriage. And with respect to the child, I shall just clarify, in 2011, when they were dating from 2008 to 2011, he says, she is my daughter. And so he voluntarily goes there and puts his name in her birth certificate stating that she is my daughter. And now to say that that just goes into the root of what a person could be, irrespective of their strained relationships between a man and a woman, if he has taken her as his daughter from then, now to say the daughter of some man, that just goes to show what kind of a person. Your Lordship, might kindly see the memo of documents, Your Lordship.
No, we should be on
Just on the technicality.
entertainability of the
Absolutely.
DV Act before
Please,
the concerned court.
please. Page 32 of the list of documents, Your Lordship.
30?
Page 32.
The WhatsApp message. WhatsApp messages.
Please, Your Lordship. Hope you're okay to take the house and change your mind and Natalie passport and sign the divorce papers in India. This is what he has asked her.
All right.
Page 28. This is the most repulsive act of a person to state.
Page 28.
28. You might celebrate your birthday in Bangalore. I'm going to drag this till you become old, and Natalie, that's the daughter, will never have money to enjoy her youth unless she finds a rich man like you did. For that, you know what she has to do.
That's all right.
And then she berates him, stating, how could
that's
you call the daughter now?
Entertainability, but
Maintainability, Your Lordship. At continuously what she tells him is, you have left me with no money. Your Lordship may
no,
kindly
the
go to...
contention is both of you are separated in terms of the Russian law. The contention.
Contention.
Contention is that you separated in terms of Russian law. The marriage also had taken place in terms of Russian law, and later on they registered here or whatever it is. And all the incidents that are now being narrated have all happened in Dubai, is what is said.
I shall
No,
produce where,
that
please.
is all said.
Please.
Now that is why we'll just concentrate on the entertainability of the petition before the DB court. Not going what is he, how
Page
is he, how
42.
much money he has.
Page 42.
That's all.
You did raise your hands in me, and if you don't remember, you put a gun on my head. Now I've read the provisions.
Where did this happen?
Your Lordship,
Dubai?
One of it, the raise hands is here, and Dubai putting a gun on her head is Dubai.
Okay.
Your Lordship, all of this is sufficient to, one, show mental cruelty, physical cruelty. Thirdly, economically draining her out, completely stating you will not have a penny. Your Lordship, at page 5 of that very document, Embassy Group's hospitality businesses received a boost with Jitu Virwani's children, Natalie, which I've shown.
Told me.
Yes. So therefore, she took over the reins of the business. Certain businesses were handled by her. The respondent herein, that is the wife, has signed several documents where she is one of the, any of the board members, the directors, whatever. He threatens that in Dubai, he's going to have one of those cases wherein there is some kind of a fraud in the company. So she very cleverly says, which means you'll have to bring your sister down too, because the sister is also part of it. And that's where he's trapped. He's not able to do it. Your Lordship, as I had also mentioned, that's of course a matter of another trial wherein a fake, false case was filed as against her with respect to drug peddling or whatever. The moment this petition, after it came before Your Lordship, that Your Lordship had stated that she will cooperate with the investigation, that matter. This,
Oh, yeah, oh, you told me this, yes.
please.
Mm.
And this was all done the moment
That's the
this,
contention.
that is my, just the way they have several other contentions. This is my contention. The only difference is there's factually correct over here. Your Lordship, might I?
Confidence. Yes.
Your Lordship, the rejoinder and the response, Your Lordship, also with respect to the Dubai divorce, all of that, Your Lordship, I might mark the pages and give so that I don't take your Lordship further in this.
No, no more further.
No further, Your Lordship. I'm closing. I'm
yes.
closing it. Your Lordship, with respect to the Sir, Your Lordship, I'll just take out only those judgments. I will only hand it over. I'll just read
Yes.
those. Sir, really?
And I will go through everything and then pass orders.
Pass it.
No rebuttal. It's 5 o'clock. Already spent 90 minutes on this. And see the council's waiting still.
ವೇಲುಸ್ವಾಮಿ ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದು ನೋಡ್ಬಿಡಿ ಅಷ್ಟೇ.
ಯಾವ ವೇಲುಸ್ವಾಮಿ? ಆಯ್ತು, ಆಮೇಲೆ ಮೇಡಮ್ ಮುಗಿಸ್ಲಿ.
I've noticed, Your Lordship, in every matter, I'll get less than 1/10 of the time. And yet I will not grumble.
Okay, you want me to take it tomorrow? I'll
No,
take it.
no, not
Yes.
at all. I'll wrap
No
it up, Your
problem.
Lordship. Your Lordship, at page
No,
9.
we'll take it tomorrow, madam. You continue tomorrow.
Either I'll wrap it up, Your Lordship. I'll just read
No,
out
no,
those
you can
judgments.
wrap it up tomorrow. After the wrapping up of the other case happens, you can wrap it up.
Oh, oh yes.
Don't go back saying that
No,
you
no,
get
no.
only 1/10 of the time.
No, I'm trying to say because despite that, again, they would want to point something out. I'm not complaining. I'll just read these out and I'll hand it over, Your Lordship.
I
I
think
shall
10 minutes.
with no complaints.
10 minutes is enough for you
Your Lordship, absolutely. Your Lordship, page 9.
to destroy the lull period. Yes.
Or run a 100-meter sprint.
Right. Yes.
Jackie Joyner Kersey.
Yes.
Your Lordship, page 9.
ನಾವೆಲ್ಲ ಟೆಸ್ಟ್ ಮ್ಯಾಚ್ ಅವರು T20.
That's because they have a Rahul Dravid there.
Wall.
The wall. Your Lordship, Sumit versus Himani Sumit.
Page 51.
Mr. Raghavan would be Gavaskar. Sumit versus Himani, Your Lordship. The domestic violence took place in Germany. I've just extracted those portions just to state that even if they say most of it took place in Dubai, this is just to bring the word. The wife filed a complaint here in Nagpur. And what the court says is she carried the trauma. That is the key words over here. So this is that judgment. According to her, mental stress and
But
trauma
there the
carried.
relationship was still subsisting.
It still subsisted. I have shown with photographs that
No, no,
it still subsisted.
In this case.
In this case, which I'm also saying in our case, it still subsists.
All right.
It seems to be a very toxic relationship. Beyond that, I don't think there's more.
No,
If-
that is why domestic violence emerges.
That is why emergence. But if all of those toxic, all of those what he messages is all withdrawn, I think it's more a question of the male ego. Once somebody with 20,000 crores, you follow what I say. Otherwise, you will face the consequences. That's all it is, Your Lordship. It's nothing more than
All
that.
right.
Your
No,
Lordship, paragraph.
We are on
14.
entertainability.
Your Lordship, page 14. Para 14.
Is that you're on entertainability, not entertainment?
That Mr. Raghavan's provided enough. Page 14, paragraph 14. In my view, by drawing the analogy from these observations, it has to be held that apart from the express provision of 27, consequence of trauma, suffering, and distress carried by the complainant to her paternal home would be sufficient to reject the submissions advanced. Next is Mohammed Zubair Faruqi, Your Lordship. This is with respect to shift to India to file the DV. That is from US, shifted to India, she filed the DV, that
Yes.
entire matter.
Yes.
I will not read the rest, Your Lordship. In page 11, a continuation of that with respect to Krishna Bhattacharya. This is 2 years later after she came down, she filed it and it was still maintainable. Next one is, Your Lordship, further down, that is Rajasthan High Court's Robato. In that, Your Lordship, a foreign citizen can file a DV. Just in case they try to say, though she has an Aadhaar, passport, all of that, they're now trying to bring in that's also covered, Your Lordship. I shall file a detailed synopsis of all
Do
of that and please,
You can file written submissions also if you want.
please.
You watched.
ಅದು ವೇಲುಸ್ವಾಮಿ ಒಂದು ತೋರಿಸ್ಬಿಡಿ.
Vel Sami, which is that?
ಇಲ್ಲ
ಕೊಡಿ.
Sir, court of, sir.
ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
No, no.
ಅಲ್ಲಲ್ಲ, ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಪಿ?
Court
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
Which one?
Citation, 3, yeah. First. No, it's in page number 1. 2010, 10 SCC 469. Idralli, if your lordship will kindly see, my lord, this, kindly see, my lord, para 31. In our opinion, a relationship in the nature of marriage is akin to a common law marriage. Common law marriages require that although not being formally married, a couple must hold themselves out, because all this was said, my lord, after divorce, they went to so many places, etc., etc.
Yes.
The couple must hold themselves out to society as being akin to spouses. In fact, on the contrary, the petitioner is saying we are divorced, we are not husband and wife. This is how he has been holding out to everybody. That's her complaint. And then, my lord, they must be legal age to marry. They must be otherwise qualified to enter into a legal marriage, including being unmarried. They must have voluntarily cohabited and held themselves out to the world as being akin to spouses for a significant period of time. That is, after the divorce, after the legal relationship came to an end, they must do this if they want to contend that it is a relationship in the nature of marriage. It should be a common law marriage. And what is a common law marriage has been discussed. And here, my lord, the allegation is contrary. You have been going around everywhere saying that we are not husband and wife. What kind of a husband are you? And that has caused me a lot of trauma. Is the allegation of the petitioner.
Drama?
Yes, drama, not trauma.
Trauma.
According to us, all that we do is drama.
Yes.
And then, my lord, last one sentence, in our opinion, a relationship in the nature of marriage under 2005 Act must also fulfill the above requirements, and in addition, the parties must have lived together in a shared household as defined in Section 2S of the Act. Mere spending weekends together or one night stand would not make it a domestic relationship.
Yes.
This, my lord, I think conclusively. And if there's anything more, my lord, can we have permission to file written submissions and then give?
All permission grant.
Your lordships are in. Thank great.
ಏನು ಹೇಳಿದ್ರಲ್ಲ ಆ ಕೇಸ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಾದ್ರೆ ದಿ ಓನ್ಲಿ ಥಿಂಗ್ ವಿ ವೋಂಟ್ ಕಮ್ ಟು ನೋ ಇಸ್ ವಾಟ್ ಯು ವಿಲ್ ರೈಟ್ ಅಷ್ಟೇ. ಸೊ ಏನ್ ಬೇಕಾದ್ರೆ
ಹಾಗೆಲ್ಲ ಹೇಳಿದಾಗ ಎಸ್
ಏನ್ ಬೇಕಾದ್ರೆ ಕೊಡಿ,
ಏನ್ ಬೇಕಾದ್ರೂ ಕೊಡಿ. ಕರೆಕ್ಟ್. ಎಸ್ ಲಾರ್ಡ್.
ಎಸ್
ಗ್ರೇಟ್ಫುಲ್. ಗ್ರೇಟ್.
ಎಸ್ ಮೇಡಮ್ 1/10 to or half.
I'll make it up with written submissions.
Yes.
Obliged.
10 minutes ಸಾಕು.
Yes. But there is other matter, my lord, where the state was supposed to.
Sir.
In the other matter, my lord, the state is supposed to have given your lordship's inquiry.
Which other
report.
matter?
Past over matter.
See number 23. ಇಲ್ಲ ಇದಲ್ಲ ಇದಲ್ಲ ಇದಲ್ಲ.
All of you please don't get up. I am not getting up. Be
Yeah.
patient till I get up. Yes.
Interim order question.
At will. Yes.
Serial number 23 matter. CPR counsel.
No, the 230 mode matter ಇರಬೇಕು.
Oh, I see. We'll wait. We'll wait.
Yes. ಏನು ಮೂಡ್ ಮ್ಯಾಟ್ರ? ಸತ್ಯನಾರಾಯಣ್, ಓಯ್ ನಿಮ್ದೆ ಸೆಟಲ್ಮೆಂಟಾ? ಎಲ್ಲಿದೆ?
ಸೆಟ್ಲ್ ಆಗಿದೆ, ಬಂದಿದ್ದಾರೆ ಪಾರ್ಟೀಸ್.
ಬಂದಿಲ್ವಾ?
ಬಂದಿದ್ದಾರೆ.
ಆಲ್ ರೈಟ್.
ವೇಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್
ಕೊಡಿ.
ಸೈನ್ ಆಗಿರೋದು ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ. ಅಗ್ರಿಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ. ಪಾರ್ಟೀಸ್ ಆರ್ ಬಿಫೋರ್.
ಮೀಡಿಯೇಷನ್ ಆಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ.
498 ಏನಾ? ವಾಟ್ಸ್ ದಿ ಒಫೆನ್ಸ್?
ಮೈ ಲಾರ್ಡ್,
ಒಫೆನ್ಸ್ ಏನು?
498A. My learned friend is appearing for the girl.
ಸೆಟಲ್ಡ್ ಅಲ್ಲ?
ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಆಯ್ತು. Parties were before the mediation in MC 2042 of 23. Yes, you
Please.
can go.
Parties are before the court.
Sign madogu.
Obliged.
Next.
Till number 2, Kiran Krishna Swami.
Office objections. Niva.
12073.
No, 13578. Krishna Swami. 5 o'clock ಆಗೋಗಿದೆ. ಇದೆಯಾ copy? This we will not permit. Road rage and troubling the drivers. Glass ಹೊಡೆದು ಸ್ಕೂಟರ್ ಮುಂದೆ ನಿಲ್ಲಿಸಿ ಗಲಾಟೆ ಮಾಡಿ. Anyway, he is not there. List the matter on Tuesday in the fresh matters list. Yes, next.
Number 3, M. Sharashchandra, withdrawal.
In terms of. Yes, Lena Abraham. Lena Abraham is here. Yes, madam.
My lord, there are two matters. One is a domestic violence case which is pending with the Metropolitan Magistrate Court.
What have you challenged in this now?
The thing is that I'm filing also a memo.
Dispose the matter. You want disposal of the matter?
No, I am the petitioner in this matter. I'm filing a memo also.
Memo for what, madam?
Memo in Kerala court, he came for a settlement and there were terms written that he will withdraw so and so cases in Bangalore and he will file for a joint divorce petition in Kerala. But against that settlement and the judgment order passed on the petition, which was actually filed by me for the divorce.
Now, what do you want?
Now he is running two cases in Bangalore. One is divorce petition MC 209.
All right. What have you challenged here?
I am seeking for a speedy disposal. My prayer is
Speedy disposal.
yes,
That's all?
and also stay in two petitions filed by him. One is
Want speedy disposal or stay?
both.
You can't ask.
Okay, then I'll go with the stay, my lord.
We'll go with the stay.
Yes,
Have you appeared before the committee?
yes, my lord.
All right. Where have you sought this stay?
I have filed, my lord. Actually, I have filed 6 IAs. They have, then I have not pressed all the remaining 5 IAs. Only 1 IA is pending now. Stay for MC 209 and OS 2892 but 2022.
MC, I can't stay here.
Okay.
OS also, I can't stay here. Domestic, which is domestic violence case? That is filed by you.
Yes, sir. Domestic.
How can you ask stay of your own case?
No. Domestic violence case, I am not asking for
An
stay.
MC and OS, I can't stay here. You should go to the GM court. GMFC.
Okay.
Hmm?
Okay.
This petition should not be presented here. I think you should go to the other court.
My lord, then can I only ask then the direction in the domestic violence matters? Because in Kerala court, I have fought 2
Domestic
years.
violence matter, if you want speedy disposal, I will direct.
Okay.
Not a problem. But if you want OS and the MC petition to be disposed, this court does not have jurisdiction.
Okay.
That is why maintainability is the office objection.
There are 2 cases, only 1 case.
Now, madam, your
Okay.
prayer is within 3 months to dispose PCR 5234
Yes.
in FIR 238 of 24.
Yes.
That investigation is not yet complete. You are the complainant.
Yes.
How are you asking disposal of that? Should they not investigate against your husband?
Yes, my lord, but they are taking a long time. And there
No,
were,
it is registered in 2024.
yes, after the disposal of the Kerala court case.
No, madam. The best thing you do is go before the other court, seek
Okay.
expeditious disposal of all your cases. That
Okay.
court will grant.
Okay, my lord.
Here I don't have, this I will grant, but this is your own case.
Yes, I need
Same
speedy
state.
disposal in that because there are 5 IAs are pending, my lord, in that.
That's all right. Now, I will take this day after tomorrow. Let him see what investigation has happened in this case. Then we will direct disposal. You are coming from Kerala or you are here?
I am staying here, but in OS 2892 case, they are trying to get an injection,
No,
I have
that
a
before
minor
the,
child also.
that before the other court, not before this court.
Okay.
This
And,
only, you take note, you serve a copy or you take a copy. Additional SPP is directed to accept notice. List day after tomorrow in the fresh matters list. Nodi investigation, yav stage alide, get the papers. You just show him the papers, madam.
Okay,
Yes.
my lord, the second case, CMS 99/2024, in this kindly direct the court for the speedy disposal, my lord. In the same prayer only.
Miss yavdu, madam? That is domestic violence.
Domestic violence case. Because I have filed 5 IA in that, interim maintenance I have asked, interim protection
Then
order I have.
no order is passed.
No orders have been passed, my lord.
The petitioner appears in person, seeks the following prayer. The petitioner in person would restrict her prayer for a direction to the concerned court to dispose the applications for maintenance, shared household and other applications so filed under the provisions of the Domestic Violence Act. The submission is that the concerned court has not considered the applications despite the complaint filed under Section 12 of the Domestic Violence Act in the year 2023. The prayer is innocuous. The need for maintenance is what is projected by the petitioner. Therefore, the concerned court shall answer all the applications that are filed along with the complaint under Section 12 of the Domestic Violence Act expeditiously at any rate within 4 weeks, 4 weeks from the date of receipt of the copy of this order, if not earlier. Yes.
My lord, one more matter I have
One
filed.
more?
Yes, sir. Criminal petition 9091 of 2024.
It's not listed, madam.
It is listed.
There are 2 petitions listed of yours. One is 8560.
Yes.
That I have asked day after tomorrow.
Okay.
Government party ಮಾಡಿಲ್ವಾ? ಆದ್ರೂ ಅದು ನೋಡಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನಾಗಿದೆ. ಎಸ್, ಅವ್ರ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಗೊತ್ತಾಗಿರಲ್ಲ. 5 is 9091.
90.
That I have disposed. I have directed the court to consider your applications within 4 weeks.
Okay. The domestic violence case, my
Yes,
lord.
domestic violence
Okay,
case.
this is the criminal miscellaneous petition pending in family court for under section 125 of CRPC for interim
125.
maintenance.
All right, that you will concern court, I have said, same order.
Same order I can produce before the concerned court.
Produce it.
Because 1 year this is pending.
Produce it, madam. No problem.
Okay.
ಅದು ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಎಲ್ಲ ತೆಗೆದ್ಬಿಟ್ಟು 125 ಅಂತ ಹಾಕ್ಬಿಡಿ. ಎಸ್.
ಅಲ್ಲ, ಎರಡಿನಲ್ಲಿನೂ ಬೇಕು, my lord. For because 2 courts I am running my.
One domestic, your prayer is with regard to domestic violence court or what?
Yeah, under
criminal
criminal
miscellaneous.
petition 8560.
It is criminal miscellaneous, madam.
Okay.
So I have directed under 125 to conclude the proceedings.
In 9091 kindly pass order, my lord. I
I
mean,
have already passed order, madam.
for the speedy disposal also and interim maintenance, I have filed an IA in this.
I have said to consider all the applications.
And 2 courts I can show the same petition.
No, you can't. One order you can't show in 2 courts.
Okay.
Only in 9091, which is that is before 125 proceeding, you can show that. All right.
My lord, humbly, my apologies, kindly consider to show in a domestic violence case also. One more order, my lord.
That prayer is not there.
Yes, my lord.
That is not there. I can't go beyond the prayer.
Yes, 2 petitions I have filed in 2 different prayers are there, my lord. In 9091, there is a
We'll
different
see.
prayer.
Well, if that is not there, I will post it again on Friday. We'll see. All right. Yes. Now all councils are held up.
Number 6.
Friday. Yes.
Lord, I have preferred a 311 application before the trial court, my lord, and that has
ಏನ್
been
311 urgency?
311, my lord. He may be posting it for the orders, my lord, final orders. Arguments is, it is listed.
Petitioner to serve on the counsel who
Served, my
represents.
lord, already.
ಯಾರಿಗೆ?
Served, my lord.
ಎಲ್ಲಿದೆ?
Morning I have.
ಇಲ್ಲಿ ಕಾಪಿ ಕೊಡ್ಬೇಕು ಅಂತ ಗೊತ್ತಲ್ಲ.
Yeah, it's served, my lord.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಏನು?
17th is there, my lord.
Yes, look into it.
Ma-
List on learned additional SPP is directed to accept notice for the respondent.
my lord.
List on 17th in the fresh matters list. The concerned court shall defer its proceedings till further orders at the hands of this court.
Much lord.
Next,
7.
office objections comply ಮಾಡಿ. To be complied ಮಾಡಿ. 7 withdrawal, 8 withdrawal, 9 ಇದು cover, Ajay Govindraj. Covered, yes. Next,
Further hearing for settlement. Bill number 10.
Rudrappa, settlement
Both are present for the
Huh?
settlement.
Petitioner is present.
offense,
Point number 2.
Offense for
376.
376,
417, 420.
promise of marriage.
Promise of.
Come on merits, I will not settle 376. Merits ಮೇಲೆ argue ಮಾಡಿ, ಈಗಲ್ಲ, ಈಗ ಶುರು ಮಾಡಬೇಡಿ ಆಮೇಲೆ. We'll post it on Wednesday, fresh matters, we'll finish it.
Tomorrow.
Tomorrow, okay?
21st.
ಅವ್ರೇನ್ ಬೇಕಾಗಿಲ್ಲ ಸರ್.
21st ಡೇಟ್ ಇದೆ ಸ್ವಾಮಿ. ಡೇಟ್ ಇದೆ ನಾವು ಸೆಟಲ್ಮೆಂಟ್ ಗೆ ಅಂತ.
21st ಡೇಟ್ ಇದೆ. ನಾನು 21st ಡೇಟ್ ಇದೆಯಲ್ಲ ಬಿಡಿ.
ಅಫಿಡವಿಟ್
ಸೆಟಲ್ಮೆಂಟ್ ನಾನು ಮಾಡಲ್ಲ. 376 ಡೋಂಟ್ ಟಾಸ್ಕ್ ಫಾರ್ ಸೆಟಲ್ಮೆಂಟ್.
Second on.
ಏನು?
may kindly be taken on record.
No, sir, I will not settle the issue. 376, I will not settle. You come on merits, promise to marry, we will answer.
Not the allegation that my lord the relation my lord for from 2 years.
ಹೌದು sir, I will not settle the issue in a 376 case. Try to understand. Come on merits, we will answer.
Wait a minute.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
Agency ಇವರು issue.
ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದಾರ ಯಾರು?
ಕಸ್ಟಡಿಯಲ್ಲಿ ಇಲ್ಲ.
ಮತ್ತೆ?
ಕಡೆ ಇಲ್ಲ.
ಆಗಿಲ್ಲ, warrant
Bail ಆಗಿಲ್ಲ, ವಾರೆಂಟ್ ಆಗಿದೆ.
ವಾರೆಂಟ್ ಆಗಿದೆ.
ಯಾಕೆ ಹೋಗಿಲ್ಲ ಕೋರ್ಟಿಗೆ?
ಮೊದಲಿಂದನೂ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದರೆ ವಿತೌಟ್
List on, the matter was directed to be listed on 21st, listed on 21st. The petition, the counsel for the petitioner has moved the matter owing to a warrant hanging on his head. The issue relates to breach of promise of marriage and the offense, the subject offenses have sprung. Therefore, list the matter on 21st as directed earlier. Warrant of any kind hanging on the head of the petitioner shall remain stayed. Yes, next.
11.
Release from status of being part heard, post the matter before the bench having roster. Next. Interim order, if any, shall continue till the matter is listed before the appropriate roster, the bench having a. Next. ಮುಗಿತ ಅಷ್ಟೇನಾ? Yes. ಫಾಸ್ಟ್ ಯಾಕಾಗಿರೋದು?
Records.
ಯಾವ್ದು ರೆಕಾರ್ಡ್?
Records.
ಯಾವ್ದು?
Bill number 23, man.
ಪಾಸ್ವರ್ಡ್ ಕರೀ. 23.
Yes, sir.
Password 17.
17. ಎಲ್ಲಿ ಅವರು?
17.
ಅವ್ರು ಇರೋ ಟೈಮಲ್ಲೇ ಪಾಸ್ವರ್ಡ್ ಕೇಳ್ತಾರೆ, ಇವಾಗ ಇರ್ತಾರ? ಎಸ್, ಲಿಸ್ಟ್
Day after, my lords.
on Tuesday, on Wednesday in the fresh matters list as a last chance. ಮಾಡಿ.
speak for hand delivery.
ಇಲ್ಲ ಸರ್, ಯಾವತ್ತಿದೆ ನೆಕ್ಸ್ಟ್? ನಾಳೆ ಕೊಡ್ತೀನಿ, ನಾಳೆ ಕೊಡ್ತೀನಿ. ಎಸ್, ಇಷ್ಟೊತ್ತಲ್ಲಿ ಆರ್ಡರ್ ತಗೊಂಡಿದ್ದೆ ತಪ್ಪು ಆಗಲ್ಲ. ಓವರ್ ಆಗಿ ಕೇಳ್ತೀರಾ? ನೋ ಸರ್, ದೆನ್ ಏನು ಎಂಟ್ರಿ ಮಾಡಿ ಪ್ರಿಂಟ್ ಮಾಡಬೇಡಿ. ಲಿಸ್ಟ್ ಆನ್ 21st. ಲಿಮಿಟ್ ಇರ್ಬೇಕು ಎಲ್ಲದು. 5:15 ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಬಿಟ್ಟು ಎಂಟ್ರಿ ಮಾಡ್ರು ಅಲ್ಲ, ವಾರೆಂಟ್. ಏನೀಗ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರಾ? ಎಸ್.
23.
My lord, 17 interim order may be extended.
That will be extended.
That's okay.
Although list on 18th as a last chance, awaiting the submissions of the counsel for the respondent.
Much okay.
23 will take it again on.
Really, B report has been filed. Court has rejected the B report.
B report filed ಮಾಡಿದ್ದಾರೆ.
Rejected the B
No, but
report.
The complainant filed a protest memo. Now protest memo has been accepted and a direction has been given for further
Further
investigation.
investigation.
Permissible.
No, no, I'm not on that. There is nothing in the complaint against me.
On merits we will answer.
That's why, my lord, I want to stay.
ಅದ್-
There's no interim order, there's no protection so far as I'm concerned.
That's all right. ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದಾರಲ್ಲ ಅವರೇ ಏನ್ ಮಾಡಲ್ಲ.
ಈಗ 156 ತಿರ್ಗಾ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, that is 173(8).
ಮಾಡಿದ್ದಾರೆ ಈಗ ಅದು ಹೊಸ್ತು.
The
ತಿರ್ಗಾ
report
ಆರ್ಡರ್
is
ಮಾಡಿದ್ದಾರೆ.
filed on the ground that the
No, no.
complainant has not
ಅವ್ರು
cooperated.
ಕೋಆಪರೇಟ್ ಮಾಡಲ್ಲ, but this is hanging on me.
Who has not cooperated? Complainant has not cooperated. Then don't precipitate till I hear the matter. List the matter on heard the learned senior counsel ಅಂತ ಮಾಡಿ. Again, Wednesday in the fresh matters list. Till such time the respondent police in the garb of further investigation as directed shall not precipitate the matter or take any coercive steps. Yes. Next.
77.
70?
77, it's a fresh matter, my lord. 77, let me take it up on Tuesday, my lord. It's a DE matter.
DE matter? DA?
Yes, I have been exonerated in the departmental inquiry.
Oh, that kind of a case.
Yes.
All right. ಯಾವತ್ ಮೇಡಮ್ ಅದೆಲ್ಲ ಇರೋದು?
My lord, that matter I'm seeking stay for this reason. Challenging the charge sheet, my lord, I filed a revision petition. There was a stay all through. Withdrawing that, my lord,
There was a stay all through?
Yes, my lord, I'll produce the order sheet. There was a stay all through.
The
Withdrawing with, my
learned-
lord, I filed the present 482.
heard the learned, ಆ ಕಡೆ ಯಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ ಜಾಗ ಇರಲಿಲ್ಲ ಅಂತ.
Heard the learned counsel Shivaprasad Shantangod appearing for the petitioner. The petitioner had preferred a criminal revision petition in criminal revision petition 559 of 2020 against the order passed by the concerned court. The coordinate bench had granted an interim order of stay on 11/9/2020. Subsequent to the grant of the interim order, the petitioner has now been exonerated in a departmental inquiry. Therefore, the petitioner submits that the issue stands answered by the judgment of the apex court in the case of Ashu Surendranath Tiwari, so and so, reported in 2020 10 SEC page 2027 SEC, alla? Yes, so and so 736 636 2020 9 SEC page 636. Therefore, there shall be an interim order of stay in the light of the aforesaid reason that there was an interim order in the criminal revision petition till the next date of hearing. Next. Next. 78.
Petitioner, your lordship. Yeah.
ಎಲ್ಲಿ ತಾಹಿರ್?
Went to trial court, your lordship.
Went to trial court?
It was up to 5 o'clock here.
ನೀವೇನ್ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಹೋಗಿದ್ದೀರಾ? Oh, I am a special bench. I thought you are not here. Which special bench? All right.
Tomorrow, lordship.
Next ಶುಕ್ರವಾರ ಅಂತ ಹೇಳಿ. Next ಶುಕ್ರವಾರ ಮುಗಿಸ್ಬಿಡಿ ಅದನ್ನ, whatever it is. 20th in the fresh matters list. Yes. Next. First over ಆಯ್ತಾ? ಅಲ್ಲ, list continue ಅಲ್ಲ. Serial number. All matters where interim orders are there, they will be extended. And they will be posted after 2 weeks. I don't know whether I'll continue or not. If I continue, we'll take it up as usual. And in serial number 110, 112, 131, 133, 137, there are no interim orders. One not?
My lord, 135, my lord.
No, if it has come before me and I have not granted interim order, then it will come in admission. Not reached ಅಷ್ಟೇ. ಅದನ್ನ ಮೇಡಮ್ ಅದನ್ನ ಮೇಡಮ್ ಒಂದು ನಿಮಿಷ ಮೇಡಮ್ ಇದು ಇದಷ್ಟಲ್ದೇನೆ ಅವ್ರೇನು ಹೇಳ್ತಿದ್ರು ಅದನ್ನ ನನ್ನ ಮುಂದೆ ಬಂದಿದ್ರೆ ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟು post them all in fresh matters on Tuesday.
My lord, serial number 135.
Sorry, on Tuesday.
Item number 93, please, there is no interim order.
It will come on Tuesday. If it has come once before me and I have not granted interim order, it won't come on Tuesday.
My lord, serial number 135, my lord.
Amale, it will come in admission, we will consider.
My lord, serial number 135, my lord. My lord, your lordship.
VC ಇರ್ಬೇಕಾದ್ರೆ ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರಿ, ಆರಾಮಾಗಿ ಆಫೀಸಲ್ಲಿ ಇದ್ದೀರಾ, ಇಲ್ಲಿ ಎಲ್ಲರೂ ಕಾಯ್ತಾ ಇದ್ದಾರೆ.
My lord, apologies.
VC ಹೇಳಲೇಬೇಡಿ. All right, it will come, ಅದನ್ನ fresh matter ಹಾಕಿ.
My lord, second list, my lord.
The same matter, my lord, yesterday, the extension, the objection was.
I'll come, sir. Second list ಬರ್ತೀನಿ.
Serial number 153, I request for
Short what?
153, 4
Yeah.
PM matter.
Adel, wait, man. Huh? 14%. 122. It will be extended. You registry to print the, what's your name, sir? So and so. Registry to print the name of so and so in place of the party in person, interim order stands extended ಅಷ್ಟೇ. ಎಲ್ಲರೂ ಹೇಳ್ಬೇಡಿ, please. I have told you, wherever, ಇದಕ್ಕಿಂತ clarity ಇನ್ನೇನು?